Good morning. My name is Stephanie L. Willis, and you're here with the LawNewz Network. Thank you for joining us here today. And here we are. We'll be sending you to the Henry Segura matter. I'm sorry. I have two trials going on at the same time. So if you all were not paying attention last week we had on Friday we specifically had the medical examiner by the name of Lisa Flanagan who testified. She provided us a brief timeline of exactly what may have happened or what probably did happen the day of the shootings of Brandy Peters, Tanaya Peters, and Javante Segura. Here we have Henry Segura, who is being tried for 4 counts of first-degree murder, which the prosecutors in this case are seeking capital punishment. So if in the event that he is convicted of these 4 first-degree murders, there is a chance in the second portion of the phase of the trial that the jury may find that it is necessary for him to unfortunately have the death penalty. So we have live feed in the trial right now. We're going to take you there right now so that you can take a look.
Locking counts, I've attempted to draft an instruction similar to the standard, but it's a little bit of a twist on the standard. But it would include first-degree murder. Or second-degree murder. So y'all need to look at that. Frankly, I can't find any cases where homicide was the underlying felony for felony murder. I haven't looked extensively, but I looked a fair amount. I can't find any case where that's been done. There are a number of cases that, there was some confusion at one point in time that the underlying felony was a lesser included offense, and double jeopardy prevented convictions as to both, but I think the Supreme Court pretty clearly sorted that out, and so that's not an issue. But it is something we need to look at because it's a little bit novel in terms of legal issues. That's the only other issue I see in there that has much significance. So probably, if y'all would tonight, let's look at that so we can have some discussion about that early on, so we can know where we stand on that. Anything else from either side?
No, not this time.
I think we were short a couple of jurors. Having a problem with parking this morning. I guess we have the grand jury here, we have regular jury selection, and we have our jurors, so that they weren't here early enough, they didn't get a parking spot, so we're waiting for a couple. As soon as we have all the jurors, we'll start. All right.
And thank you for joining the LawNewz Network. My name is Stephanie Willis, and we're here covering the Henry Segura trial. What you just saw, if you were able to see, the judge did take the bench. It seems as if they were handling a few housekeeping matters, which at times occurs prior to starting the day of trial. They will go over anything that's outstanding, anything that could probably try to make the trial move a little bit more efficiently. So we also heard from the judge that apparently some of the jurors actually had a little trouble finding parking this morning, so we may be starting a little bit later than we anticipated. But so the court is in recess, I believe a short recess at this time, but I believe they'll be bringing everything back shortly. Now, to get back to what we were talking about, on Friday, the medical examiner by the name of Lisa Flanagan testified. She gave a brief, I guess, summary or timeline of exactly what may have happened around the time that Brandy Peters and her children were shot and murdered. She informed us that Peters she testified that Peters may have been shot 7 to 8 times, but it was likely that the gunshot wounds did not kill her immediately. So it means that Brandy actually suffered some before she actually passed away. Brandy Peters, the official cause of death was blunt traumatic injuries to the head, along with the face, and multiple gunshot wounds. Unfortunately, little Tamaya Peters, which was one of the twins, passed away via a gunshot wound to the back of the head, and the other two children by the name of Tanaya Peters and Javante Segura were actually, they died via drowning. We also had the latent prints examiners who actually testified. But before we get to that, I'm going to throw to a clip just so that you can become a little bit more familiar with what Dr. Flanagan testified to on Friday.
Lisa Flanagan. That's Flanagan.
Have you provided her with photos you're proposed to use, Ms. Dugan?
Yes, sir. I don't know which specific ones.
We'll give them all to her.
Do you want me to identify for you ahead of time which ones?
That would be good.
With respect to the autopsy photos of victim Brandy Peters, it states 102. It would be D, E, G, I, O through T, W, Y, J, J through LL, VV through WW, and AAA and BBB.
Triple A, is it?
Yes, sir. With respect to Tamaya Peters, I didn't mark the initial photo identifying her, but I don't object to a photo to identify who it is. But then after that, the only ones I don't object to are I, J, O, Q, and R. The rest I object to.
Okay.
So those are 102 and 104. Were there objections? There was 106 and 108. One of those is Tanaya and one of those is Javante.
Yes, Your Honor, I object to all of those autopsy photos.
And that's just a generalized objection. Don't think we should get into them because you're not disputing the cause of death.
Yes, sir. 403 analysis.
Okay. All right. Dr. Flanagan, the prosecutors indicated that the photos that she is marked for identification to be presented to the jury are photos that you picked out to explain your findings. Is that accurate?
Yes, it is.
There is an objection as to some of these photos based upon them being overly gruesome, I guess. I guess that'd be the only way to describe it. Are there photos in there that you feel like you could do without that would not interfere with your ability to explain each of your findings in the case? In other words, are there repetitious photos in there?
I tried not to put repetitious photos in there. I went through and picked out the photographs that were as clean as the ones that I have, the ones where I've cleaned the blood off. But she has many, many injuries, and the photographs show different angles, and basically I tried not to duplicate them, but yes, some injuries show up in more than one photograph, but that's because I had to show different angles to get a better view of the wound that I was trying to document.
You want to cross on that, Mr. Brent?
I suppose it would be most helpful to have the photo so I can ask her specifically why that photo is necessary to explain her testimony and findings. Or do you want me to just inquire generally?
We're not going to go through
Yes,
each
sir.
photo
Okay.
at this point.
With respect to victim Brandy Peters first, the photos that I'm most concerned with are the ones of internal examination, where you're tracking bullet paths and things of that nature. You can't really, would you agree that you can't really tell as a layperson what you're looking at there anyway? Could you explain verbally to the jury without having to show them internal pictures of the victim in an effective and clear manner without showing those pictures?
Well, I think the photographs, the ones you're talking about with the probe through them, show the wound tracks through her body. They're the only ones that actually, as far as the gunshot wounds, caused injury to an internal organ. I didn't show any pictures of the organ itself, but kind of implying this is where the lung would be, and I just show the path that it took through that chest. And they're the only gunshot wound injuries that, as I said, caused any significant internal trauma.
I mean, you're going to verbally explain all that to the jury as well as you're showing pictures, correct? That's your plan?
Yes.
Could you explain just as effectively what the path is by simply saying, look, the bullet entered here on the left side of the victim's torso and exited there on the right side of the victim's back? Can you do that in a manner that is clear, as you did in your report?
I mean, I could try, but obviously I'm not able to know how they're interpreting that and if it would help them visually to see the wound track through her body.
With respect then to the wound, the primary wound to the victim's forehead on the left side, that's really the only specific individual wound that I have great concern about. Could you explain that wound and how it led to the victim's death without having to show pictures of that wound?
Well, that particular wound is probably the most significant wound of all that she sustained. It's probably the fatal wound.
Could you just say that and let the jury know that there was a significant injury to the left side of her forehead with skull fractures and breaks and all that caused brain hemorrhage? Could you just explain it like that without having to show that part of the pictures?
Again, I can't tell what they would interpret from my words when there's a photograph to show it. Even her identification photograph will show the injury to her face.
I understand. I would just make argument, Your Honor.
You can be heard.
All of this is subject to a 403 analysis. Clearly, it would be in the witness's opinion useful to be able to explain with photos so that they can see exactly what she's talking about, but that's not the end of the analysis under 403. And I would suggest that it's not especially probative or helpful. The topics that she's talking about, bullet track or the injury to the forehead, are not hard to understand topics. She can say where the bullet entered and where the bullet exited. She can explain that the injury to the forehead was the primary cause of death. She can explain that there was skull fracture and brain hemorrhage. I don't think that the jury needs to see the victim's face caved in up close to be able to understand that, especially when cause of death is not at all in dispute, which goes to the first part of the analysis as to whether it's even probative. So given that the testimony is not in dispute and given that the pictures are horrifying, I would suggest that it's not appropriate.
And welcome back. What we were just going through right now is actually kind of a pretrial hearing or pretrial motion prior to Dr. Flanagan actually testifying, excuse me. So what happened here is they were going through some of the evidence that may have been the prosecution would have liked to have been admitted through Dr. Flanagan. And the defense was saying pretty much that some of the photos that were taken would have been prejudicial to the jury and really would not have made much of a difference, or maybe would have had the jury kind of their emotions escalate, or wouldn't have been much, it wouldn't have been helpful to Dr. Flanagan's testimony. So at that point, after the arguments were made, the judge actually decided to overrule the defense's objections in regards to the evidence or the particular photos that the prosecution was trying decided to admit during that time through Dr. Flanagan. What we're next going to go to is we're next going to throw to a clip, actually, of Dr. Flanagan's actual testimony. So we're going to go to that now and take you there. As soon as we get live feedback from the courtroom, we'll be sure to bring that in.
What information did you receive prior to performing the autopsies?
Well, our office was notified that these individuals had been found deceased in the residence, and that obviously it was suspicious. There was obvious trauma to the individuals, and the police, they started their investigation. I assume jurisdiction, since because of the circumstances of the death, and ultimately the bodies were brought to the morgue, and I completed an autopsy on each one of them.
And the judge is back on the bench in the Henry Segura matter, so we're going to take you to the live trial right now.
All right, everybody be seated, please. Welcome back, everybody. Sorry, apparently we had a little problem with parking this morning. We'll have designated parking spots for you by this afternoon, so we'll provide that to you. But everybody needs to work on being here in a timely fashion. We start going 15, 20 minutes every time we take a break, and we're not going to get this trial done in the time we've allotted. Then I'm going to be hearing complaints from y'all, but that's just what's going to happen. So we need to be a little more vigilant about not trying to see how close we can come to the exact time, and we need to get it started on time. Anybody been exposed to something that they need to discuss with me from over the weekend? All right, if you'd face the clerk and be sworn, please, ma'am.
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
All right, you may proceed.
Thank you, Your Honor. Good morning, ma'am.
Good morning.
Can you please introduce yourself to the jurors?
Yep. My name is Rebecca Cuevas.
Okay. And did you, I believe that's a married name?
It is.
And what was your previous, prior name?
My previous last name was Blizzard.
Okay. And it's my understanding you used to work for Tallahassee Police Department?
I did.
Did you work for Tallahassee Police Department back in November of 2010?
I did.
Okay. And with the Tallahassee Police Department, what was your duties?
My official title was a forensic specialist 2, which basically means that I went to crime scenes, collected evidence, documented, processed evidence, and then I was also specialized in fingerprints, so I compared fingerprints as well.
Okay. And how long were you with the Tallahassee Police Department in that capacity?
I started working there in 2008, and I believe I worked up until 2011 full-time, and then I believe I fully resigned in about 2015.
Okay. And did you hold the same position throughout the course of your employment with Tallahassee Police Department?
In the beginning, I was just a forensic specialist, so I did not do fingerprint comparison, and I couldn't tell you what the date was when I actually started doing that position.
Okay. In order to do the forensic specialist where you're collecting evidence, did you undergo any kind of training or classes that showed you how to do that properly?
Yes. Before I worked at TPD, I also worked at the Florida Department of Law Enforcement, so in the fingerprint section there. So I got extensive training there, and then also on-the-job training at the Tallahassee Police Department.
Okay. And in your duties there at the Tallahassee Police Department, did you have an occasion to go out on November 26, 2010
I did.
Be involved in a homicide involving Randy Peters?
Yes.
Okay. And how is it that you become involved in an investigation like this?
Typically, we get dispatched to locations from investigators.
Okay. And was that what happened back on November 26, 2010?
Yes, it was.
And where was it you were dispatched to?
I was dispatched to Jack McLean Park.
Where is Jack McLean Park?
It's on Paul Russell Road. I'm not sure the exact number, but...
Okay. Out there towards the fairgrounds and all that?
Yes, yes.
Okay. And you were called to Jack McLean Park to collect evidence?
I was.
Okay. And when you arrived at Jack McLean Park, when you're processing Jack McLean Park, how do you go about processing a scene such as that?
Typically, the investigators kind of know where things are. But I basically photograph the whole area, but sometimes video. And then depending on what we see, we put out little markers that we think might be of evidentiary value, and then photograph those and then go about collecting the evidence.
Okay. Whenever you first arrived, do you talk to law enforcement or investigators and they kind of give you an idea and overview of what you're doing there?
Yes.
And did you, in fact, when you processed this scene, did you go in and take those overall photographs and then, I guess, closer up as you locate certain items?
I did.
Your Honor, may I approach the witness?
You may.
I'm showing some previously marked for identification purposes, state composite 117, photograph A through L. Without showing it to the jury yet, please take a look at those.
They are in evidence, Mr. Fuchs.
Okay, there were some questions about whether we had actually done that at one point, so I wasn't sure.
117A through L were admitted.
Okay, thank you. Does that accurately depict the scene that you responded to there at Jack McLean Park
Yes, it does.
and the photographs and evidence that you collected?
Yes.
Your Honor, permission to publish them throughout the course of testimony?
You may.
Dim the light just a little bit, please, Your Honor. Now, Ms. Huevos, is that right?
Yes.
Okay. What are we looking at here? This photograph A.
That was one of the bathhouse that was at Jack McLean Park.
Okay. Is this one of the areas that you process and look for items of evidence?
Yes, it was.
What are we looking at? Photograph B.
That is a picture of, there was like a little pavilion that had picnic tables. I believe it was kind of adjacent to that bathhouse.
I see these little yellow tag things here. What are we looking at there? What are those?
Those are the evidence markers. So we typically put those out so you can actually see where evidence is when you're taking overall photos.
Okay, so what we're looking at in this particular situation is after you've already kind of identified certain areas of interest?
Correct.
Your Honor, may I approach the witness?
You may.
Showing some previously marked for identification purposes as States Exhibit 118C, D, E, F, and also 118M. Actually, take a look at those items, please. Do you recognize those items?
I do.
Okay. What do those items appear to be?
These were items that were marked on that photograph there, but they were like clothing tags.
Okay. And whenever you respond to this location, you've marked these items, how do you go about actually collecting these pieces of evidence?
Specifically, we, like I said, we'll mark it and photograph them, and then we'll obviously put on gloves, and in between each piece, like picking up each piece of evidence, we'll change our gloves out.
Okay. And do you package them a certain way to make sure that they're safeguarded?
Yes, they will go in their own individual envelope or bag.
Okay. And the envelopes you see there and the items before you, is that the envelope that you would have packaged those items in?
It is.
do you mark them in some way to show that you were the one that was collecting them and that what the item contained in each one is?
Yes, I'll write a description of it, what the number was, like item number 1, and then I also initial.
Okay. And did you do so in this particular case, conform to those?
I did.
Okay. Your Honor, this time I'd move state's composite 118, make sure I get the right numbers. C, D, E, F, as well as M in the evidence, please.
C, D, E, F, and
M as in Michael.
so
That's an
my
L.
notes that said we'd already admitted 118A through
Just
just A.
Yes, sir. Just that.
All right, any objection? No, Your Honor. All right, they'll be admitted.
All right, thank you. Photograph C. What are we looking at here?
That's the same pavilion, it's just a different angle. But again, the evidence markers where these pieces of evidence were found.
Okay. Photograph D.
That's a close-up of item number 1, and it was a closed tag.
Okay. Is that the item that's contained in State's Exhibit 118C?
Yes.
Photograph E.
Again, that's item number 1, and it's just a closer-up picture of the closed tag.
What are we looking at with photograph F?
That is, again, the pavilion with the picnic tables and just a different angle of the items that were marked on the ground there.
Okay. Now, is item number 1 in this picture, or is this going to be additional items in addition, other than item 1?
It looks like it's additional.
Okay. Okay. What's in this photograph?
That would be item number 2, and it was also closed tags.
Okay. And is that the item that's contained in 118D?
Yes, it is.
Photograph number H. Could it be item number 3?
It is.
And is that the item that's contained in 118E?
Yes, it is.
One moment. Photograph J.
That was item number 5, and it was a little piece of some kind of tag.
Skip number 4. And is that the one that's contained in 118M?
Yes, it is.
Unfortunately, I skipped over. Photograph I.
That's item number 4, and again, a little piece of tag from.
Okay. And is that the item that's contained in 118F?
Yes.
Now going back to photograph A, there appears to be a trash can in front of that restroom area. Did you process that or look for that items in that particular trash can?
I believe I did.
Showing you photograph K. Is that trash can?
Yes, it is.
And photograph L. Kind of a closer up.
Yes, that would be a closer up picture of that trash can.
That T-shirt, was that seized as evidence?
It was.
Showing some previously introduced into evidence as a 118A. Actually, take a look at this, please.
Did you want me to take it out?
You don't have to take it out.
Okay.
You can just look inside and identify
Okay.
it. Do you recognize that?
I do.
And is that the same item that's depicted in this photograph?
It is.
And is it in the same or substantially same condition it was whenever you seized it?
It appears to be, yes.
You're on permission to publish the previously introduced piece of evidence.
You just gonna show it to them?
I am. Now, as it relates to A, I notice there's some dark stains on the shirt. At the time, were you, or at any time, I guess, were you able to test for potential blood, see if that was in fact blood?
I did not.
Okay. Would Annie Cressy back in your office be someone at that time, be someone who would have tested for possibly suspected blood?
She could have.
Okay. I'm showing you state what's been previously marked for identification purposes, stated exhibit 118B. Actually, take a look at that, please.
Okay.
Do you recognize that item?
I do.
What does that item appear to be?
It was a white collared shirt.
And was that collared shirt also found at Jack McLean Park?
It was.
Okay, did you package that in the same manner that you previously talked about, doing the little tags and everything like that?
Yes.
Okay. Your Honor, this time I move states exhibit 1, I'm sorry, is it in the same or substantially same condition it was whenever you seized it?
Yes.
Your Honor, this time I move states exhibit 118B in evidence, please.
It's already in evidence. A through M are in evidence. It's fine.
I'm sorry.
Correct.
No, it is not, Your Honor.
No, it's fine.
No, sir, this was not presented before for evidence.
Okay. Right, is there objection?
No, Your Honor.
It be admitted?
Thank you, Your Honor. Permission to publish?
You may. what exhibits are you going to want to admit from 118? We got B through F and M in now. What other exhibits do you want to admit?
Yes, sir. The other exhibits I've got are 118G, H, I, J, K, and L remaining.
Any objection to any of those?
There you
They'll be admitted.
Thank you. Now, both of those shirts that we just showed in A and B, they were found in a trash can, correct?
They were.
Okay. As far as you know, you don't know whether they have any relations at all to the homicide that occurred 6 days earlier, do you?
No.
Showing you the exhibits we just discussed, G, H, I, J, K, and L. Actually, take a look at those items, please. As it relates to item G, what is it that is contained in that package?
Here, it says gloves.
Okay. And where were those gloves found?
These were also found at Jack McLean Park, I believe in a trash can.
Okay. H?
H is a glove.
Again, where was that found?
They were also found in a trash can at Jack McLean Park.
What about J, K, and L?
They're also gloves. Also found at Jack McLean Park in a trash can.
Hold on. How about the glove?
Cross.
No problem.
Any juror have a question of this witness? All right, if not, you can step down. Do we need to keep her any further?
No, Your Honor.
All right, you're
I would ask to keep her under the rule.
all right. Remain under the rule. You'll be subject to recall. Defense will contact you if they need to. Next witness.
Your Honor, this time state would call Joellen Brown. One moment to give this evidence.
Somebody need to get her.
And Your Honor, may I approach so I can switch the,
What's that?
can I approach so I can switch the projector over?
Okay.
Thank you. Nope, excuse me.
Up here, please, ma'am. You face the clerk and be sworn to.
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Have a seat, please, ma'am.
Good morning, ma'am.
Good morning.
Can you please introduce yourself to the jurors?
My name is Joellen Brown, and I have been a senior crime laboratory analyst at the Florida Department of Law Enforcement. Excuse me. I retired in December of 2015.
As a lab analyst at the Florida Department of Law Enforcement, what were your duties?
I worked in the DNA biology section, and items of evidence that were submitted for cases I would examine and look for bodily fluids such as blood, semen, and saliva. And if I found them, I would do DNA typing in order to try to determine who they came from. I also could test for the wearer of items by swabbing off epithelial cells.
Okay. And I assume that you had some sort of specialized training and experience that would allow you to do that?
Yes. I have a master's degree from Ohio State University in pathology, but I also trained at FDLE specifically to do this job for 13 months and have worked there for 19 years until I retired.
Okay. And when you say you train, do you take specialized classes? What kind of classes are we talking about?
Yes, the training involved a lot of readings, a lot of actual written tests, and also working with the evidence and learning how to do all the procedures.
Okay, and have you previously testified as it relates to DNA comparisons and analysis?
Yes, I have.
Approximately how many times?
About 80 times.
Okay, Your Honor, this time I tender the witness.
Any voir dire, Ms. Brown? No, Your Honor. You may proceed.
Now, you mentioned you do testing for DNA and as other biological material. How do you go about doing that in a situation, let's say you have a swab?
If I have a swab, well, first of all, if it has any red-brown staining on it, I would test it for blood. If it is a swab that doesn't have any visible staining on it, I would just cut a little piece of the swab. I would do a chemical test that would extract out the DNA from the cells. Then we do a procedure called PCR, or polymerase chain reaction, which basically is like a molecular Xerox machine, making many, many copies of those pieces of DNA that are in that sample. Then we run that sample.
Let me stop you right there. Why do you do that?
We do that because the amount of DNA in a cell, or a few cells, is just too small to be detected. So we want to make copies of whatever DNA is there in order to be able to detect it.
Okay. What's the next step in your analysis?
We then run that sample through a genetic analyzer. It has been through the process of PCR, those little bits of DNA that we're looking at are labeled with a fluorescent dye. And the genetic analyzer uses a laser to pick up those colors. Each one is a different color. There are 4 different colors. And the laser then prints, or the machine rather, then prints out a little diagram of peaks for us to interpret as to what type of DNA is there. Those peaks look like upside down ice cream cones, little pointy, very pointy, not like mountains, but like ice cream cones.
Okay. You talk about these peaks, and as I understand it, there's essentially 2 peaks per person at each one of the loci or locations. Is that correct?
Yes. In the STR type of analysis that we do for DNA, at that time that I was working on this case, we had 13 markers that we looked at. Now we do 15, and they're soon going to go to 20. But at those 13 loci, you inherit a gene for each one of those genes one from your parents, one from your mother, and one from your father. So each person would have 2, although you may have only 1 peak if you inherit the same type of gene from each parent. And we designate those genes by numbers. So for instance, you could be an 8-10 at a particular locus, or you could be an 8-8 if you got an 8 from your mother and an 8 from your father.
Okay. And did you follow these same kind of procedure? You mentioned earlier that the first thing you do is look if there's a red-brown stain, that you look to see if there's a possibility of blood being present.
Yes.
Okay? And then you said if you don't have blood present, you then start cutting it off the swab and start doing the analysis. What do you do if you have a red-brown stain?
Well, if we have a red-brown stain, we do basically the same analysis, but we do a chemical test to determine if that gives indications of blood, because something like rust could also be a red-brown stain.
Okay. And then in order to do this analysis, you obviously, and let's talk specifically towards this case, you became involved in the homicide investigation regarding the homicide of Brandy Peters, Javante Segura, and Tanaya Peters, correct?
Correct.
Okay. And it's my understanding you received a lot of swabs, and we'll get to those in just a little bit. When you receive a swab from a crime scene in this particular case, let's say, what do you do about going and analyzing that particular swab? You've already talked about the procedures, but how do you go about determining who it may be?
Well, first of all, as I said, we determine if there's any stains. We do chemical tests to decide if there is blood there. If there would be a swab from a sexual assault kit, for instance, we would do a test to see if semen would possibly be there. And once we identify that something's there, we would then cut the swab and do exactly what I had said before. If it is a swab that is something for touch, meaning that if you touch an item, you can leave some cells there, such as a doorknob, there might be no stains at all on that swab, but we know we are testing for touch DNA, so we would just go ahead and cut that swab and do the same procedure for that.
What is touch DNA? What are we talking about there?
When you touch something with your hands, or even if you're wearing clothing, parts of your body that touch your clothing will leave some epithelial cells. Those are kind of cells that are on your skin and line your body. So your body is constantly sloughing off those cells. Therefore, when you touch something, you may leave some cells. But different people leave cells at different rates. So I might be a good shedder of cells, but someone else might be a poor shedder of cells. So whether or not we can actually develop touch DNA from an item is an iffy possibility.
Okay. And the other kind of DNA, as you mentioned, red blood cells and things like that, if there's blood or some other kind of liquid left on the scene from the person that contributed for DNA, would that be a way that you find that DNA comparison?
Yes, blood and saliva are very good indicators of DNA.
Okay. As I understand it, you, in this particular case, you analyzed a whole lot of stuff.
Yes.
And that you're multiple reports, so you did a bunch of different analysis, correct?
Yes.
Okay. Would it be helpful for your testimony to the jurors if we had a chart, a color-coded chart that would help depict and explain your testimony as we go through this?
That would probably make it simpler, yes.
And have you reviewed that color-coded chart that we just talked about to make sure the accuracy and it properly reflect your findings?
Yes.
Okay. If I refer to you to the screen up here, is this the chart we're talking about?
Yes.
Okay. And you actually have a pointer up there to help throughout the course of this. And over here, I've kind of made a key, if you will, as to the different colors and what they mean. Does that accurately depict what you looked at?
Yes.
Now, as I understand it, the first test that you did...
You're going to make a hard copy of this available?
I am, Your Honor. I tried to print it out, and unfortunately, we had a little problem with the printer, but I will make a hard copy and submit it into evidence, or into demonstrative aid.
Let's mark this 134 when we get the hard copy. So you're not offering it in evidence, you just want to use it for demonstrative purposes?
Yes, sir.
Defense have objection? No, Your Honor. All right. I still think we should make a copy available for the record. It'll be for identification purposes only. The significance of that to the jury is if it's a demonstrative aid, it does not go back with you during your deliberations. You will not get this chart for your deliberations. We're just going to use it here in the courtroom. May I proceed?
Thank you. Now, Ms. Brown.
Can you see it all right? It'd be better if we didn't turn all the lights off, but can you see it all right? Is that in the back row, can you see it?
Now, Ms. Brown, I noticed we have a couple of different color codings here. And the green would be the mixture of the family and things along those lines. How do you go about determining whose DNA it is? We were talking about your procedure, but you get, in this particular case, you get some buccal swabs that you analyze first and foremost.
Yes. In this case, I was given buccal swabs from the victims of the crime, and I'd go through the same procedure with them to develop their DNA type. And as I mentioned, a person gets two, we call them alleles. Allele just means what kind of a gene you could get. An 8 or a 10 is an allele. So each person would have 1 or 2 peaks. So they would have 2 alleles, but they might have 1 or 2 peaks at each locus. If I have a mixture, that means I will have more than 2 peaks indicated, and therefore I know that there's more than one person there.
Okay. And you mentioned the 2 alleles. Did you receive a buccal swab from Brandy Peters?
Yes.
And could you please tell us what the alleles were for Ms. Peters at the different locations?
The names of the alleles are kind of long, so in the laboratory we abbreviate them with letter D and a number, and what that indicates is what chromosome those are on.
Okay.
So for Brandy Peters at D3, which is the first one, her type was 1517. At VWA, her type was 1518. At FGA, her type was 2426. Then we have a marker called amylogenin, which indicates the gender of a person. In other words, it can tell if a person has only an X chromosome, or actually 2 X chromosomes, but only 1 peak at X. And if the person is a male, they'll have an X, but also a Y chromosome. So for Brandy Peters, her amylogenin type is XX. For D8, her type is 1115. For D21, her type is 2528. For D18, her type is 1719. For D5, her type is 1111. For D13, her type is 1111. For D7, her type is 1112. For D16, her type is 913. For THO1, that's TH01, her type is 77. For TPOX, TPOX, her type is 810. And for CSF, her type is 1114. And those are the 13 markers plus amylogenin. That was a full type for her.
Okay. And what about Javante?
Javante's type at D3 is 1717. At VWA is 1518. At FGA is 2426. At amylogenin, he has a male, so he has an XY. At D8, his type is 1215. At D21, his type is 2528. At D18, his type is 1919. At D5, his type is 1114. At D13, his type is 1112. At D7, his type is 1012. At D16, his type is 1113. At THO1, his type is 78. At TPOX, his type is 89. And at CSF, his type is 1111.
Now, Tamaya and Tanaya, they are twins.
Yes.
What does that do to your DNA analysis as it relates to, I guess, the buccal swab itself?
Well, of course, you can have identical twins or fraternal twins. And when I did the typing on Tamaya and Tanaya, it turns out that they are identical twins. So they have exactly the same DNA type at these 13 markers.
Okay, and what are the markers, the alleles at those markers for Tamaya and Tanaya?
The twins have at D3, 15, 17, at VW8, 14, or VWA, sorry, 14, 15, at FGA, 20, 26, at amylogenin, XX, at D8, 11, 12, at D21, 25, 28, at D18, 17, 18, at D5, 7, 11, at D13, 11, 12, at D7, 10, 12, at D16, 13, 13, at THO1, 7, 8, at TPOX, 8, 8, and at CSF, 11, 11.
Okay, and what about Mr. Segura?
Mr. Segura, Henry Segura, at D3, type 1717. VWA is 1518. FGA is 2124. Amylogenin is XY. D8 is 1216. D21 is 28 and 32.2. D18 is 1819. D5 is 1214. D13 is 1212. D7 is 1010. D16 is 1113. THO1 is 78. TPOX is 99. And CSF is 1111.
So what you do, if I understand you correctly, is you take those numbers and you develop certain swabs that were taken from the scene, and then you'll develop, I guess, peaks as it relates to the swab from the scene, and then compare them to see if those alleles are present at the proper locations.
Yes, whatever DNA type I got from the evidentiary material, I would then compare it to these victims' types. Most of the items came from their house, and especially if they were touch DNA, I would expect them to have one or more people from the occupants of the house on those kinds of items.
Okay. If we can refer to the chart, let's start, if we can go through these. What I see here is on the first line, which would be 103A, State's Exhibit 103A, B, C, D, E, F, through M, that these all appear to be swabbings or scrapings that were taken off of Brandy Peters. Do you do comparison or do you analysis based upon those items?
Yes, 1 through 10 were scrapings from her fingernails. I'm sorry, 103A through 103J. I used 1 through 10 as the FDLE number. That's what I was referring to. And at all 10 of these, Brandy Peters' type was found, which of course is normal. The green indicates that there was nothing foreign to her. The yellow indicates that there was some unknown alleles showing up.
Okay. When you say there was some unknown allele showing up, what does that mean?
That means there would be an allele showing up that's not hers. And in the cases of these 3 areas that are yellow, There was no indication of a Y, so there was not male DNA there. So I concluded that the foreign type was female, since there was no male there.
Okay. And these are all fingernails that we're talking about that have the yellow, so we're talking about State's Exhibit 103C, 103H, and 103I, correct?
That's correct.
Okay. As you make your analysis, are there different levels of these peaks that help you with your analysis or tell you how much DNA there is there, essentially?
Yes, the height of the peak tells you how much DNA is present. Oftentimes we can see in a mixture that there's a major component. In other words, the peaks are higher for that person, and there might be a minor component where the peaks are lower. There could be one or more minor components.
Okay. Do you have a specific term you use for that, I guess, frequency or the height of those peaks?
The unit, kind of like inches, if you were measuring with a ruler, is called RFUs, or relative fluorescent units. And as I mentioned before in PCR, these 13 areas are labeled with a fluorescent dye. So the laser picks up the fluorescence from these dyes. So their measurement unit is RFUs, or relative fluorescent units.
Is there a significance as it relates to the RFU number when you're performing your analysis in order to do a comparison for inclusion and exclusion?
Yes. At the time, in 2010 and 2011, when I was working on this case, the standard operating procedure for FDLE stated that between 50 and 100, we would call those star alleles, if that's all the taller they were. And what that meant was we couldn't be sure if we saw just one allele there, was that a homozygote, meaning it has two alleles of the same type, as before I gave you the example of 8-8. We couldn't be sure if that was 8-8, or was it an 8 and then the other allele that went along with it might have dropped out. Dropping out means there's just not enough DNA there to show us a peak. So therefore, we could not use the starred alleles between 50 and 100 to do any statistics to include a person. And we could exclude a person, however. So let's say if I had an 8 and a 10, both of which were starred, if I had a person whose type was 8-10, I could not say that they were included, even though it looks like they might have contributed something there, because I was not allowed to do statistics for a starred allele. And it was required that we had to have statistics in order for it to give some weight to how likely this is that person. So therefore, we could use starred alleles to say someone was excluded. If someone's type was 11-12, but my starred alleles were 8 and 10, then I could say that that person was excluded. But I could not say if a person was 8 and 10 that yes, they are included there, because I could not give a statistic based upon our standard operating procedures.
I guess is the scientific reason behind not doing an inclusion in that range that we just talked about for a star allele, what would that be? Why is that you wouldn't be able to do that?
That's, as I said before, we could not be sure that if I had a single allele, such as an 8, was that person's type really an 8-8, or was it an 8 something else and the other one just dropped out because there was not enough DNA. 50 to 100 RFUs is very low. The normal range for our calling is from 50 to like 8,000. And for a good profile, big strong profile, you would have RFUs in the hundreds. So 50 to 100 is pretty low.
Okay. So because the DNA, there's so little there, it makes it difficult to make a determination who it actually belongs to, but you can actually exclude somebody if something allele is there that shouldn't be.
If the person has an allele that's not present, like if a person's 11-12 and the starred alleles are 8 and 10, I know that that person could not have donated that. But if a person is an 8 and 10, I really can't say if the 8 and the 10 is from them, or if it may be from two different people and the other alleles have just dropped out. So that's why, scientifically, it's not a good idea to do statistics on those.
Okay. As it relates to these particular items we're talking about here, with the RFU numbers, are they of the numbers that you would be able to make an inclusionary term, or can you only use it for, are they star alleles you can only use for exclusion?
Well, on Exhibit 48, at D3, there was a 1517 from Brandy Peters, but there was also a 16 present. That was not a star. Then at CSF, there was an 1114 that would have been from Brandy Peters, but there was a starred allele. So technically, I could do a statistic on D3.
Okay. But you've got star alleles otherwise, and at this point, it's an unknown female who, that secondary mixture is, correct?
Correct.
Okay. And same with 103H and 103I, we're talking about an unknown female mixture, correct?
Yes, it was the same kind of situation with Exhibit 53, which is 103H for the court.
Okay.
There was a 16 at D3 and a star at 16, or at D3. There was another allele at FGA that was not starred. There was another allele at D8 that was not starred.
As it relates to DNA that's being left at a particular location, your analysis can make a determination that DNA is there, correct?
Correct.
Can you make any determination about when DNA is left?
No.
Okay. Why would that be?
DNA can last for a long time. For instance, in the laboratory, when we have standards that we want to keep, we dry it out on a little piece of cloth, and we can keep it in the freezer for years. However, under different circumstances in the environment, if an item was out in the woods, let's say in the summer in Florida, when there's lots of heat, which degrades DNA, and even dirt will degrade DNA because there are enzymes and organisms in dirt. So it all depends upon the environmental situation.
Okay. As it relates to these particular items, there's no way to tell whether or not this is something that happened on scene or whether it's something that would have been maybe your nail technician or something along those lines that left that DNA.
That's correct.
Okay. We can move on to NOP, 103 NOP. That appears to be additional items that were scrapings or swabbing from Brandy Peters that did not have any foreign DNA. Is that correct?
That's correct.
Okay. As it relates to 103 R, S, and T, those are purple, and I believe that means that they are not analyzed. Is that correct?
I looked at the item, but in terms of doing DNA analysis, each one of those was hairs from Brandy Peters' fingers, and there were no roots on those hairs. Therefore, I could not analyze them. For hairs, to do DNA analysis, you must have a root.
Okay. And why is that?
For the type of DNA testing that we do, which is nuclear DNA testing, only the cells in the root have nuclei that have viable DNA in it.
Okay. All right. Let's move on to State's Exhibit 81, 82, 90, and 35. These are red coded. What does that indicate? That Brandy Peters' DNA was present?
Yes.
Okay. And then I note that there's something here that says it's a mixture with an unknown male and unknown female as it relates to each one of those items. Could you tell us about that, please?
Yes. Item 81.
You've got the numbers not showing numbers.
There we go.
Item 81, which is a swab of the interior front door handle, was a mixture. Brandy was the major component, and it was a mixture because there was a Y chromosome indicated, but only a Y. There was nothing else. So therefore, I'd have to say that unknown person is male, but I don't have any other information on that person. For 82,
Wait, let me stop you right there. What do you mean you don't have any other additional information on that person?
there's no other alleles that I could use to make a call.
Okay, so you know that it was a male, so you have the XY chromosomes, but there's nothing else there for to say who it was.
That's correct.
Okay. Okay, next.
82, which was the swab of the interior deadbolt area of the front door, was a mixture of Brandy and the twins' DNA. But there were some unknown alleles there, and there was no indication of a Y, so I called that an unknown female.
Okay. Next.
And number 90, which was a swab of the interior deadbolt area of the front door. I think actually 90 is the exterior. It says interior here, but I think it actually is the exterior. This was a mixture also of Brandy and the twins. And again, there was an indication of a Y, so there was an unknown male. I didn't have enough information to say. It could have been Javante, I can't say.
Okay. So the only thing you know is that that was a male, possibly even Javante.
Yes.
Okay. Next.
Exhibit 35, is that what you're referring to?
I think it's going to be FDLE. I think we're next. We're on. Yes, Exhibit 35, FDLE 33, swab of phone cradle.
On the swab of this phone cradle, there was a mixture, including an unknown male, but it did have enough DNA that I could search the unknown type in CODIS, which is...
Well, let's not talk about CODIS, okay?
Okay.
Let's talk about, at this particular time, we have this exhibit, and as relates to your test back on December of 2011, what was your finding on that particular date? As I understand it, there was presence of at least 2 individuals.
Let me find my report for that one.
Yes, yes, ma'am.
Yes, this mixture there was Exhibit 33 from TPD, it's Exhibit 35 for the court. It was a swab of the side of the phone cradle. It demonstrated the presence of at least 2 individuals, at least 2. And if I would assume that there were only 2, I did have a complete DNA profile for the major contributor and a partial DNA profile for the minor. Complete means I have all 13 markers. Partial means I have less than 13. And the major DNA profile matched Brandy Peters. And the results for the minor donor were consistent with coming from a male individual.
Okay. And it's my understanding at that point, you determined that Tamaya, Tanaya, and Javante were excluded as possible contributors to the DNA profile that time, correct?
Well, actually, when you're dealing with mixtures of family members, it makes it a little more difficult to interpret. So I did interpret that as 2 people and that the children were excluded. However, on looking at it more carefully, I thought, oh, well.
All right, well, let's do this one first, and we'll get to your subsequent analysis, because I know that came out at a later time.
Okay.
Okay, all right. I'm not trying to cut you off. I just want to go by date, so that way we kind of keep this structured a little bit, okay? All right, so as it relates to 34, which is State's Exhibit 36, swab of the handset piece of phone. As I understand it, what were your results on that one?
There were at least 3 individuals indicated, and you would know that there were at least 3 because there would be 5 or more alleles at some of those loci.
Okay, back me up a little bit. What do you mean by that?
Well, as we discussed, if it's a single person, there's 1 or 2 peaks. If there are possibly 2 people, you would find 3 or 4 peaks, because they might be different from each other. And then if you have a third person, that's usually indicated by having more than 4 peaks, if they're not related anyway.
So then, as I understand this one, then we've got more than 4 peaks, and that's an indicator there's a possible third donor.
Correct.
Okay, and what was your finding, if anything, as it relates to that third donor?
Brandy, Tamaya, and Tanaya, and Javante were all included as possible contributors to the mixed DNA profile, but there were indications of an additional contributor to the mixture.
Okay. And that's the handset of the phone, correct?
Correct.
Okay. State's Exhibit 44, what was your finding as it relates to the master door handle there, the master bedroom door handle?
That was a mixed DNA profile from the swab of the exterior master bathroom door handle, which demonstrated, again, at least 3 individuals. And I could not determine major or minor components for those. But Brandy, Tamaya, Tanaya, and Javante are all included as possible contributors to that.
Okay. So essentially, we're consistent with the family members here, correct?
Correct.
All right. As it relates to item number 45, which is TBD number 36.
That was a swab of the exterior toilet room door handle. That indicated the presence of at least 4 individuals. And I could not determine the profiles for major and minor contributors. Again, Brandy, Tamaya, Tanaya, and Javante are all included as possible contributors to that mixture. And if I assume the presence of all 4 of the victims, there's indications of at least 2 additional contributors to the mixture.
Okay. And let me pause you right there. At one point, we were talking about comparisons when you have 2 persons and they figure out who was the minor and the major. And obviously, you'd have 2 peaks, I think is what you said, was significantly higher than other ones, so you could tell they were the minors and majors, correct?
Correct.
As it relates to this one, you said you could not consider, you couldn't figure out who it was that was the major and the minor. Why would that be?
Because a lot of the peaks were about the same size. And also, since there's so many people in this mixture, we don't know who's sharing what with whom. When we're talking about a mother and her children, if there's a mixture of a mother and 1 child, you would only have, because they share 1 peak, you know, these are mom's peaks and these are child's peaks. The child inherited 1 of those peaks from the mother. So there would only be a maximum of 3 peaks. And in some cases, the child might have exactly the same type as the mother, and there might be only 2 peaks. So when we're talking about a mixture of a mother and a child, instead of the usual situation where there would be at least 4 peaks, or 3 or 4 peaks at all loci, instead, with the children, there's no more than 3 peaks. So when I included Brandy and all of the children, Tamaya and Tanaya have exactly the same DNA type. Javante is a little different. So it's possible with a mother and 2 children that have 2 different types, there might be 4 peaks. And so, but that would be the maximum. In some of the cases, in some of the loci for this particular exhibit, there were more than 4. So I knew that there were more than just the family members. There were some DNA alleles that were foreign to the family members.
Okay. And then Exhibit 111, 110, 131, 112, 113, and 114. Those are all buccal swabs of each one of those individuals that you use for comparison purposes, correct?
That's correct.
And as I understand, Green, it means you found no foreign material in those buccal swabs, which is to be expected, correct?
That's correct.
Okay. Now, if we can real quick, as to 45, which would be TPD Exhibit 36, it's my understanding at a later time you received some other buccal swab for possible comparisons.
Yes.
Okay. And one of those buccal swabs, or two of those buccal swabs, was Mary Richard Williams and Cassandra Williams. Is that correct?
Yes.
Okay. And did you go back and compare that with that exhibit to find out where they were possible donors?
Yes, I was given buccal swabs from many different people who might have visited the home, and even police officers, to make sure that they did not leave their DNA there. And I compared all of those profiles that I developed to these mixtures. And in this particular mixture, which was States 45, the exterior toilet room door handle, I could exclude everyone except for Mary Rashad Williams and Keyshandra Williams.
Okay.
They had some alleles that would have been included in that mixture.
And you don't know who these people are as they relate to anybody. That would have to be an investigator that talks to who as Mary Rashad Williams, Cassandra Williams are, correct?
I don't know who they are, no.
Okay, fair enough. Whenever you did the comparison, and I noticed that Henry Segura and Tony Anthony, of course, the children are there, were you able to determine paternity for Tamaya and Tanaya Peters?
Yes, Antonio Anthony is the father of Tamaya and Tanaya.
Okay. And as it relates to Javante Segura, were you able to determine paternity there?
Yes, Henry Segura is the father of Javante Segura.
So as I understand, all your testing on December 3rd of 2010, with the unknown male, you were able to exclude Mr. Segura as on Exhibit 72 and 7, you excluded him on the phone, the toilet, and of course the female DNA from the fingerprints, correct?
Yes.
Okay. But you could not exclude him on 72 and 74, which is the front door handle and deadbolt, correct?
For Exhibit 74, which is States 90, I could not make any conclusion about the male contributor.
Correct.
Just to say that there was a foreign male contributor.
Okay. And the same with 73, correct?
Do you
Or
mean
72, excuse me. 72.
Right. I got no results obtained for the minor donor except for amylogenin, which is consistent with a male. So I had no information on which to make any kind of conclusions.
Okay. Let's move on to the January 31st report, please.
If this is a stopping point, Mr. Chief, maybe
Yes.
take 10 minutes here.
Thank you, Your Honor.
Mr. Grable. All right, let the jury step out. Take 10 minutes. Either side need anything?
No, sir.
All right, we'll be in recess.
Good morning.
Can you please introduce yourself to the jurors?
Yep, my name is Rebecca Cuevas.
Okay. And did you, I believe that's a married name?
It is.
And what was your previous, what was your prior name?
My previous last name was Blizzard.
Okay. And it's my understanding you used to work for Tallahassee Police Department?
I did.
Did you work for Tallahassee Police Department back in November of 2010?
I did.
Okay. And with the Tallahassee Police Department, what was your duties?
My official title was a forensic specialist 2, which basically means that I went to crime scenes, collected evidence, documented, processed evidence, and then I was also specialized in fingerprints, so I compared fingerprints as well.
Okay. And how long were you with the Tallahassee Police Department in that capacity?
I started working there in 2008, and I believe I worked up until 2011 full-time, and then I believe I fully resigned in about 2015.
Okay. And did you hold the same position throughout the course of your employment with Tallahassee Police Department?
In the beginning, I was just a forensic specialist, so I did not do fingerprint comparison, and I couldn't tell you what the date was when I actually started doing that position.
Okay. In order to do the forensic specialist where you're collecting evidence, did you undergo any kind of training or classes that showed you how to do that properly?
Yes. Before I worked at TPD, I also worked at the Florida Department of Law Enforcement, so in the fingerprint section there. So I got extensive training there, and then also on-the-job training at the Tallahassee Police Department.
Okay. And in your duties there at the Tallahassee Police Department, did you have an occasion to go out on November 26, 2010 and be involved in a homicide involving Randy Peters?
Yes.
Okay. And how is it that you become involved in an investigation like this?
Typically, we get dispatched to locations from investigators.
Okay. And was that what happened back on November 26, 2010?
Yes, it was.
And where was it you were dispatched to?
I was dispatched to Jack McLean Park.
Where is Jack McLean Park?
It's on Paul Russell Road. I'm not sure the exact number, but...
Okay. Out there towards the fairgrounds and all that?
Yes.
Okay. And you were called to Jack McLean Park to collect evidence?
I was.
Okay. And when you arrived at Jack McLean Park, when you're processing Jack McLean Park, how do you go about processing a scene such as that? Typically,
the investigators kind of know where things are, but I basically photograph the whole area, but sometimes video, and then depending on what we see, we put out little markers that we think might be of evidentiary value, and then photograph those, and then go about collecting the evidence.
Okay. Whenever you first arrived, do you talk to law enforcement or investigators, and they kind of give you an idea and overview of what you're doing there?
Yes.
Okay. And did you, in fact, when you processed this scene, did you go in and take those overall photographs and then, I guess, closer up as you locate certain items?
I did.
Your Honor, may I approach the witness?
You may.
I'm showing some previously marked for identification purposes, state composite 117, photograph A through L. Without showing those to the jury yet, please take a look at those.
Mm-hmm.
They are in evidence, Mr. Duke.
Okay, there were some questions about whether we had actually done that at one point, so I wasn't sure.
117 A through L were admitted.
Okay, thank you. Does it accurately depict the scene that you responded to there at Jack McLean Park?
Yes, it does.
And the photographs and evidence that you collected?
Yes.
Your Honor, permission to publish them throughout the course of testimony?
You may.
You dim the light just a little bit, please, Your Honor. Now, Ms. Huevos, is that right?
Yes.
Okay. What are we looking at here? This photograph A.
That was one of the bathhouse that was at Jack McLean Park.
Okay. Is this one of the areas that you process and look for items of evidence?
Yes, it was.
What are we looking at, photograph B?
That is a picture of, there was like a little pavilion that had picnic tables. I believe it was kind of adjacent to that bathhouse.
I see these little yellow tag things here. What are we looking at there? What are those?
Those are the evidence markers. So we typically put those out so you can actually see where evidence is when you're taking overall photos.
Okay, so what we're looking at in this particular situation is after you've already kind of identified certain areas of interest?
Correct.
You may.
Showing some previously marked for identification purposes as States Exhibit 118C, D, E, F, and also 118M. Actually, take a look at those items, please. Do you recognize those items?
I do.
Okay. What do those items appear to be?
These were items that were marked on that photograph there, but they were like clothing tags.
Okay. And whenever you respond to this location, you've marked these items, how do you go about actually collecting these pieces of evidence?
Specifically, we, like I said, we'll mark it and photograph them, and then we'll obviously put on gloves, and in between each piece, like picking up each piece of evidence, we'll change our gloves out.
Okay. And do you package them a certain way to make sure that they're safeguarded?
Yes, they will go in their own individual envelope or bag.
Okay. And the envelopes you see there and the items before you, is that the envelope that you would have packaged those items in?
It is.
Do you mark them in some way to show that you were the one that was collecting them and that what the item contained in each one is?
Yes, I'll write a description of it, what the number was, like item number 1, and then I also initial.
Okay. And did you do so in this particular case, conform to those?
I did.
Okay. Your Honor, this time I'd move States Composite 118, make sure I get the right numbers, C, D, E, F, as well as M into evidence, please.
C, D, E, F, and
M as in Michael.
so I noticed it said we'd already admitted 118A through just A.
Yes, sir.
Okay.
Just that.
All right. Any objection? No. All right. They'll be admitted.
All right, thank you. Photograph C. What are we looking at here?
That's the same pavilion, it's just a different angle. But again, the evidence markers where these pieces of evidence were found.
Okay.
And welcome back to the LawNewz Network. My name is Stephanie L. Willis, and I'm your host for this morning. We are covering the Henry Segura trial here today, and what we've seen here is we're actually on a break right now in the courtroom. The judge issued for a 10-minute recess just to kind of give the jury a little bit of a break. I know that we were getting some information from the DNA, the individual who collected all the DNA. I believe her name was Joellen Brown. Now, this information is highly important both for the prosecution and the defense, because we know in this case from reports that allegedly another individual by the name of Quinones advised that he advised someone else to carry out this, this murder, and this is the theory from the defense, due to the fact that Brandy Peters owed some money to a Mexican gang. So in this case, this DNA that we find here is extremely important. One being the fact that we're not seeing any DNA that's coming from Henry Segura. There have been partial DNA evidence that was found, partial DNA that they were able to determine was a male because of the fact that there was that Y chromosome. However, they were unable to determine who exactly the DNA belonged to. Furthermore, the DNA examiner also advised that she found DNA evidence from both Brandy, Tamaya, Tanaya, and Javante. Another thing that I thought was of great importance, was the fact that the prosecution made sure that Ms. Brown pointed out that she did test the DNA in regards to the investigators who may have been on the scene, in addition to other family members, because that way that they're able to exclude a good group of people. So we're able to say, okay, maybe this is a male DNA, but we're able to exclude the investigators or other family members who may have been in and out of the apartment or the house at that time. So that information is extremely important. We also heard some testimony this morning from an individual by the name of Rebecca Cuevas. Rebecca Cuevas testified as to the pictures, the photographs that were taken at the scene. She also testified as to a shirt that was found with some blood stains on it. All of this information, although tedious and although sometimes boring, is very important. It's important, one, for making of the record, and two, it's important for the juror members to actually hear this evidence and for it to be admitted into evidence, so that they can gain the totality of the circumstances. Because we know for a fact that this pretty much is a case based upon circumstantial evidence. We don't have a murder scene that a murder weapon that we know of at this time, and they found Mr. Segura far away from the crime. He was not there. He was actually in Minnesota when they found him. So the evidence that the prosecution is presenting at this time is extremely important. But I do have to say that, in my opinion, and I don't know how you all feel, and feel free to please chat with us in the chat room so that we can get your opinion as well. But I don't know how well this DNA evidence is working for the prosecution, because of the fact that, of course, we're finding a lot of DNA evidence from Brandy, from Tamaya, from Tanaya, from Javante, but we're not finding anything really that's linking us to Henry. And if I'm a juror member, and if I'm defense counsel, of course, I'm going to harp on the fact that Henry's DNA was not found at the scene of the crime, and the fact that there is this other individual who may have been there. This partial DNA may have belonged to someone else. We're unable to determine who it is, so that may bring out some reasonable doubt from members of the jurors. One thing that I do want to update you all on is the individual who was originally set to testify by the name of, I believe it was Alvin, I forgot his name at the time, but he was supposed to testify as to the fact that he would have, that he was the one who issued out the hit on Brandy. However, he has since decided that he will plead the fifth. And so we all know what happens when an individual pleads the fifth. Every question that's answered, if he does take the stand, because he is sitting in a local jail at this time, if he is brought into the courtroom and does take the stand, it is possible for each and every question that he is asked, he will respond that he has elected his right to plead the fifth. Now, what we're going to go to is we're going to go to another clip. We're going to bring you back to Rebecca Cuevas during the interim time, so that we can just bring you up to speed for those of you who may have missed some of her testimony. So we're going to take you to that clip now.
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Have a seat, please, ma'am.
Good morning, ma'am.
Good morning.
Can you please introduce yourself to the jurors?
My name is Joellen Brown, and I have been a senior crime laboratory analyst at the Florida Department of Law Enforcement. Excuse me. I retired in December of 2015.
As a lab analyst at the Florida Department of Law Enforcement.
And welcome back. The judge is back in the courtroom, so we're going to bring you live to that feed. I do want to correct the individual's name. His name is actually James Santos. He's the inmate that claims that he ordered the hit, and his attorney has advised that in an email that he has decided that he will plead the fifth, and that's his final decision. So what we're going to do right now is going to bring you right back into the courtroom just so that we don't miss any testimony. So stay tuned.
All right, everybody be seated, please. May proceed, Mr. Chief.
Thank you. We can now turn to your report dated January 31st of 2011. Okay. Looks like a whole lot of stuff was analyzed at this particular time. Is that correct?
Yes, this is a culmination of a lot of testing. Yes.
Well, let me ask you a question. Why is it that there's some stuff tested on December 3rd, there's some stuff tested on January 31st, and multiple different times? Why would that be?
These dates are just the dates of my report.
Okay.
From the time that the crime occurred, I was working pretty constantly on analyzing things every day.
Okay. Is there any kind of rules or anything that regulates the number of items that Tallahassee Police Department or any other agency for that matter can submit at certain times, or how you go about choosing what to analyze and in what order?
At that time, there were no rules that said multiple things could not be determined. How I determined to test things is I pretty much tested everything.
Okay.
There might be a few things that were left out. For instance, the victim's clothes did not need to be tested if they were all bloody. We know that victims, if they were bleeding, that was their blood.
Okay. Well, that brings up a good point. As it relates to the victim's blood being on their on the clothes, is it possible for, obviously in this particular case, talking about Brandy Peters had very extensive injuries and there's a lot of blood involved. Is there a situation where essentially her blood could, I guess, wash out other DNAs or overpower DNAs and things along those lines?
Yes, especially if we're talking about one person's touch DNA and the other person's bleeding. We get DNA much more easily, and there's a lot more of it from blood. Very little DNA from touch.
Okay. So it's possible essentially that it would overpower at that point for many to touch DNA from Mrs. Peters because of the amount of blood she had.
If we had someone touched an area and then she bled on it, that's correct.
Okay, all right. So let's talk if we can. Let's move through this. State's Exhibit number 9, which is Tallahassee Police Department number 1. Well, let me ask you another question. When it talks about the analysis, do you ever talk to law enforcement or work with law enforcement in going through things that may be more likely to show DNA to help you, or do you just, in this particular case, analyze everything?
Sometimes we do talk to law enforcement.
Okay,
Yes.
Did you do so in this case?
I don't recall.
Okay, fair enough. Long time ago.
Right.
Okay. All right, so let's go to State's Exhibit 9, which is TPD 1. What was your finding as it relates to that?
This red color is indicating that that is Brandy Peters type. From all these exhibits that are colored red, I either got a complete type, a partial type, or a major type, and all of them matched Brandy.
Okay. And so let's go. So we're talking about number 9, 10, 11, 18, 19, 20, and 53. All of those were consistent with just being Brandy Peters with no mixtures found, correct?
I will have to check. Yes, there was either a complete, partial, or major DNA profile. When I say major, that was indicate that there was a mixture.
Okay. And I believe as it relates to 23, you actually found a mixture there, is that not correct? Which is State's Exhibit 54?
On,
And I think those are mislabeled. I think that's supposed to actually be Exhibit number 22 and 23. You found a mixture, is that correct?
by TPD's number 22 and 23, yes, there was a mixture.
And then, so in State's Exhibit number 53, which is TPD 22, and State's Exhibit 54, TPD 23, you found a mixture. So these two actually should be moved up, correct?
Well, there were indications of an additional contributor, yes.
What does that mean? There are indications of an additional contributor.
That means that Brandy Peters was a major component, but there were some other little alleles showing up, so I have to say that there's an indication that there's another contributor. However, it was not enough to call it a partial.
Okay, and that was my next question, is that's a different explanation than we've previously heard. Previously, we've heard possible unknown male, possible unknown female, and then we've heard, as it relates to the bone cradle, additional minor contributor. What is the difference between what we previously heard and this as it relates to a possible contributor?
Basically, that means that all of the foreign alleles are between 50 and 100, so I cannot call it a type. That would be those starred alleles again.
Okay, so what we're talking about is there's evidence of something's there, but you can't make any kind of determination at all.
Correct.
And in this particular case, as it relates to 22 and 23, am I correct in saying that you couldn't even make a determination whether it was male or female contribution?
I believe that is correct. Yes.
We're talking about 22 and 23 here. States Exhibit 53 and 54. correct?
Yes, I think on the right-hand side where it says possible mixture for,
It should be up here.
it should be up there, yes.
Yes, okay. All right. All right, so if we can move on to 55, State's Exhibit number 55, 56, 21, 22, 29, 23, 37, 73, 74, and 75. All of those are same, consistent with Brandy Peters being the major donor, or the donor, correct?
Correct.
Okay. And again, we're continuing through 76, through 76, 77, 92, 91, 93, which are all these are swabbings from inside the home as well. All right, those are all consistent once again with Brandy Peters being the donor.
Well, State's Exhibit 76, which was TPD 71, which is a shovel. I actually did 7 different swabbings from that shovel, at different areas of the shovel. 3 of those fit into this category. The other 4 are different.
Okay. What is different about the other 4?
I'll have to talk about them individually.
Okay. So I think I've got them on the chart later on, but we can go ahead and talk to them since you brought it up.
Okay, so area 4, the data is insufficient for inclusion purposes, but results are consistent with originating from a female individual. Tamaya and Tanaya and Javante are all excluded as contributors to these DNA results, and no determination can be made about the possible contribution of Brandy to these results.
Okay. So you've excluded Tamaya, Tanaya, and Javante, but you could not exclude Brandy as being the possible contributor as the female donor, correct?
Correct. That means that the alleles that were showing up were starred alleles.
Okay. What's next?
Area 5, and this is from the back of the shovel, the shaft of the shovel, demonstrated the presence of at least 2 individuals, and assuming 2 donors, a complete DNA profile for the major and DNA results for the minor could be determined. The major matches Brandy, but the results for the minor contributor are consistent with originating from a male individual. And I have excluded all the other standards that I had as being the contributor to this DNA profile.
Okay. And that DNA profile, or is that based upon, as we previously heard, starred alleles, but you have a XY chromosomes?
There is a Y, yes.
Okay. So we know it's a male, but we don't have anything else for, everything else, all the other alleles will be a star. Is that my understanding of your testimony?
Correct.
Okay. All right. Next spot on the, I think we have 2 more spots to go on the shovel.
I think those are in another report.
Okay. All right. Then we'll get to those shortly.
Okay.
All right. So 103V, 103HH, and 103W were swabs from nail clippings and swabs from Brandy Peters.
And welcome back to the LawNewz Network. We had a bit of a technical issue, but we're trying to get everything coming back up to normal so that we can bring you back up to speed. At this point in time, Joellen Brown is still on the stand. She's still testifying regarding DNA. The last thing that we were able to pretty much hear from Ms. Brown is the fact that she was differentiating, excuse me, between the partial DNA evidence that she had found and the complete DNA evidence that she had found on the scene. Again, one more time, I do want to reiterate that we did find out that James Santos, who initially claimed that he was the one who put out the hit on Brandy Peters, has since decided as a final decision that he if he's called to take the stand, that he will plead the fifth. So I just want to update everybody on that as well. In addition to the fact that we heard some discussion that the state may later be seeking the felony murder doctrine. So we're not sure. This is something that will be discussed between the judge, the prosecution, and the defense when they are going through their jury instructions. So that's something that we will obtain some more information about as well. What we're going to do now is we're going to throw you to a clip with Joelle Brown in the event that any of you may have missed her testimony. I know that for some, it may seem dry, but for others, it's really, really important that we do listen to this testimony because it's telling us about the DNA evidence that was found in the house and some of the DNA evidence that might exclude Henry Segura from the actual incident. So we're going to take you to that clip right now so that you can take a look.
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Have a seat, please, ma'am.
Good morning, ma'am.
Good morning.
Can you please introduce yourself to the jurors?
My name is Joellen Brown, and I have been a senior crime laboratory analyst at the Florida Department of Law Enforcement. Excuse me. I retired in December of 2015.
As a lab analyst at the Florida Department of Law Enforcement, what were your duties?
I worked in the DNA biology section, and items of evidence that were submitted for cases I would examine and look for bodily fluids such as blood, semen, and saliva. And if I found them, I would do DNA typing in order to try to determine who they came from. I also could test for the wearer of items by swabbing off epithelial cells.
Okay. And I assume that you had some sort of specialized training and experience over how to do that?
Yes. I have a master's degree from Ohio State University in pathology, but I also trained at FDLE specifically to do this job for 13 months and have worked there for 19 years until I retired.
Okay. And when you say you train, do you take specialized classes? What kind of classes are we talking about?
Yes, the training involved a lot of readings, a lot of actual written tests, and also working with the evidence and learning how to do all the procedures.
Okay, and have you previously testified as it relates to DNA comparisons and analysis?
Yes, I have.
Approximately how many times?
About 80 times.
Okay, Your Honor, this time I tender the witness.
Any voir dire, Ms. Brown? No, Your Honor. You may proceed.
Now you mentioned you do testing for DNA and as other.
Welcome back to the LawNewz Network, and we're going to throw you back to the Henry Segura matter. We currently have Joellen Brown, who's still on the stand right now, and we're going to take you back to her live testimony right now.
So I swabbed the whole thing, and that does not interfere with the firearms examination.
So you swab it and then send it on to firearms, correct?
Correct.
Okay. All right. And what were your results as it relates to 49, 50, and 71?
I did not get any DNA results on those.
Let's talk about 27, 76, 69, and 46. And one of those would be the swab of the hall light switch and swab of the master bathroom faucet handle.
Which one is which?
76, 69, and 46.
Okay.
What is your results there?
I got no results from those items.
Now, on these two, you're talking about a swab of the hall bath light and the swab of the master bathroom faucet. Fair to say those are pretty common things that somebody would touch or utilize. Is that a fair statement?
Correct.
Okay. But you didn't find any DNA?
Not that I could use, correct.
Okay. We already talked a little bit about this, but why is it that, I mean, something as common as these two things may not have any DNA on them?
Well, for one thing, people shed DNA at different rates. And if it's possible that a person who doesn't shed much DNA was the last person to touch, like the light switch, they may have rubbed off other people's DNA. As
Okay.
long as there was no blood on them, we would be assuming that we were just testing for epithelial cells from touch.
Okay. So is it fair to say that just because there's no DNA present doesn't mean that somebody wasn't there and somebody didn't touch it?
Correct.
Absence of evidence is not evidence of absence, essentially. Is that correct?
I would say that's true.
All right. Exhibit number 17. Which is a swab of blood on the floor in the hallway in front of the bathroom. What was your results there?
Tanai and Tamaya were the major contributors. The minor could not be determined, but I was able to exclude all the samples that I had gotten.
Okay. When you say, and we've heard this a couple of times, and I think we've already covered it, but when you say Tamaya, Tanaya, it's because they're twins. You can't say both of, you're not saying both of them, you just can't tell the difference between the two, correct?
Even if both of them had contributed DNA, the profile would look like one person.
Exhibit number 26, another projectile.
I got limited DNA results for this item, but I was able to exclude all that I had swaps from.
Okay. And then 34, State's Exhibit 34, which is TBD 32, the swab of the phone cord. What were your results there?
Tanai and Tamai were the major contributors. I could not determine the minor component. In other words, any minors were starred alleles again, but I could exclude everyone that I had swaps from.
Okay. And then 76, this is the shovel that we've previously gone over, correct?
That's correct.
All right. What about State's Exhibit number 41, TBD item number 121, cigarette butt and ashtray in the master bedroom?
The major contributor was from Brandy, and there was a partial minor contributor that was consistent with a male.
Okay. And as I understand, I think we already talked about this, you later on got some other DNA. Did you make any findings as it results to an individual by the name of Jeremy Smith, and I believe that would have been in June 9th?
Yes, I got buccal swabs from Jeremy Smith and analyzed them as usual. When I compared his type to the donor from that exhibit, he was included as a minor contributor.
Okay. And the State's Exhibit number, again, you don't know who Jeremy Smith is, you just know that that's something you looked at, correct?
I don't know who he is.
Okay. 61, 63, and 64, what were your results there?
Um, 63, I had DNA results which were foreign to the victims, but I had no determination for Henry Segura.
Okay.
64, Tanai and Tamai were the major, and the minor results were limited again.
Okay.
And 61 was just a mixture of all the victims.
Okay. All right. Go on one more. I think we had 65 still.
Oh, 65?
Yes, 65.
That was the swab of the toilet flush handle. I had limited results, could not make any determinations there.
Okay, again, very common thing in place that people utilize, no determination, no DNA was sufficient for determination purposes, correct?
Correct.
66, this is a swab of suspected blood on the back of the tub wall. What were your results there?
Brandy Peters was the major. and the minor could not be determined.
Okay. Again, star alleles for the minor.
Correct.
And 67, 96, and 47.
67 was a mixture of Brandy and Tanaya Tamaya. 96 was the twins and Javante included, plus an additional contributor. And 47 was Tanaya Tamaya, plus another male, and Javante was excluded.
Okay. And as it relates to 96, possible mixture, were you able to make any kind of determination about male, female, or was there insufficient data to give you those?
It was insufficient.
Okay. And as it relates to 47, did you go back and test that against that buccal swab with Jeremy Smith as well?
You're talking about which one?
I think 47, Stacy did 47, TPD 135.
Yes, I did.
Okay. And your results there?
He was included as a possible donor to the mixture.
Okay. Next, let's talk about, it's actually supposed to be labeled as State's Exhibit 103 HH, which is the sexual assault kit that was taken from Brandy Peters. Did you analyze that?
I did not analyze it for DNA, but I did do an examination for semen.
Okay. And what does that mean?
Well, for a sexual assault kit, that's pretty much what you're looking for, is semen. And I did not find any on the buccal swabs, vaginal swabs, oral swabs, or anal swabs.
Okay. And the reason you look, why would you look for semen versus just doing a DNA analysis?
Well, there will be a lot of DNA from the victim on all these swabs because they were taken from her body. There's no need to do DNA unless we know that there's something foreign there, which would be the semen.
Okay. So essentially you're looking to see if there's, again, a bodily fluid or something that was deposited that may have DNA from somebody else.
Correct.
Okay. And in this particular case, you found no evidence of that, so you didn't do any further analysis.
That's correct.
Okay. Item number 13, 14, 15, 16, 30, 33, 42, 25, and 39. Did you do analysis on those items?
These were all tested for blood, and there was none, so no DNA analysis was done.
Okay. Again, you're looking for some sort of bodily fluid that would have been deposited, and because there was none, you didn't do a front analysis, correct?
Well, let me just look at these. 13, 14, 15, and 16 were swabs that were supposed to be suspected blood. Those were the ones that I did phenolphthalein testing for blood, and there was none.
What is I'm sorry, I missed that.
Phenolphthalein.
Can you spell that for Madam Recorder, please?
PHENOPHTHALEIN.
All right. What is that?
That is a chemical that if blood is present and you drop it on a sample, it will turn pink.
Okay. I assume it reacts to the blood in some way, shape, or form?
Yes, it's reacting to the hemoglobin in the blood.
Okay. And for those that don't know, including me, what is hemoglobin?
Hemoglobin is the substance that makes your blood red. Has iron in it. If you're iron deficient, your hemoglobin is deficient.
All right, so that's 13, 14, 15, and 16. What about 30, 33, 42, 25, and 39?
If they had suspected blood, I tested them for blood and they were negative. There was, number 30 was a silver-colored bracelet from the master bedroom floor. I did not examine that.
Huh?
Which number did you stop with?
I had it in my head now, I forgot. 39 was the last one.
39 were letters from a TV stand in the master bedroom. I did not examine those.
Again, 103BB, 103U, 103Q, Y, Z, GG, YX, excuse me, and Z. Again, not analyzed.
Correct.
B, 103AA, these are all projectiles that came out of Brandy Peters. They were not analyzed, I assume, because they were in her and would have her DNA.
Well, 103AA is from Tamaya.
I'm sorry, Tamaya, yes, ma'am.
Right, I did not analyze those.
Okay. Stacy, 24, 78, 48, 99, and 103CC. Again, no analysis was done.
Correct.
You checked for blood, but possibly, but there was nothing really.
Did you mention 96?
No, but I will now. 96.
Oh, 96 is not in, should not be there because it was examined.
It was.
Yes.
Okay. Then let's take a look at Stacy Exhibit 96 and 133. What was your finding as it relates to that?
There was a mixed DNA profile from the swab of the kitchen phone plug inserted into the wall that demonstrated at least 2 individuals, and the DNA profiles for the major and minor could not be determined. Javante, Tamaya, Tanaya are included as possible contributors. There's indications of an additional contributor to the mixture, but Brandy and the other swabs that I had received are all excluded as contributors to this mixed DNA profile.
Okay. What about 99, 103CC, 103DD, 103EE, 103FF, 87, and 100? It appears, well, first of all, let's talk about 99. Disposable camera on a kitchen counter. Was that analyzed?
No.
Any particular reason behind that?
No.
Okay. 103CC, 103DD, 103EE, and 103FF appear to be clothing and or the wig that Ms. Peters was wearing at the time. Is there a reason why those were not analyzed?
Yes, they were blood soaked and we didn't need to identify her blood on them. If there had been some areas where there was no blood and we could have tested for someone touching the clothes, we would have, but there was not.
Again, we're talking about a situation, I think we already covered this, regarding her blood basically would have drowned out any other DNA.
Correct.
Okay. 87 and 100, we're talking about paperwork and I guess in hair. On 87, we're talking about hair. Was that analyzed?
Which TPD number is it?
TPD 141.
No.
Is there, why would that one not have been analyzed?
I believe the hairs were not analyzed because it was assumed they would be from people in the house.
Okay. So this one wasn't analyzed, it's not from the same thing we talked about earlier where there's no root or anything along those lines, there was just not an analysis done.
I did not, I did not look at it.
All right, and then the last two we have is 100 and 101, miscellaneous paperwork and trash bags. Those were not analyzed?
That's correct.
Okay. If I can, go back to State's Exhibit number 72, which is Tallahassee Police Department number 45. Talk about this. A swab of suspected blood from the lower middle cushion in the living room. Swab of the couch cushion.
Okay.
Did you test that for the presence of blood?
No. Let me refer to my notes, please.
Well, let's talk about the DNA. Did you test this for DNA?
I did test exhibit TPD Exhibit 45 for blood. It was positive.
And whose DNA was that?
Tanai and Tamaya is who it matched.
Move on to your June 9th report, please. And I believe we talked a little bit about this report already where there were multiple swabs from different persons that you used for comparison purposes. But specifically, if I can refer to you, State Exhibit number 32, which is Tallahassee Police Department number 12, a purse that was found on the master bedroom floor. What was your result of the analysis for that?
I took multiple samples from Exhibit 12. I took a sample from the zipper and pull tab area, the handles, and the bottom and sides.
Okay. If you can walk us through that analysis, please.
Well, this is a purse, and I tried to imagine where would people be touching it. Obviously, a woman would be holding the handles. If it had a zipper, she would be pulling on the zipper pull, and then just the outside of the purse in general. If someone, I believe this purse had jumped out on the bed, if someone did that, they might have picked it up by the bottom and shaken the things out. So I tested all three of these areas separately to see what I would get.
Okay. And what were the results of those three areas?
The first area, which was the zipper and the pool tab area. Gave a full profile which matched Brandy Peters.
Okay. What about the other two?
Okay, area 2, which was from the handles, gave a partial DNA profile, which matched Brandy Peters, but there was also the possibility of an additional contributor to the DNA profile. I did not get any results for this additional contributor with the exception of amylogenin, which indicated that that was a male.
Okay. And again, all you can tell us is a male, but there's nothing for inclusion purposes, or even exclusion purposes, a start allele.
There was nothing else but amylogenin.
Okay. And, I'm sorry, did you already cover the third spot?
No.
Okay.
From the sample from the bottom and the sides of the purse demonstrated at least 3 individuals. Brandy, Peters, and Javante Seguro were included as possible contributors. And there are indications of an additional contributor to the DNA profile, but they were limited results and the data was insufficient for inclusion, so that they were starred alleles again. However, I was able to exclude all the other swabs from standards of the people that I had received, including Tamaya and Tanaya were excluded.
All right. And I believe you did a report on July 15th, and that was the one where you went back and compared Ms. Mary Richard, there's nothing there, and Ms. Mary Richard Williams as well as Yashondra Williams, and we previously talked about that, correct?
Yes, that was the report in which I had received buccal swab from 7 different people. Were you talking about the July 15th report?
Yes, ma'am.
Okay.
I think you switched back on what we're showing up there, Mr. Pugh.
Yes, sir. There's no actual diagram that goes with the July 15th report because it was just additional. My understanding is essentially it was additional buccal swab that you went back and compared previous items with, correct?
Correct.
Essentially, as I understand your analysis, Ms. Brown, is essentially inconclusive. You had a lot of possible mixtures and things along those lines. You can relate, am I correct in that?
I don't think I would use the word inconclusive.
Okay, how would you describe it?
I would use inconclusive if I couldn't make any kind of conclusions at all.
Okay.
I made a lot of different conclusions, including, Brandy Peters type at various areas in the house, and also the children. And then there were some foreign DNA types. There were some partial DNA types. I was able to make a conclusion that I believe it was Jeremy Smith was included on a cigarette butt in the bedroom. And then there were some very minor foreign donors. So there were foreign donors there.
Fair enough. As it relates to those foreign donors, they were, I guess, the start alleles you previously talked about. So they're not for purposes that you can go back and later do inclusion when statistical comparisons, correct?
No, that's not true of all of them. That's true of a lot of them. But there are some that could be, conclusions could be made. Inclusion statistics could be done.
Okay. Again, we've also talked about DNA, and in fact, you can't tell when it's there and when it was deposited, correct?
Correct.
Okay. and that and I think we kind of covered this about the DNA as far as to telling when it can be deposited. I know we already talked extensively about the blood can possibly wash out, especially with Brandy Peters and her injuries. What factors are there as it relates to what would cause DNA to degrade or remain for extended period of times? What kind of factors are we talking about?
Well, as I said before, if a sample is outside in the heat can degrade DNA. If it's gotten dirty, dirt can degrade DNA. Chemicals can degrade DNA. That's why if there's a blood stain somewhere you want to get out, you might use bleach, and bleach will definitely degrade DNA. But other conditions might be favorable to preserving DNA. For instance, cooling in a refrigerator or a freezer can preserve DNA.
Air-conditioned house, better than outside, would be fair to say, then, right?
I would say in an air-conditioned house, DNA would be pretty well preserved.
One more, Aaron.
Ross?
One more, Aaron.
I'm sorry.
No other question.
Ross?
Yes, sir. Actually, may we approach your Honor?
Okay, let's go sidebar, please.
Welcome back to LawNewz Network, ladies and gentlemen. It looks as though this sidebar is something to do with the DNA evidence and whether or not the specific evidence that she's referencing is going to be admissible. Now remember, there's been a lot of controversy about the DNA evidence in this case. There was some portion of that evidence that tested positive as a match to someone named Angel Avilia Quinones, who is allegedly connected to the drug trade. That evidence has been hotly contested by the lawyers in this case as to whether or not the jury would hear about it. My understanding of the ruling on that was the jury will hear that there was evidence that tested that it was a positive match to a foreign male DNA, but it's not clear to me whether the jury will hear the evidence that of exactly whom it tested positive as a match to. I know that some of you in the chat rooms have been discussing this aspect of the case and whether or not this particular fact will be admissible. Cross-examination of this witness will be very interesting, not necessarily that the defense attorneys will go after her as much as they will go after the way the prosecutor has approached the case. She is standing, which makes me think that perhaps they're going to start back up in a moment or two. But in the meantime, remember that the DNA evidence in this case does not create a clear line to the defendant, and in fact is in many ways helpful to the defense. The prosecution, still obviously, I'm going to bring you back because the judge is speaking.
All right, let the record reflect jury's out of the courtroom. Why don't we take a proffer of what it is you want to ask, Mr. Prince?
Yes, sir. Ms. Brown, at some point during the course of the analysis, as it relates to TPD Exhibit 24, FDLE Exhibit 33, the swab of the phone cradle, which you recall we've previously discussed at evidentiary hearings, you at some point during the course of that analysis developed an investigative lead, correct?
Yes.
And based on the development of that investigative lead, The normal process would have been for you to request buckle standards for the particular individual who you believe there was an investigative lead for, correct?
Yes,
To do a match report for the agency who submitted the evidentiary exhibit to you for analysis.
correct.
And of course, also you would notify the state attorney during the course of the pending litigation, correct?
Yes,
In this case, however, after developing that investigative lead, you were prevented from first requesting the standards, correct?
correct.
You were also prevented from notifying the submitting agency and the state attorney, violation not on your part, but was a violation of FDLE policy requiring disclosure of those types of investigative leads, correct?
Yes.
No further questions.
Want to cross on the subject?
Eventually you did tell.
Yes.
State Attorney's Office.
Yes.
And eventually, I don't know whether you were still there or not, but eventually did get the DNA for that particular individual. Do you know anything about that?
No.
Okay. The information that this investigative lead, we're talking about the CODIS system, correct?
Yes.
Okay. So you upload stuff onto CODIS, and any kind of return that comes back is based upon what they're telling you, what CODIS tells you.
Correct.
Okay, they give you a report and a letter.
Well, it's a little more complicated than that. I see the matches that come back. I look through them. If they're a very strong match, I contact the agency that has that sample and ask them for a confirmation. Then they send me a letter of confirmation. If it is not a good profile, sometimes there's more than one return, and I have to go through and decide which ones are a good match, or if there's more than one good match, and ask those agencies for confirmation. And then I get a confirmation letter.
And when you say you get the information back from that agency, they submit you the DNA profile of that CODIS hit, correct?
No, they
Or the
just
allele
say
numbers?
that they have confirmed the match, and then they give me the name. At the time that the match occurs, I don't know the name.
Okay. So how is it you go back and look at and verify whether it's a good match or not? I don't understand.
The match report that I got from CODIS would show my sample and the sample that it matched to. And then I can look in my file and see if that person, if it's a person that it matches to, it could also be a sample. If there are any indications in my profile that I was not able to upload to CODIS, for instance, that would indicate that that person was definitely included, or there might be an area where they had alleles that were not included in a mixture. Usually this is a mixture that we're talking about.
All right. And so in this particular case, you got the match back, the alleles that are in that match, correct?
Correct.
And you have no way of verifying where those alleles in that match came from.
I'm not sure I understand.
You don't know where it came from. You weren't part of the agency that originally collected it and submitted it into the computer and all that stuff, correct?
Well, the information that I have is that this was from a convicted offender, and then it tells me the agency. In this case, it was the FBI.
Okay. Again, you weren't part of that analysis, correct?
I did not type that person, no.
Okay. And you have no way of verifying that analysis and that name and everything is the person that's in question, correct?
That is up to the agency that put in the sample in the first place, which would have been the FBI.
All right. Thank you.
Any further on that, Mr. Prince?
No, just argument, Your Honor.
Let's be clear for the record. You used a TPD number and FDLE number. What I want is the court exhibit number. Is this 35? Is that what we're talking about? State's Exhibit 35?
One moment, I'll make sure that we get it right.
I forget what numbers you used, Mr. Prince.
It is State Exhibit 35.
Did you say FDLE 24 and TPD 33? Is that what you said?
Yes, sir.
Yes, sir. FDLE 24, TPD 33.
All right, so State's Exhibit 35 is
Correct.
what we're talking about.
Yes.
Ms. Brown. All right. All right. So, Mr. Prince, why is that relevant?
Well, for a number of reasons. There there was additional DNA analysis done by other investigators, other analysts who disagreed with Analyst Brown's findings to the extent that they're going to testify, and I don't know for certain whether the state intends to call them. I guess the easiest way for me to say this is that it's part of the overall narrative that the defense intends to present, which is that law enforcement had a particular perspective on the direction of this investigation. The fact that in violation of FDLE policy, a senior analyst was prevented from reporting a match, which would have been compliant with FDLE policy, doing a match report, which would have been compliant with FDLE policy, and requesting buckle standards, which would have been in compliance with FDLE policy, is relevant to the jury's analysis of the investigation as a whole.
Let me clarify something with the witness. Did anyone outside of FDLE have any involvement in this process of disagreeing with your proceeding forward?
No.
That was internal of FDLE? Yes. She's trying to get...
Oh, yes.
I see you nodding your head. Okay. Right. So it's internal to FDLE. So how do we put that on state attorney's office or Tallahassee Police Department to the extent that's what you're suggesting?
I'm not suggesting that we put it on the state attorney's office or the Tallahassee Police Department in particular. I think it just shows the overall tone of the investigation, and perhaps more important than showing the overall tone of the investigation, I think it would aid the jury in understanding how it was that when we have DNA which matches another individual involved in this narrative, the defense narrative of the case, how it was that that person was not earlier identified as a suspect and investigated. That's something that I imagine if that testimony is before them, they'll want to know is how is it that this person was not investigated earlier, and that goes to explaining why that person was not investigated earlier, because the DNA match was buried.
It doesn't, because Tallahassee Police Department had no knowledge of this analysis for whatever reason, and had they done so, and in fact when they were became aware, it was gone and gotten, and he was in fact investigated. So it's going to confuse the issue there, and doesn't do exactly what it is Mr. Prince is trying to put it forth to do. And in fact, it's the exact opposite as it relates to that. Again, this is all, everything about this match calls for hearsay, and there's no authenticational aspects. That's why the CODIS hits aren't allowed in a courtroom proceeding. In this particular case, just to call it an investigative lead instead of a CODIS hit doesn't change the nature of it. All we're doing is doing semantics and changing the name. So instead of calling it CODIS, we're calling it an investigative lead. It's still a CODIS hit, and there's a reason long-standing as to why they're not admissible in the court. In addition to that, once again, this is all, as the court pointed out, it's an internal thing. It wasn't as if this was told to Tallahassee Police Department and they buried it, as Mr. Prince is trying to put forth. That's just not the situation, and it would create a falsity in the juror's mind.
Further, Mr. Prince?
Just very briefly, Your Honor, I don't want to belabor the point. We're not trying to introduce it for hearsay purposes. We're not trying to use it to corroborate our own DNA analyst comparison of the match. That's why I'm not asking to be able to say that statistics were done or that the CODIS system said that the suspect was Antonio Angel Avila. It's just that I want to be able to show why, in particular, a suspect identified as an investigative lead was not investigated during the time when Mr. Segura was being identified. Why Mr. Segura was identified as the primary suspect during the early stages of the case. It's because the Tallahassee Police Department did not receive evidence relevant to their investigation because of an FDLE breach of protocol.
I must sustain the objection. It seems to me has very slight probative value and is going to cause a great deal of confusion. Basically, what will then get off on a rabbit trail of what is FDLE's internal policies and why do they have those policies, and are the policies right or wrong, which has nothing to do with what we need to determine in the trial. It also puts us into what is CODIS, and I've already ruled that CODIS has not been shown to be scientifically reliable, so it's not admissible, but it's going to throw that into the mix. Ultimately, the actual examinations that were done can be presented to the jury. I have not prohibited that, and I think the defense has testimony that they're going to present on that issue, and we're going to go directly to the analysis without the confusion mixed in. I would have a different posture if somehow or other the police department or the state attorney's office had some involvement in making this determination, but from the testimony presented, that is not the case. So I'm going to sustain the objection. Are you going to have other cross of Ms. Brown?
Yes, sir.
All right, let's have a jury back, please.
Before we bring them back, can we change that so that I can show her the...
You want the display of that?
Yes, sir. Yep.
I see you want to meet with the attorney.
I didn't know you'd undone it. I thought it was just a matter of
confused.
Your Honor, just for the record, co-counsel is asking to make the following comment.
Everybody be seated. You may proceed, Ms. Prince.
Thank you, Your Honor. Analyst Brown, I want to clarify a few things about what your role was at FDLE. You said you had testified as an expert in approximately 80 cases or so as of the time of your involvement in this case, correct?
Correct.
But testifying in court is only part of your job. You develop evidence on thousands and thousands and thousands of probably uncountable evidentiary exhibits. Is that right?
Yes.
And the state of Florida routinely throughout your long career relied on your expertise and testimony in building their own cases and convicting people charged with criminal offenses, correct?
Yes.
And I think that was made clear as well, but you were employed full-time. It's not like you were an independent contractor by the Florida Department of Law Enforcement.
Yes.
Okay. I want to ask you a few general questions about interpretation of data. Can you tell the jury first what a kit is?
A kit is just a box of chemicals produced by some company that enables us to do the DNA analysis. So for instance, in this case, I used two kits. They were called Profiler and Cofiler. And we use those together. Together, those two kits give us the 13 loci. In 2012, which was after this case, FDLE changed to a different kit called Identifiler, which gave 15 loci. So it's just basically the chemicals that you need to do the DNA analysis.
And in order to interpret DNA results using those kits, interpretive guidelines are developed by the Florida Department of Law Enforcement for use specifically with those kits, correct?
Yes, we go through a process of validation using the kits to determine what are the limits. Like, for instance, I was mentioning the starred alleles. At that point in time, between 50 and 100 were considered not reliable in terms of is that a homozygote or a heterozygote allele, and how high we can go for the RFUs and how low we can go. And below 50 we know is not reliable because there's electronic data that gives little blips that are not peaks. So validation is done and interpretation guidelines are formed.
And validation is not something that's imparted kind of willy-nilly. It's an extensive testing process to make sure the interpretive guidelines for that kit work best with that kit, correct?
Yes, that's correct. It takes months to do a validation.
And likewise, you can't just mix and match interpretive guidelines with different kits. You mentioned, for example, the Identifiler Plus and Minifiler kits. You can't just take the co-filer and profiler interpretive guidelines and use those guidelines to interpret data from some other kit's results, right?
That's correct. Each kit has to be validated by itself, and the interpretation guidelines are specific for those kits.
And the reason for that is that it wouldn't be scientifically reliable to use interpretive guidelines not validated for use with a particular kit, correct?
That's correct.
Another general topic I want to ask you about is blind testing. Explain what that is and why that's important for the objectivity and reliability of a DNA analyst's findings.
I'm not sure what you mean by blind testing, actually.
Well, I'm probably using the wrong term because I'm not a scientist, but not being told a story about the case, not communicating directly with the investigator about his ideas or notions on who a suspect is. Why is that important to a DNA analyst's findings?
Well, a DNA analyst has to be impartial because we can't look for someone's DNA. So I guess maybe that's what you mean. In fact, when we do the testing, if at all possible, we test all the items of evidence before we test the standards of the people, and we interpret whatever kind of results we get on the evidence, and then later we compare to the standards to see if they fit into that particular interpretation of a mixture, for instance.
And that's what you did in this case, right? You started developing all of the profiles from the evidentiary exhibits before you did any comparison to standards that you would develop for known individuals.
Well, with my first report, by that time I had done the standards for the victims of the crime, and I think 2 other individuals, Mr. Segura and Mr. Anthony. I did have those, but you don't compare those to your evidentiary samples until you're finally that particular sample.
And as you mentioned before, that's to prevent contamination of your own interpretive process, right?
Right.
Okay. One more additional point I wanted to clarify in general. There was some discussion of sexual assault kits, and you also mentioned when talking about blood covering touch DNA, would the DNA you would expect to extract from vaginal fluid or a vaginal swab, for example, have the same sort of overwhelming effect on touch DNA potentially present in the same swab? Is that question clear?
Yes, that is true, because when you do swabs from a victim, whether they're vaginal swabs or whatever kind of swabs, you're getting a lot of DNA from that victim. And if you were looking to see just who might have touched that victim at that spot, it's most likely that you would get a lot of DNA from the victim and maybe none from the person who touched because of the overwhelming amount of DNA from the victim.
Thank you. I want to talk a little bit too about the phrase exclusion and what that means. We heard Mr. Fuchs say, whereas the absence of evidence is not evidence of absence, evidence of exclusion is in fact evidence of that person's DNA, correct? Being gone, not being a part of the mixture, I mean.
It would be evidence that the person's DNA is not part of a mixture, correct?
And so that's not simply saying that their DNA is absent. It's saying there is DNA to compare it to, and that person is scientifically eliminated as a possible contributor to that particular mixture if they're excluded.
That's correct.
Okay. I'm sorry that I can't refer to the state's exhibit numbers, but I want to ask you about a couple particular exhibits that you analyzed, and I'll use the TPD and FDLE number, and ask you specifically about Mr. Segura's exclusion from those.
So we need to use the exhibits according to the Branson, and we can use both, but we need at least according to this.
I'll try to pause them after each question, Your Honor, to get on the same page about which state exhibit number it is. The first that I want to ask you about is, let me see here. FDLE exhibit number 3, TPD exhibit number 48. This is a scraping from Brandy Peters' right middle fingernail. Do you have the report there where you analyzed that?
Yes.
And that was found to be foreign female DNA, correct?
State exhibit is that?
FDLE 3 is 103C.
Okay. State exhibit 103C. Repeat your question, Mr. Prince.
Yes, sir. Analyst Brown, you were able to identify foreign female DNA at one marker there, is that correct, at D3?
Correct.
And based on the particular genetic numbers present at that marker, you were able to exclude the other known contributors, correct?
Correct.
Okay. With respect to FDLE exhibit number 8, TPD exhibit number 53, scraping of Brandy Peters' left middle fingernail.
Which appears to be 103H.
103H. Likewise, you were able to identify foreign female DNA at 3 separate markers, D3FGA and D8. Is that correct?
Correct.
Excluding other known contributors.
Yes.
Likewise, at FDLE 9, TPD 54, scraping of Brandy Peters' left ring finger under the fingernail.
Which appears to be 103I.
103I, State's Exhibit. Again, you were able to identify foreign female DNA at D3, excluding other known contributors, correct?
Correct.
All right. I want to talk to you a little bit about the swab of the phone cord, not the phone crate yet, but the phone cord, FDLE 23, TPD 32.
23 and 32.
Yes, sir. FDLE 23, TPD 32.
State exhibit 34.
State's Exhibit 34. Again, that's the swab of the end of the phone cord. You were able to identify at least 3 donors to the mixture there, correct?
Yes.
And it might be worth pausing at this point to explain. There are different criteria for saying for certain how many donors there are to a mixture, right?
That's correct.
And so to say that it's a 3-person mixture, what are the guidelines that you use to be able to say that definitively?
Well, in this case, they were a little different than normal. I think I explained before that if you have 3 people in a mixture and each person is getting an allele from their mother and their father, there's potentially up to 6 alleles that can be at a locus if you have 3 people. However, if you're dealing with a mother and her children, the mother and a child, a mixture of 2 people, will have only the maximum number they can have is 3, because the mother and the child will be sharing 1. Then if you have a 3rd person, the mother, the child, and a 3rd person, it's possible there's only going to be 4 alleles in a mixture, because 3 will be from the mother and child, and the 4th one may be from the 3rd person. So even though it might look like a mixture of only 2 people, it could possibly be 3 people if we're talking about a mother and a child.
I guess generally speaking, though, to be able to say that it is a 3-person mixture, there are certain criteria, right?
If it is not, if they're not related people.
And then there would likewise be a separate set of criteria to say that it's a 4-person mixture, right?
Well, basically, it's the minimum number of alleles that you would see.
Okay. The point of me asking you questions, the question I want to get to is, there is some room, some gray area between it being identified definitively as a 3-person donor and a 4-person donor. In other words, you can have 3 clearly identified with evidence of contamination or contribution from some potential 4th donor without it meeting the criteria to say it is a 4-person donor, correct? 4 people have donated to the mixture.
Your Honor, I'm going to object to that question. It seems to be confusing when watching Ms. Brown's reaction to that. So
I think that's up to the witness if she doesn't.
Well, if I understand the question correctly,
Well, let's not guess. If it's unclear to you, just tell us that, please.
Could you repeat the question, please?
Sure. I just want to clarify that while there are certain guidelines for calling, let's make it 2 and 3, for example. While there are guidelines for saying this is a 2-person mixture, and then there are guidelines for saying this is a 3-person mixture, it can be a 2-person mixture that doesn't meet the criteria for identification as a 3-person mixture, but that doesn't necessarily mean that there can't be evidence of contribution by 3 people to what you identify as a 2-donor mixture, correct?
Yes, that's correct, because our language that we use is this is a mixture of at least 2 people. If people share alleles, which many people do, a 3-person mixture could look like a 2-person mixture.
With respect to the evidentiary exhibit that we were just speaking about, FDLE 23, TPD 32, and the court's already read the state exhibit number for that one, you were able to identify at least 3 donors, correct?
I said that the twins, Brandy and Javante, were included in the mixture, yes.
And the twins were the major profile, is that right?
Yes, the major DNA profile matched the DNA from Tamaya and Tanaya.
And to be clear, this is the cord that goes with FDLE exhibit number 24, TPD number 33, which is the phone cradle.
Which is state's exhibit 35.
Yes, it was identified as the swab of the end area of the phone cord, number 13. And I believe
Okay.
the phone cradle was considered number 13.
And then with respect to the exhibit we were talking about, 23, FDLE 23, TPD 32, Henry Segura was specifically excluded as being a possible contributor to that mixture, correct?
That's correct.
Okay, moving on to State's Exhibit 35, which is FDLE 24, TPD 33. You have your findings relative to that exhibit before you there?
Yes, that was the swab of the side of the phone cradle.
All right. May I approach the witness, Your Honor?
You may.
And just for identification, this will be listed as defense composite exhibit 1A and 1B.
Yes.
Do you recognize that?
Yes.
Is that the electropharogram that you developed in testing the DNA from that evidentiary exhibit?
Yes, it is.
Does it appear to be in the same or substantially the same condition as when you obtained the results and made your notes?
Yes.
Your Honor, for efficiency's sake, I would request at this time to move into evidence what's been pre-marked for identification only as defense composite exhibit 1A and 1B into evidence as defense composite exhibit 1A and 1B and request permission to publish to the jury.
Is there objection?
All right, ladies and gentlemen, the cross-examination of the DNA expert continues, and as you may have heard, there was a pretty major motion with a pretty major ruling made regarding the DNA evidence we were talking about a little bit earlier, and that is the evidence tied to Angel Avila Quinones. The long and the short of it is that much of this evidence testimony is actually helpful to the defense. And certainly doesn't seem to create a direct line to Mr. Segura, who you see there on the screen. The defense continues to cross-examine this expert. Many of you have noted, and I think I agree, that the jury may be sort of over it at this point, and this horse may have been beaten dead. But they continue, and it looks like they're continuing now. We will bring you Gaspar live when it is live, so stay tuned with us, and I will bring you there when we have feed from the courtroom.
As discussed at sidebar, I'll admit Defense Exhibit 1A and B.
May I publish to the jury?
Yes, you may. Yeah, I'm a second making that.
Analyst Brown, what is this that we're looking at?
This is the kind of printout we get from the DNA analyzer. It's called an electropherogram, or EGRAM. And this shows you the peaks at the different loci.
And this may be a very simplistic way of describing it, but we've probably at some point seen a cartoon of a DNA character that looks kind of like a ladder. These individual markers right here indicated by boxes, are those like the individual prongs of the ladder?
No, not really.
Okay, you did the explanation now.
It'd help if you slid that up to make it a little higher up. It might be, I mean, not all of it, yeah, just so. Is it focused?
Could it be enlarged a little?
That's what I'm working on.
Oh, there we go.
Better? Yes, thank you. Go. Just explain then as simply as you can, because obviously even after discussing this over and over, I still don't know how to articulate clearly what are these individual markers that we're looking at right there.
Okay, each one of these bars here, there's one that's the D3S1578 marker, or I called them a loci. There are 13 of them. This is one. This is another one. Oops, right there. This one is a large one. It goes all the way there. So there's 3 markers there. Then this is the amylogenin marker. You see there's a big X right there, and there's a smaller Y. So that indicates, notice how small the Y is. That indicates that there's a mixture of female and male DNA. If it was just male DNA, the Y would be about the same size as the X. Then here is another marker, and another marker. So there's 3 markers there. And actually each one of these comes out as a different color. This is blue, this is green, this one is yellow. From the machine, we don't see it in color when it's printed out. Then here are 3 more markers, one here, and one here. And that's a total of 9 markers, but the other markers are on another page from the other kit. This kit here is representing these 9 markers, which is Profiler Plus, is the name of this kit.
Okay, and then I see these peaks or ice cream cones as you described it before at each one of those markers. Are those what you were describing before as the individual genetic numbers at each marker?
Yes.
Okay.
Each one of these areas has multiple numbers of alleles that it could be. Some of them range from 5 to 20, for instance. And you asked me what each one of these loci was in your big long string of DNA, which is millions of base pairs long. We can identify these individual areas on your genome, on your chromosomes. And when this says D3, that means it's on chromosome 3. When this one says D8, it's on chromosome 8. Some of them have odd names like VWA and FGA, but those are on chromosomes as well. And this is just a long strand of DNA, and these particular ones are called STRs, or short tandem repeats. And if this says 15 and 17, what that means is there's 15 repeats of a certain piece of DNA, and these happen to be 4 letters long. Well, they're not letters, they're bases, but we abbreviate the bases as A, C, T, and G. So there might be AATC or AGCT or any kind of combination. So this person from their mother or father got a 15, and from their mother or father got a 17, which combined gives them the type of 1517.
Okay. If this were, or we don't even have to talk in particular about this exhibit, but if you have a perfect 2-donor mixture, you're going to have 4 allele present, even if they're, the same number twice, because they got the same number from both parents. But you're going to have 4 present genetic markers at each one of those locus. Is that correct?
You might not be able to see them as 4. Like, for instance, this is a mixture. If they share alleles, then you will not see 4. In fact, you could possibly only see 1 if the 2 people are homozygous, like 8-8, and both of them are 8-8. You would see only a peak of 8. I mean, there would only be 1 peak, which was 8. So when you say that you need to see 4 alleles from a 2-person mixture, that means out of all the 13, it's likely that you'll get 4 somewhere. But that's not necessarily so. You'd be anywhere from 1 to 4.
Because there could be overlapping numbers, as you've indicated.
They could be sharing alleles,
Sharing.
That's correct.
And there would tend to be, if it's a good sample, meaning that there are good quantities of DNA from both donors, you would, for example, if they were all sharing 1 allele number, you would expect to see that allele be a really high RFU, a really high quantitative number, correct?
Compared to the rest, yes.
Right, okay. In this case, however, we're dealing with a sample that isn't especially high, but high enough still to do interpretation. Is that correct?
This is a touch DNA sample, and so, yes, a lot of the peaks are not very high.
Okay. And just to be clear about what you were saying before, regarding starred allele, using the interpretive guidelines validated for profiler and co-filer, you're allowed to use starred allele to exclude somebody from a mixture, correct?
That's correct.
Okay. You just can't do statistical inclusion unless it's above 100, right?
That's correct.
And that's to make sure that your findings are not being influenced improperly by white noise in the instrument, correct? Or
Correct.
some other contaminant, right?
Correct.
Okay. I'm going to ask you about a couple of those things, those general topics that the jury might need to know about to understand why you interpreted the electropharogram in this manner. Tell us what white noise is, for example.
If you go down below 50 RFUs, since this is electronic data, you will see little bumpy peaks below 50. And during the validation process, it's determined how low you can go, basically, and not have any interference from those white noise peaks. So in this case, 50 was the cutoff point.
Another topic that probably needs explanation is drop-off or dropout. What does that mean, and how does it occur with a sample like this?
When you have very low levels of DNA, sometimes you will not be able to see a second peak. I can't see a very good example of it up there. But for instance, a person could be a 10-12, could be their type. If it's very, very low, like between 50 and 100, you might see the 10 and not the 12, because there's just wasn't enough of the 12 to be amplified and show up on this type of electropharogram.
Okay, and then the last thing before we get into your findings here that I want to ask about is, what happens to the DNA quantity as we're going from the left side of the electrophorograms that we're looking here to the right side?
Well, you can see it kind of decreases. The X is very tall, then this is smaller. These are about the same size, and then out here, you can hardly see them at all. They're very small, only 138, 79, and is that 184. That just is because of the fact that out here, these alleles are larger alleles, actually, in terms of how long they are. And when DNA degrades, as all DNA will degrade a little bit, the bigger pieces degrade faster than the smaller pieces.
And that will result sometimes in, for example, I see down at the bottom there, D7 on the bottom right.
I think it's obscured for me anyway by the evidence.
Slide the sheet up a little higher.
Yes, you can see right here for D7, there's nothing showing up right there.
And that's as a result of what you talked about, it being a larger locus where...
That's correct.
Okay. I'd like to ask you specifically about the findings at the different locus here now, starting in the top left with this D3. Can you show the jury what you were looking at, how that was relevant to your interpretive process, and what your ultimate findings were with respect to each locus?
When I first looked at the mixture, it appeared that there were no more than 4 alleles at all of the loci. Like, for instance, here's an example where there are 4 alleles. Some there are only 2, and there's no example of only 1. But that told me if I was going to see any minor people showing up, they would show up at this area from here to here, because these are the smallest pieces of DNA, so they would tend to be preserved the most. And if there's a minor component dropping out, then we might get out here and see nothing or very little. So when I first looked at this, it looked like it was a 2-person mixture. Obviously, you can tell that there are some alleles that are much larger than the small alleles. So that would be who would be a major component. So I therefore wrote on there major 15, 17, minor, inconclusive, because I can't tell. It doesn't look like there are any minor alleles. A minor allele could be a 15, a 17. It could have dropped out, but I would expect it to be there. Here, again, it looks like a 2-person mixture, because it looks like 15, 18, I think that is major, and these 2 smaller ones would be minor. And out here at FGA, again, there's 2 pretty large ones, even though this one is kind of small compared to that one, but you would expect that in a touch DNA sample when you're talking about the larger loci. And then there's teeny tiny ones, 21, which is only 50 RFUs, and 25, which is only 60 RFUs. So that I considered to be the minor component.
Okay. So at FGA then, we would have a genotype for the minor contributor, a clear identifiable genotype. Is that right?
It would be 21, 25. However, they are starred alleles.
So we would be able to exclude a known sample against that, but we couldn't do statistical inclusion on those.
We could not do inclusion, but we could exclude, correct.
Okay. Going back to VWA, the middle marker on the top row there for a minute, is that the one where ultimately you judged the 14 to be a stutter and not an allele, evidence perhaps of potential contribution by a third donor, such as one of the twins?
Well, let me explain what stutter is. In front of each of these big alleles, there will be a small peak that is exactly 1 repeat smaller. And that is a known effect. We know that that's there. Let's see. I'm not sure I can find you a good example of that. These are bigger than stutter because the machine that analyzes these is set to cut out stutter. it's about 11% of this large peak will be the stutter peak. And that one, 134, is more than 11% of 624. So therefore, if there is some stutter there, there's also some contribution by another person's DNA.
And so on a peak like that, an effect like stutter can stack on top of DNA that is really there, but perhaps below usable limits to make what looks like an identifiable allele. Is that right?
That's correct.
And in this case, based on its positioning, you decided not to call 14 an allele, right?
Well, I decided that's not exactly true. When I looked at the entire, you have to look at the big picture. When I looked at the entire picture of the profile, I saw that down here, there was a 7 allele. There's a large 11, it looks like an 11-11 homozygote, and then it looks like a 7 and a 12. However, it turns out that the girls, Tanaya and Tamaya, have a 7 allele. And it turns out it's a rather rare allele. There's different percentages for each population or each ethnicity, and for African Americans, which they are, it's less than 1% of people have a 7 allele. So I thought that was probably indicative of the fact that since this is touch DNA from a telephone that children would probably be touching in their mother's bedroom, that it's possible that at a very, very low level, these girls were included.
So I guess I said that wrong. We know that the girls are excluded from being the minor contributor to this mixture, right?
I could not say that they were included because everything that might have been from them was a star allele. So therefore, I cannot say they are included.
Right. But you were able to say that, I know that there's, as we talked about before, room between it being a 2-person mixture and being a 3-person mixture, as clearly identified, that there can be a 2-person mixture with evidence of contribution by a third. You were able to exclude the girls, the twins, from being the minor contributor, but you did find evidence of their contribution to this mixture, correct?
Well,
Welcome back to LawNewz Network. I'm Heather Hansen, and we are going to take you over to the Gaspar courtroom. We know that closings are going to start today. May hear some motions first, so we're going to take you straight there.
Okay, Mr. Sen, you've now had a chance to look at the exhibit list that was previously provided to your co-counsel. Do you have any objection to the exhibits marked 16 through 1573 that are on the list before you?
No, sir.
Those will be admitted without objection.
Your Honor, just for clarity of the record, Mr. Sin did, back when we handled this, object to Exhibit 1526. I do have that written in as not admitted, so we would be obviously not.
Thank you.
That is welcome.
So the exhibits are admitted except for Exhibit 1526, the recording of the defendant from Fairview Hospital and Legal.
Thank you.
You know, I get 1525. USB drive, 2 CDs of audio analysis from OOIC. Is that being offered?
It wasn't testified to, so, I mean, if you want to remove it,
Yeah.
I don't have an issue.
I want to remove it then.
Yes, Your Honor.
So not 1525 or 1526. Mr. Sen, when you left on Friday, you were contemplating whether you would have additional witnesses, and you were going to discuss that with your co-counsel and with your client. Is that correct?
It was, Your Honor.
Have you reached a decision?
Sir, I have reached a decision. As I put on the record, Friday, with respect to Dr. Bellato, I had some strategic reasons I chose not to call him, and we've already covered that. The only remaining witness that would I would potentially consider calling would be my client, Joshua Gaspar. We've talked about it a good deal. It's been my advice to Mr. Gaspar that based on the state of the evidence as it exists right now, we are in a position where it's not in his best interest to testify. We'd like to rest on the burden of proof, but I would ask you to inquire of my client that that is his decision.
Mr. Gaspar, is that correct? You've talked with your attorney about your right. Okay. Thank you. And I will, of course, instruct the jury that not to consider that for any purpose. Next, the defense is resting.
Correct, Your Honor.
They had one witness. Do you have a rebuttal witness to that one witness, the trooper from Georgia, the former trooper from Georgia, the expert witness?
No, Judge.
Okay.
I would renew, no, strike that.
I'm going to work on some other matters. I had the bailiff contact by text both parties yesterday, and I assume you got that message?
Yes.
Saturday evening, yes.
All right. So that is an issue we'll take up after I've done here with some other matters. Okay.
Your Honor. Thank you, sir.
So that will be the renewal of Defense Rule 29.
Yes, Your Honor. Think about 30 minutes, sir.
Possibly.
So we should consider this, we're still in session for the morning, we're not at lunch yet, right?
No. I might send the jury to lunch, but you're not at lunch yet.
Right. Just making sure.
Are you guys going to be on the floor? Is that what you want to do? Okay, then stay on the floor, stay near
Okay. See you soon.
I will let you go. I appreciate that.
Sure, welcome.
Rita, you have the email?
Yes.
Okay, let's start there.
All right, ladies and gentlemen, just as fast as we went to Gaspar, they decided to take a 30-minute break. So we're going to take you back to the DNA evidence in the Segura case, and we'll be back with our guest, Matthew Adam Gray, to discuss both cases as soon as there's a break. So for right now, back to the Segura case.
And the types of the victims at D8 are 11:15 for Brandy, 11:12 for the girls, and 12:15 for Javante. And although the 12 is also found in the children, it also could possibly be from that male third donor. And so, again, there are 4 alleles here, and if this was just a mother and her child, there would only be 3.
Right. And part of the reason with respect to D8, for example, that you're able or willing to identify the 12 as potentially being foreign is because of the proportional values of the DNA present at that marker. Would that be correct? Is that one of the factors that you look at to say, yeah, that's probably foreign and not some evidence of contribution in low levels from the girls or Javante?
Well, I wouldn't at this point, no.
What is it that allows you to say that 12 is probably foreign then?
It could be from the children. I don't know that.
Again, then you're just doing it in the most inclusive method possible to try and sweep in as many people as possible.
If I could do statistics on this locus, and I would include all of those alleles, 11, 12, and 15, in doing the statistics.
Okay.
How about for D21 then?
Okay, D21 is 2528, and it turns out that all 4 of the victims are 2528. So I can't differentiate whether the children are there or not. And there is nothing that's showing up here that's foreign.
Okay. How about for D18? Any evidence of foreign contribution there?
Brandy is 1719, the girls are 1718, and Javante is 1919. So the major is 1719. Again, this 18 is possibly from the girls. But I can't do statistics on this locus anyway because it is a starred allele at 18.
You would only be able to use that for exclusion purposes.
Correct.
Okay. What about down at, is it D5 on the bottom left there?
Yes. At D5, Brandy,
Yes, sir.
Brandy's type at D5 is 1111, and so it corresponds with the major. The girls are 711, and that was the clue that I thought probably indicated that they were there. And Javante is 1215. And there's no 15 showing up, but there is a 12 showing up. I really think that Javante is not in this mixture. So therefore, this 12 is foreign to the girls and Brandy.
Okay. And then how about at D13? Is there evidence of potential foreign donor there?
No, because Brandy is 1111. The girls are 1112, and so is Javante. So this might be from the foreign person, but I don't know. And I cannot use it for statistics. Or I can use it for statistics. Yeah, that's one.
You would be able to use that one because it's a 123?
Yes,
okay.
I could use that one for statistics.
Okay, so that one could be from either the girls or a potential foreign donor.
Correct.
And if you had a sample to compare it against, you would be able to do inclusion statistics for the profile of the
correct
known foreign donor at that point. Okay.
If a person had 1111, 1212, or 1112, they would be included there.
Okay. I'm going to show you now the second part of the defense. The co-filer part of the results you obtained for this evidentiary exhibit, is that right?
Yes. I should say that there are 2 loci between profiler, this is co-filer. Between profiler plus and co-filer, there's D3 is found in both of them, and D7 is found in both of them. Those redundant loci kind of is a check to see, to make sure that you put the same DNA in both of those reactions, because they're separate reactions. And for this D3, we get exactly the same thing that we got from the profiler plus, which is a good thing. It's 1517. So anyone included in there has to be 1517, 1515, or 1717. It turns out that the Brandy and the girls are 1517, and Javante is 1717. So that, and whoever is the foreign contributor has to be one of those 3 types, 1515, 1717, or 1517, because I would not expect the foreign donor to have dropped out over here on this side.
Okay. And how about for D18? Or is that
D16?
Sorry.
Okay. The major component is 913, and that is Brandy's type. The girls are 1313, and Javante's 1113. But I don't think that he is in this mixture, so therefore the 11 is foreign. So what we would say is it's 11 plus. What that means is the foreign person has an 11, and what is their second allele? We don't know, because this one is so low that its other allele could have dropped out. And there is a way to do statistics. If I could have used this, I could have done statistics, but since that's a star, I cannot.
Okay. Same result on amylogenin down in the next row is with profiler?
Yes, it is given the same.
Okay. THO, that's one that we didn't look at on profiler, right?
Right, this one is only in co-filer. Here, the major seems to be 7-7, and that corresponds to Brandy's type. The girls are 7-8, and also Javante is 7-8. So 9 is definitely foreign to them. I wasn't sure if this 8 is represented by the girls or the foreign type. So therefore, I would call the 8-9 both foreign. However, I cannot do statistics on this one either because the 9 is a star.
Okay. What's the next one? Is it TPOX?
Yes, TPOX. The major component is 8-10, and Brandy is type is 8-10. The minor is 9, and the girl's type is 8-8. Javante is 8-9, but I don't think that he's there. So I would say that the 9 is foreign.
Okay. And
then it's CSF. Like, they're getting pretty small now, but still 11-14 are major, and that is Brandy's type. The girls are 11-11, and Javante is also 11-11. And so the minor is inconclusive. I didn't see anything that was foreign to them, so I would not call a minor.
Okay.
That's also way over here on the right-hand side where it may have dropped out.
I understand. And were you able to make any findings with respect to D7 at the bottom?
Yes, if you could move it up, please.
Yes, that's fine.
Okay, the major peaks here are 11 and 12, and that corresponds to Brandy's type. There's a 10, and the girls are 10 and 12, and Javante's 10 and 12. So it's really inconclusive there. The minor, the 10 might be from the minor donor, or it could be from the girls. I couldn't say, but I can't use these for statistics anyway, since the 8, or the 10 rather, is a star.
Okay. I guess the takeaway question from that I would have, just to clarify and summarize, is first, there is evidence of contribution by more than 2 people, in your opinion.
Yes, considering that the mother and child probably contributed to the mixture.
And if you were to do inclusion comparison, or comparison for purposes of inclusion, statistical inclusion in the mixture, you would have looked at all of the numbers, correct? All of the allele numbers present in the mixture.
For making a judgment as to whether a person is included, I would, but for statistics, there were only 2 areas that I could use for statistics.
Okay. And the fact that there are, because we have at least 3 people contributing to the mixture here, the fact that allele numbers are present that don't match a particular person doesn't necessarily exclude them from the mixture, correct? Does that make sense?
Could you ask that again?
Yes, because this is kind of a messy mixture where it looks like the girls are probably contributing as well, but it also looks like there's a foreign contributor. With the fact that numbers are present that don't match a known foreign sample, if you were doing a comparison, necessarily exclude that foreign donor?
If their alleles had dropped out, no.
Okay. And there was evidence of dropout in looking at this sample, right?
The foreign donor, which was evident at VWA, is very low. So yes, I would think that their alleles may have dropped out.
Okay. All right. I want to move on and ask you briefly about some other items.
Much longer, Brent?
We could take a break. I don't know exactly.
Let's go ahead and take a lunch break. Let's don't discuss the case among yourselves. Anyone else? Be back ready to go 1:15. Stay in session for just a moment. conversation at sidebar, Barbara, we're redacting the bottom part of Defense Exhibit 1A. Mr. Prince, once you get with her and make sure that's done, so just put that part in evidence. It'll just take the bottom part off. All right? Either side, anything further? No. Mr. Prince, you were trying to say something earlier, just as the jury came in. Mr. Cummings was wanting you to do something. I don't know.
Yes, sir. He was wanting me to preserve for the record regarding the objection that we made, or I guess it was the state's objection, but regarding the argument we made at sidebar about being allowed to get into the fact that she was prevented from notifying the submitting agency. Mr. Cummings wanted to make the point that the state had to some extent opened the door by asking a question which required a response relative to CODIS during the direct examination, and that we should have, based on that, been able to go into that.
I don't believe that's the case. So anyway, there was one very brief mention. They quickly moved away from that. I don't think the door's been open. Anything else? No, Your Honor. All right. See y'all at 1:15. Somebody was going to make me copies of the emails and the letters that we discussed Friday. You going to do that, Mr. Prince?
I will. Do you want those prior to the Wednesday hearing, Your Honor?
I'd like to get.
Welcome back to LawNewz Network. I'm Heather Hansen, and I am here with a former prosecutor, current trial attorney, Matthew Adam Gray. Welcome, Matthew.
Thank you. Thanks so much for having me.
There's so much to talk about here, and let's start with the Segura case because there's so many legal issues here that the lawyers have been fighting about.
Absolutely.
Let's start with the DNA evidence that we've heard such very exciting evidence that we've heard so much this morning.
Yes.
Tell us a little bit about what you thought of the approach of the defense attorney in cross-examining her about this DNA evidence.
I mean, I think right out of the gate, he could have just said, let's establish right out. There was no evidence whatsoever, physical DNA linking my client to the scene of this crime, yes or no. Just start with that. And then go into the mind-numbing necessity that he needed to do, probably in order to establish later on for his expert to speak to the DNA. But the jury, I mean, at this point is probably falling asleep.
Well, I want to kind of unpack some of that because I agree with you. If you start with that point and then kind of throw it in there every once in a while to reiterate it, it could be helpful if you've got a jury falling asleep. But you mentioned that it's necessary for his expert. Tell us why.
Sure. I mean, I think that because the judge ruled that the CODIS hit was not admissible because it's hearsay, but then kind of alluded to later on he was going to allow his own expert to address that. I believe it was the Quinones hit, the Avia Quinones of this person that is surprisingly linked to this Mexican drug cartel, and the woman that's been murdered also happens to be a drug runner. So I think later on he's really going to give them a lot of leeway to explore that on their own case. So there's probably pieces of that DNA evidence that at this point is mind-numbing and boring, but maybe essential him for a link later on to get in front of the jury.
And I think you're right about that, Matthew, because they're talking about, just now they were talking about, is this part of the argument for Wednesday? So the plan right now, as far as we know it, is the prosecution expects to rest right around Wednesday. And then there's going to be a host of arguments on, one of the things will be exactly what you just brought up. How much can they get into? And when you reference the CODIS, that's that database of DNA evidence that thus far has been precluded to be specifically spoken about. But the judge has sort of said that maybe in the defense case, they will be able to make that connection to this Avila Quinones, who was apparently a major drug cartel participant.
Unbelievable.
So that's going to be really interesting argument and evidence if it gets in. The other argument that's supposed to be had on Wednesday has to do with this apparent confessor who made a confession to the crime and now has said today that he plans to plead the Fifth.
Correct.
Now, we talk about hearsay a lot here on Law News, but if he decides to plead the Fifth, if Santos, who's the person who had confessed to this crime, plans to plead the Fifth, is there a way for the defense attorneys to still get in that testimony, do you see, or is it really going to be precluded because he's just not going to say it?
Well, I mean, the judge has kind of taken a look at that already and said that he's going to allow him and some of that testimony to be admissible. I mean, if he's going to get up there and plead the Fifth, there are restrictions on putting a witness on for the sole purpose of impeaching them. But I do think if this is someone who has confessed to a crime for which the defendant who is seated there's life is on the line, I think the judge is going to give them a lot of leeway. At the very least, he'll allow them to impeach. I understand, sir, that you're pleading the Fifth now, but isn't it true that you admitted to murdering the person that this person's on trial for?
Right, and then again, even though we always tell juries the questions aren't evidence, it's only the answers that are evidence, those questions are going to be, if given in, if asked in front of the jury, so they will definitely stick in the jury's minds as it will end up being evidence, even if the judge tells them that it isn't.
I mean, jurors that I speak to, my friends, whenever they're on jury duty, they're like, they hear the close of the state, then they hear the close of the defense. So like, he did it. I mean, they hang on the attorney's words. I mean, they're not supposed to, but really, they do believe a lot of what they come, and a lot of successful trial practice is building credibility with the jury and speaking to them and giving them goosebumps. I mean, some of these, the prosecution's case here is real slow and steady. The defendant stands up, it's like, this is what I'm gonna tell you this. They're paying attention. By the time the prosecution was done, I don't know, maybe they're snoozing, it's time for a cup of coffee, but when the defense got out of there, right out of the gate, he was speaking to them. He spoke about his soul, his heart, like he's really trying to compel them and convince them that his client didn't commit this heinous crime.
Absolutely, and one of the things you pointed out before we came live on air about the openings is that it sort of gave us a tip as to what we might expect in the defense case. What did you say you're expecting?
I mean, based on what he said, I don't know how else he can get all that information from the jury unless his client is willing to testify. And it's a tricky strategy, but I think what they must have been thinking, rather than play games with reasonable doubt and that the burden's on the state and that they haven't placed any physical evidence at the scene, is that you have a jury that's looking at the death of 3 toddlers and a woman who fought so hard that she broke her fingernails and fractured her hand and watched her children murdered in front of her.
Right.
So they're like, we can't have any open questions, so we need to explain to this jury, why is he calling her and lying about it? Why does he have a backup cell phone? Why is he in the area, the cell sites, at or about the time of the murder? And so they're going to put him on the stand to explain. And
he's going to have to fall on the sword, as you said, about the fact that he's a player.
Right, and that's how they're doing it. I mean, they got right out in front of it, and that's sometimes you see that's how they do it. They're like, listen, he's a creep. He doesn't pay child support. He cheats on every woman that he's ever been with, but he's not a murderer.
Right, and he's a creep who knows how to get out of paying child support without having to kill someone.
I like that. Exactly, I agree.
Yeah, I think that it's a very effective way to come at a case like this one, which, as you said, I mean, I know from our viewers that anytime children are involved, it's extremely emotional.
Wrenching. I mean, the facts of this case, one of the children was held by the neck and shot in front of, I mean, she died a slow death. It's one of the most tragic cases I've heard about.
Absolutely, and it looks like it's going to go relatively quickly, even though this morning, as you said, it seems to be sort of mind-numbing.
Real snooze fest, but yes.
One of the things, when you have to do this type of testimony, do you ever turn off the lights? I mean, it is just not a good idea
it's like
to turn off the lights.
Sometimes they really do fall asleep. I mean, you look over and they are snoozing. So it's like some of this evidence you got to move more quickly through. I really do think, I mean, I know that they're doing the case. It's easy to Monday morning quarterback from here, of course. But they got to move it a little bit. I mean, it's taken a long time with this particular witness who, I mean, her intonation, everything about her is a real snooze, huh?
Yeah, it is definitely one of the witnesses that is probably most important, and yet at the same time, difficult to make sure that you move quickly, get the points that you want, and get out of there.
Absolutely.
Now in Gaspar, we're waiting because we're anticipating closings to happen relatively soon.
Right.
But let's talk about what happened very quickly when we went to Gaspar here. Mr. Gaspar stood up, then sat back down, but what he was telling the judge was that he did not intend to testify on his own behalf. What do you think about that decision?
I think it's a good play. I mean, it could only hurt him. At this point, the state's case is a little weak. And so for him to get on the stand and subject himself to an experienced cross from a prosecutor could really probably only hurt him.
I agree. I think that this case, as it has gone in, the idea of him being reckless when he was traveling at most only a few miles above the speed limit is a little bit of a stretch. And then the impairment evidence came through Sergeant Robert Gable, who I think that many people felt as though some of his testimony was a stretch. And we're going to throw to some clips of that in just a minute. But I wanted to talk to you about the methadone aspect of this case, because we see this opioid epidemic across the United States. I feel like every day in the newspapers there's a different article about how are we going to deal with this epidemic and how it's affecting our children and heroin and people in jail. And one of the ways that's proven to help is the use of methadone.
Absolutely.
And yet cases like this sort of put methadone in a bad light. So the idea that in some states you are not automatically impaired as soon as you take methadone sort of lends itself to the type of testimony we needed to hear here, correct?
Correct. I mean, they have, again, like you said, I mean, this is the heartland. It's one of the regions of this country that's been hardest hit by this opioid
epidemic. It's an epidemic.
Thank you,
yeah,
epidemic.
It really
and
is.
it's like they're just trying, you have somebody who took prescribed medication
Right.
given by a doctor. They have the doctors testifying, we gave it to him,
Yep.
and then he gets in his car and he drives. If there was a sheet that he was handed or some type of instruction he was given that said, do not get in your vehicle, then maybe you'd have a case there. But he wasn't on notice. He's taking a doctor's medication. You have jurors in that region that, I mean, they could go either way. They could be tired of this. They could be tired of their tax dollars being spent on ER services and supportive services for people with addiction, or their hearts might go out to him. I mean, you might have people whose children are addicted to drugs who can't take methadone or refuse or unwilling to do that, and so then their hearts might go out to them that way. So it could go either way.
Well, and so many people start with these addictions by taking prescribed pain pills, to your point. And one of the things that you raised again when we were about to mic you up is the fact that the doctor, if you're going to believe that this was beyond negligence, then the doctor should be sitting there next to him.
Absolutely.
And he's not, because, you know, truth be told, this is what's happening in this clinic and clinics across the United States day in and day out. What I want to do now is throw to a clip of the doctor, and we'll listen to a little bit of Dr. Richard DeFranco's testimony, and then Matthew and I will be back to discuss it. So right now I'd like to go to clips 36 and 37 together, and then we'll be back to discuss. We will take you live to the courtroom the minute that it's live.
Methadone management typically is a liquid oral administration of a dose that's drank or drunk.
Yes, in Ohio, according to state law, we use liquid methadone in Ohio. In some other states, they use liquid or tablets. But, so this is a liquid, and if a patient were to drink his dose of methadone, he may have a peak blood concentration about 1 to 2 hours later. Is that the kind of thing you're asking?
Yes.
Okay.
But upon consuming the dose, how quickly does the body begin the graph of absorption where it's going to climb towards that peak? How fast does the ingested methadone begin to be processed by the body?
Well, I think that it begins to be processed immediately. It's going to start to diffuse through the stomach and small intestine into the bloodstream, but that process takes time. So I would say it would, I mean, all I really know is that the peak is around 1 to 2 hours. I'm not sure how fast or how high the slope is. I'm sure that's been studied.
But the point I'm trying to make here is that from the moment of ingestion, that process of absorption begins.
Yes.
And I think I have an exhibit on that subject.
This is an article where they took, 5 patients who were on methadone, gave them their dose of between 100 and 120 milligrams of methadone, and then measured their plasma levels at 1, 2, 4, 6, 8, 10, and 24 hours, and then tried to determine how quickly the methadone plasma level went up after their dose.
Does it basically agree with the statement you just made that peak absorption occurs 1 to 2 hours after ingestion?
Well, the study is only looking at 5 individuals, but according to this, it seems that the peak is a little later, maybe 3 or 4 hours.
Okay. You agree that the graph shows the blood plasma level begin to rise at the 0, the vertical left line, so that's the point of ingestion. So it becomes detectable in the blood plasma immediately or shortly after ingestion?
Well, actually, in this study, these patients were on methadone already, so at time 0, their blood level was pretty significant.
Okay, but it still demonstrates a rise in the graph?
Not in all cases. For example, the first subject listed, in 1 hour, his blood concentration went from 0.73 to 0.70. So that one fell. The next 2 went up. The 4th one fell, and the 5th one went up.
So and that also speaks to the variability of physiology that you talked about a few minutes ago.
Right.
Okay. Methadone hydrochloride is the generic or the actual drug name that can then be branded under various other manufacturers' specific labeling, correct?
Yes.
Okay. So in the methadone clinic setting, when we talk about methadone, we're talking about the drug methadone hydrochloride, regardless of the brand name.
Yes.
And you said that Ohio, in the clinical setting, is a liquid administration state. Is that correct?
Yes.
And the clinic is open 7 days a week?
It was when I was there, yes.
Okay. So, for everyone's understanding then, if you're in the program, in this program, are you required then to attend daily to receive your prescribed dose?
Until you earn take-home doses, yes.
And how does that come about?
Well, if we feel it's safe to give people take-home doses after a certain number of months, according to the state and federal regulations, we can allow them to take anywhere from 1 day a week to 6 days a week, or even 13 days every 2 weeks home.
Yeah. May I approach it?
Yes.
I want to show you several photographs. They're 1443, 1444, 1445, and 1446. Tell me if you recognize what's depicted in each of those.
These all seem to be photographs of a bottle of methadone hydrochloride, similar to the ones that we sometimes use at the clinic.
Okay. And we've all received prescriptions where you get the box and there's that folded up piece of onion skin paper with all that tiny print that's tightly bundled and attached to the box. Is one of those on that big bottle there?
Yes, it is.
And in medicine or pharmacology, that's called the package insert, correct?
Yes.
What's described in the package insert?
Well, the characteristics of the drugs, the side effects, the clinical uses, some of the pharmacology. There's quite a bit in there. Yeah.
Okay. The intended therapeutic effect would be one topic, correct?
Yes.
In medicine or pharmacology, when we talk about a contraindication, are you familiar with that term?
Yes, I am.
Define it, please. What is a contraindication?
A contraindication may be a characteristic of the patient that would make whatever particular medication you're thinking of using have some deleterious effect. There's sometimes maybe medications we use that could be harmful, but we have to make judgments about risk and benefits. So if a medication, for example, if someone had a cancerous tumor, we might give them chemotherapy that would make them quite sick. However, our hope would be that the beneficial effect of helping their tumor regress would be greater than any harmful effects. So a contraindication, there's relative contraindications, which means that,
So Matthew, there is the treating physician talking about why he prescribes this medication and taking into consideration the contraindications for prescribing this medication. How do you think that plays with the jury? I mean, this witness was called during the prosecutor's case, right, and yet it seems to me that it's really a defense witness.
Absolutely. I mean, it is a little bit of a misstep, but they did probably have to put him in front of the jury. But if he were to come out, again, like I said earlier, if he were to come out and say he absolutely should not have been driving, then that's a slam dunk. Absolutely. But he's sitting up there and basically saying that he could be driving. So how is it reckless if the doctor who gave you the medication, who isn't on trial for the crime that you're charged with, but administered the very medication that led to the death of this officer? It doesn't add up.
And there's so many things that I say to myself, well, if If it had been Gaspar's first time getting the methadone,
right,
then you might think, well, he's impaired and no one knows it because he hasn't had time to actually see. But he'd been taking the methadone regularly, I think daily, with this particular doctor. You know, there's so many ways in which the state seems to have stretched this case a little bit. Do you think that that's because it was this beloved state trooper who was the victim?
Sure. I mean, there's a lot of broken hearts. The defense touched on that in their opening, that it was capped by the troopers, that it wasn't farmed out to some kind of local PD or something closer. It was right on the border, so you could have gotten someone from another jurisdiction who wasn't so familiar with the deceased to kind of run the investigation. So sure, I mean, I think it influenced it.
Yeah, and any time, I mean, we see this it kind of cuts both ways. When a police officer is involved in it, whether it's a police officer who is killed or a police officer that does the killing, you know, more and more we're seeing in the United States a push towards having some independence in the investigation to make sure that there is no bias either way. This is a case that's a bit unusual because it's the police officer who ended up trooper who ended up being killed, and yet you can see why there would be some bias. And in fact, a lot of the witnesses were actually in tears as they testified about Trooper Velez. Do you think that the jury, being from that community, will have a natural inclination to want to punish the person who killed one of their state troopers?
I mean, it's possible. I think that's why, I think it's highly possible. I think that's why the defense right out of the gate said this is a tragedy.
Yes.
They acknowledged that. They owned it. It was one of the first things they said. This is an absolute tragedy. So they get out in front of it and then they say, but it's an accident. And I bet you during jury selection, there were a lot of questions about people that had been involved in rear-end collisions. It's a real common accident. And if some of those people were like, well, gosh, I rear-ended somebody, I wasn't paying attention. I looked to the left, I looked to the right.
Right.
But it doesn't mean that you were committed reckless. Recklessness is the definition of that charge for the aggravated vehicular homicide. So willful and wanton disregard for the safety and health. I mean, it's this very serious definition. Somebody driving like a dip isn't necessarily going to rise to the level of recklessness. So.
Well, and that's such an important distinction to make, and we talk about it so much here at LawNewz Network, but there's a big difference between negligence, which is to not act with due care, and recklessness, which, as you pointed out, is more than just driving like a dip.
Of course.
And that's absolutely a valid point that I think the defense attorney will likely make in his closing.
Over and over.
I have been very impressed by him and his ability to take some of these, not just complicated issues, but also boring issues, and make them very simple for the jury. The whole issue about driving with a suspended license has become such a big part of this case, and yet it seems so minor, but it actually is an enhancer for the crime. So if he is found guilty of the manslaughter charge, he actually could get a bigger sentence if he's found to have been driving with a suspended license. Isn't that right?
Correct. I do think, though, that when they made the charging decisions, they overcharged. And then the defense took that and ran with it and said, this is evidence that they're trying to punish this guy. The DWLS that he was driving on from Ohio, they have a reasonable explanation for why it is that he thought his license had been restored and that he got a license, and then they went back and suspended it. It just kind of speaks to the fact that they're trying to punish someone for this crime because they feel bad because someone died on their end of it, on their side. And I'll tell you, they're outmatched. I mean, that prosecutor was a real snooze in her open. And then the defense, like you said, he's an impressive guy. He stood up, hit every single point, kept them riveted, kept them interested, kept it simple. I mean, you know, parts of this case are a little confusing, but he kept it simple.
Without a doubt, the bureaucracy of the DMV, I mean, we've all lived through it, but to hear these people testifying, it definitely could become, as you said, a snooze. And yet he really got in and just hit the points and hit them hard.
He was great. He really
I'm
was.
eager to see him give his close. Just as we saw in the Segura case, we've seen two really good defense attorneys. And the prosecutors have been good, you know, some better than others. But I think that I am eager to hear how the defense attorney in the Gaspar case really just tries to circle everything up and kind of drive home the points that you've made, that this was a tragedy, but not the result of any sort of recklessness or impairment. Let's talk a little bit about the impairment piece, because we heard, and I'm going to play some clips for you, of Sergeant Robert Gable is the police officer who actually conducted the field sobriety test. And there's some issue here even with potential bias, because it seems as though there's some question as to whether Gaspar passed the test, and yet the sergeant still found him to be impaired. So let's watch clip number 44, and then I'll come back and talk to Matthew. Remember, as soon as we go live in either Segura or Gaspar, we'll take you there. But in the meantime, let's watch clip number 44.
The tasks again, it's a never-ending process, and I had been in the office for a very short time when I overheard some radio traffic. So as I'm in the office, I have a portable radio on my side, and I can hear what's going on as far as what our officers are doing and what our dispatch is sending them to or receiving from the officers. So I'm monitoring that radio traffic. I heard over the radio car 3215, which is unusual, but it's not unheard of. Within the State Highway Patrol, there's another couple of branches that use our radio system as well. And when they want to talk to a trooper that they see out on the road, they call them by their car number because they don't know who's driving the car. So that came over the radio a couple of times, car 3215, car 3215. I believe I radioed to say 511, which is Kenny's unit number. 511, someone's trying to raise you on the radio. At some point, someone came over the radio and said that a trooper had been hit. So I went to dispatch, figured out where Kenny had been working. That's when I learned he was out on 90 West in the area of milepost 164. So I headed toward the scene along with Trooper McGill, who happened to be on post he's one of our canine handlers. So he happened to be on post at the same time. He also.
So there's Sergeant Robert Gable talking about Kenny. Matthew, the fact that he refers to Trooper Velez as Kenny, does that in and of itself make the jury more likely to sort of feel personally towards the state trooper?
Sure. I mean, I think that's a good catch. I mean, he did call him by his first name, and I think the defense will speak about that in their close. I think the jury hearts are going to go out to them. I think it could potentially influence his ability to be fair and impartial if he's doing these field sobriety exercises for someone that he's so close to.
And one of the things that I know we both try cases, and one of the things that sort of gets put by the wayside is the psychology of the players, the psychology of the jury. And so to your point, you know, when you hear someone referred to as Kenny as opposed to Trooper Velez, it does make a difference. The other part of psychology that I want to talk to you about is the fact that in this next clip, Sergeant Gable is told that Gaspar may be under the influence of something. So let's listen to that clip and then talk about how that could actually influence his investigation going forward. So this is clip number 46.
Uniformed supervisors on scene.
Why is it that you're turning the scene?
That's our procedure. Our protocol is that when someone of higher rank arrives on scene, the scene is relinquished to them unless they designate someone else.
So what occurs next?
So I didn't have any direct responsibilities at that moment. We were kind of waiting on resources. So I took a moment just to kind of step back from the scene and just process for a minute mentally. Put that back in a box and went back to work.
What was the next thing you did when you went back to work?
I reapproached Staff Lieutenant Shepard and Lieutenant Hughes, inquired if it would be okay if I went over and spoke with the driver. They said that they had received instruction, I don't know from who, to just stand by on that, is what they said. Just waiting for an investigator to come. There was some discussion about whether an allegation of being on something would potentially prevent or inhibit the interview of the driver.
And what was done next, sir?
We were waiting. So reconstruction, crash reconstruction unit, they began arriving on scene. Different investigators from the local Cleveland district began arriving on scene. They were directed to witnesses and began taking statements. Some of the investigators are evidence technicians, so they began, their work. So there was a lot of scene work going on during that time as we waited. I was told we were waiting on Sergeant Blake, who was the sergeant in charge of the Office of Criminal Investigation for the Cleveland District, under Lieutenant Huggins would be above him. But
and what are you doing during this time period?
Just asking what needs to be done and doing what I'm told, following orders. So there's not a lot for me to do. So periodically checking in on troopers on scene. During that time, I called each of the other sergeants and let them know what was going on. A couple of them had already heard and had gone to the hospital. Talked to my secretary on the phone. Yeah.
What's the next step in terms of your portion of this investigation?
Sergeant Blake arrived on scene. I met him when I heard him signal or say over the radio that he was arriving on scene. So I knew that he was on scene. I met him at the edge of the scene, and he asked me what needed to be done. I told him that my understanding was that we were waiting on him to do an interview. If I back up just a minute, there had been a conversation with Staff Lieutenant Shepard, Lieutenant, now Staff Lieutenant Hughes. There had been a conversation about me observing the interview of the driver in this case. The purpose of my desire in observing him was to determine whether there was reason to go any further with field sobriety tests.
What do you mean you need to determine if there was reason to go any further with standardized field sobriety tests?
Up to this point, we had a traffic crash, and we had someone who I didn't know. It would have been relayed to me, so I had information that I didn't know the source of, that someone said they think he's on something. So for me, that's not enough to just have somebody do field sobriety tests, and there needs to be more to that. And so my desire was to interact with him in some way so that I could either dispel that or confirm that there was reasonable suspicion to continue with some sort of a impaired driving investigation.
Excuse me, Judge, wait.
Yes.
Welcome back to LawNewz Network. I'm Heather Hansen here with Matthew Adam Gray, and that clip was interesting. It's sort of setting us up for the field sobriety test, which we're going to see in just a minute, Matthew. But he's talking about putting his emotions in a box, sort of, and approaching the witness after seeing one of his friends killed. Is that even possible? You know, we want to expect that type of behavior from our police officers, and yet they're humans, right?
Right. I mean, absolutely. And of course, as I said earlier, the defense will pounce on that. I mean, you have someone who's on the stand, who's supposed to be conducting an impartial investigation, who is visibly moved.
That's right.
A year later, he's still moved by the fact that his friend was killed. And yet he's the person who's supposed to be administering these tests, which should be conducted by someone who is not being influenced in any way by their personal feelings.
Right. And then the fact that he talks about that he was told that maybe Gaspar was on something sort of sets you up to the expectation, again, that in fact Gaspar could be on something. And so in stepping in to do the field sobriety test, to have that expectation, sometimes your expectations then create reality.
Absolutely.
So let's look at the next clips, which actually Sergeant talks about his field sobriety test and what he found, and then Matthew and I will be back to discuss.
And so what happened next, Lieutenant?
Sergeant Blake opened the right rear.
And so what happened next, Lieutenant?
Sergeant Blake opened the right rear passenger door of an unmarked highway patrol vehicle where the driver was seated.
At that point in time, were you able to get a good view of the driver?
Yes, I was.
Do you see that person in the courtroom today?
I do.
Can you please identify them and describe them for the record?
Stipulate your identity, Your Honor.
Record will reflect identification of the defendant by this witness.
Thank you, Your Honor. At that point in time, where you see the defendant seated in the unmarked trooper vehicle, what happens next?
So Sergeant Blake is standing as though you were to open the door. He was in the doorway, and I was on the other side of the door looking in at Mr. Gaspar, the defendant in the case. I noticed right away that his eyes were very wide open, and he has very blue eyes, so it's very easy to see his pupils. His pupils did appear constricted to me. It's also a bright sunny day, which causes pupillary constriction. So I was certainly aware of that and looking at that, but they certainly looked very constricted. and very wide open. As Sergeant Blake explained to him that our plan was to ask him for a voluntary sample. And Mr. Gaspar was confused by that in that we had to explain several times. So I kind of jumped in on Sergeant Blake, and because I kind of sensed that Mr. Gaspar was becoming agitated, and in drug recognition expert school, we spend time making sure the students understand that if you're trying to have someone do a drug recognition expert evaluation, which is about 45 minutes to an hour and 15 minutes of time, where you're asking someone for to take their temperature, their pulse rate, their blood pressure. You're going to look in their nose and in their mouth. You're going to look at their pupils in 3 different phases of light in a darkened room. The last thing you want to do is go into like a really hard cop mode and start agitating people. So I wanted to just bring the mood down just a minute and let's slow down. Let's just talk about what we're doing here. So I told Mr. Gaspar, it's our policy, it's part of our procedure to ask someone to do that. You're not required to do it, but we're just asking if you would be willing to give a sample. He said he didn't understand why we would want to do that. Again, I said, it's just part of our procedure. It's what we do. It's a pretty serious crash. I'm sure you understand that it's pretty serious here. So it's a checkbox on a checklist that we have to say this is something that we want to do, is identify whether or not there are drugs or alcohol in a person's system for all drivers involved in fatalities. He still needed that explained again, so we went through it again. And I told him, again, you're not required to do it, but are you willing to do that? At that point, he said, I really think I need to speak to a lawyer before I say or do anything else. So that's fine.
One moment, please.
Ladies and gentlemen, you understand all of us have a constitutional right not to incriminate ourselves or talk with the police, and so the fact that Mr. Gaspar did or didn't do that at any point, it's his right, and you may not consider it for any purpose whatsoever, okay?
He was talking low. He was talking very slowly. So, as he's answering his things and asking questions, up to that point, he's just speaking slowly with a low, kind of a raspy voice. And again, his eyes just remained wide open during the conversation.
Did those observations have any significance to you?
Yes.
What was the significance of those observations?
So constricted pupils, there's a lot of reasons for them, but in a drug symptomology matrix, they fall into one category, and that category is narcotic analgesics. And it's kind of a telltale thing. There's a lot of drugs in the narcotic analgesic category, including heroin, fentanyl, carfentanil, along with a lot of prescription medications. Methadone is one of those, OxyContin, Percocet. So there's a lot of opiate-related or opioid drugs that fit into the narcotic analgesic category. All of those drugs constrict pupils. They also produce withdrawal, and they also stave off withdrawal. So seeing the very constricted pupils, hearing a low raspy voice, which also is one of the general indicators for the narcotic analgesic category, but then seeing wide open eyes doesn't fit with that necessarily. And it was certainly something of note, something of interest, something that I can't forget. So there was a lot going on with him, and because of the repeated explanation over what I believe to be something pretty simple, we basically are asking you to give a sample, and then had to keep repeating that we're asking you to give a sample. He seemed confused. He seemed to be having trouble processing the information that we were giving. So I felt there was enough there to have him do some field sobriety tests.
And what do you do next at this point?
I have him get out of the vehicle. Well, he was still seated in the vehicle when I explained to him that I would be having him do a couple field sobriety tests just to make sure that drugs or alcohol did not play a part in what had occurred that day. I did tell him that news cameras were being set up on the Alger Road overpass was just to our east. I told Mr. Gaspar that I was interested in moving him away from those cameras to put him at the opposite end of the scene. There was a van parked down there. I said we can take you to the other side of that van. That way you're not on video doing field sobriety tests.
So there's Sergeant Robert Gable talking some more, Matthew, about the field sobriety test and sort of setting up, you know, first he pulls him over and Gaspar's in the car. And some of the things that he's giving as evidence of some sort of an impairment, a little weak to me. What do you think?
I agree. I mean, what he's basically describing is someone who's just taken a dose of methadone, a prescribed dose of methadone. People that are abusing heroin, we've all seen them on the subway, the street, television, they're nodding out, they're incoherent, they're stumbling. That's not what he's describing. He's someone who just struck someone on the side of the road whose eyes are wide. Well, of course they are.
Yeah, I mean, that's another very important point, and a point the defense attorney has made again and again, is that if you just struck a state trooper on the side of the road, you're going to be in shock. I don't think that there's anyone who could, unless they were a psychopath, who could go through that type of experience and not be in shock.
Absolutely.
And so sort of, you know, setting the stage for this to be a situation where he was impaired may have been the result of having just seen one of his own be killed as a result of what could have been just an accident.
Right. I mean, they want to lay blame on someone because it's a true tragedy. But you know, drug recognition, experts are not infallible. I mean, it's not an exact science.
Right.
When you've got a breathalyzer and alcohol, that's an exact science.
That's right.
But DREs are trying to look for cues and signs to try to determine if someone's impaired. And my understanding is that many of the things that you need for a divided attention exercise like driving, he was able to do. Get out of the car, walk, turn his head, touch his nose. Those are the things that you would need to drive a car. So if he's able to do that, how do they then argue that he's impaired?
And let's go to the next set of clips. We're going to do actually 49 through 51, and then we'll come back and discuss them and discuss the actual field sobriety test.
When you may not really be impaired. So I don't want it to appear just because you're doing tests that you're impaired if you end up not being. He was confused by that again, and he asked, you know, I don't understand why you would want to take me away from the cameras. And I said, you know, look, I understand, you know, in policing, how video can sometimes not really tell the true story, and someone can make up their mind just watching a video without having the background or the audio to go with it. And so what I don't want is for someone to be watching you on live news and say, I know that guy, he's impaired, you know, the cops have him doing tests, he's impaired, when that may not be the end result of the test. And so I just want to protect you from that. He thought about it for a minute, and then he responded to me that he felt like maybe he should do it in front of all the news cameras. And so, okay, you know, that's if that's what you want to do. And then he said he felt like he should have all those cameras to show that he wasn't impaired. He said, well, you know, sir, you're going to be on dash camera. You're going to be on camera. Certainly, I'm not taking you somewhere where I'm not going to have you on camera. You'll be on camera the whole time, but I'll be audio recording it as well. So not only will it be video, but you'll be able to hear, anyone watching it later could hear it. He said, no, I think I should be on as many cameras as possible. I said, that's fine. Go ahead and step out. I'll have you do a couple things for me.
Is at this point in time that you begin to administer standardized field sobriety tests?
I didn't have my belt microphone on me. It was still in the charger. We asked him if he was currently experiencing back pain. He said that no, he was not in pain. I asked him if he would have any problem, if he felt like that would give him problems in walking, and he said he didn't think so, that he would be fine.
Now, Lieutenant Gable, at this point in time, why are you asking all these questions?
That's part of standardized field sobriety testing, asking someone if they have problems with their neck, back, legs, balance issues. Also, I'm going to be looking at his eyes, so asking if he has any eye defects or problems with his eyes.
And what happens next, sir?
I could tell that he wanted to say something, And then he said he wanted to say something. I said, well, you know, if you want to say something, I'm not going to keep you from talking, but I'm not asking you. And he said, well, I'm on a methadone maintenance program, and I just don't know how that's going to look in the test. And I said, I don't know how that's going to look for you either. I really can't advise you, you know, what that's going to do to you or what that's looking like for you right now. And I responded in that way because I really didn't know when he had taken his last dose. I didn't know if he had any food to go with it. I assumed it was oral methadone. I didn't know when his last dose prior to that was. There were a lot of factors that I didn't know to really tell him you're going to be messed up. So I couldn't really tell him. So I very honestly told him, I don't know how that's affecting you right now. I don't know how that's.
Lieutenant Gable, can you please walk us through the instructions you typically give for the walk-and-turn test?
So for the walk-and-turn test, typically the person performing the test should be to my left. So that's as though the person doing the test is over here. I would tell the person to put their left foot on a line, put their right foot directly in front of the line, heel to toe style. And so I demonstrate for them exactly what I want them to do on the line. And I would wait for them to do that. And then I would tell them to put their hands down against their sides and keep their hands against their sides throughout the remainder of the instructions. I make sure that they understand that they're not to move from that position. So while I explain this test, I really do need them to stand in this, what's considered the instruction position. And the reason why it's important they not move is there's two clues that I'm looking for during this portion of the test. I'm looking for them to move their feet apart. So if you see from this angle, it's to move the feet apart so they lose balance and have to adjust moving their feet apart. I'm also looking for them to potentially start the test before the instructions are completed. Those are the two things I'm looking for during just the instruction phase of the test. But I put them into the instruction position, I make sure that they understand they're not to move, and then once they understand, I explain to them, when I tell you to start this test, I want you to take 9 heel-to-toe steps on the line, do a turn exactly the way that I instruct you, and then take 9 heel-to-toe steps back on the line. And then I demonstrate for them. It should look and sound very similar to this. Your first step is going to be with your left foot coming around, step number 1, 2, 3, and continuing 4, 5, 6, 7, 8, 9. At the end of your 9th step, you need to leave your front foot on the ground. Bring your other foot around and use that foot to take a series of small steps to turn yourself around. Once you're facing back where you began, it should be 9 heel-to-toe steps on the line. And then there's 4 instructions given at the end. It's very important that once you start taking your steps, you don't stop walking at any time. Make sure you keep your hands right against your sides throughout the test. Make sure you say your steps out loud. And make sure you keep your eyes pointed down toward your feet throughout the test. I ask them if they have any questions about the test. And once they confirm that they don't have any questions, then I tell them to go ahead and begin the test.
Thank you.
So Matthew, there he's actually reenacting part of the field sobriety test. I get the sense that he is almost trying to convince himself that Gaspar is actually impaired. What did you think, and how do you think this will play to the jury?
Sure. I mean, I think what's happening there, it's a little unusual. I think if you have video footage, you alluded to a dashboard cam, why not just roll tape?
Right.
He's obviously impaired if he's stumbling, if he can't walk straight. Instead, he's getting down and he's saying, okay, this is what it is. It's a subtle thing that you're going to have to see on the tape because this is what it would be. Right. I mean, so he's really kind of trying to, I think, to lay the foundation for what's going to show someone who's not really having a hard time with a walk and turn.
Great point. That this is why it is because you don't see it this way because you're lay people, and so let me explain it to you. The other thing that I thought was interesting is Gaspar's asking for more cameras. Sure. He's saying, not only do I want this to be by the police camera, but I want it to be in front of the news cameras. Why do you think that was? It's
a little unusual. I mean, the methadone could be influenced the way that he thinks a little bit, or he might just have a deep mistrust of the police as being someone who is mixed up in drug addiction. We don't know what his criminal history is unless he testifies, but there might be some of that going on. He also knows that he killed a trooper.
Right.
I mean, he's not immune to that idea, so he probably wants to protect himself somewhat. What really my takeaway from this is that you have someone who's incredibly cooperative.
That's right.
Proving a case when someone clams up, lawyers up, and doesn't say anything, those are the hardest cases.
It's a very good point, because a lot of times people think that's what they should be doing, and as a lawyer, you tell people don't talk to anyone.
Don't talk to police ever. I'm like, I'm the bad guy. You tell them you know a lawyer. Do not speak to anyone about anything. Call your lawyer immediately. Right. Because most cases are proven, not most, but many cases are proven by the things that people will say to the cops. You cannot believe when you speak to them. You're like, why on earth would you have told the police that?
Right. But
and
here,
people just don't know.
But here, Gaspar sort of helps himself.
He volunteers.
He's
like, let's do it. I mean, he could have just refused, and then they would have, maybe drawn blood. But I doubt a judge would have allowed that to happen, and would have had to go on and get some kind of warrant or something to draw blood from him. They might have, but he could have played it differently, and he didn't. So.
Right, and I think to your point, I think that it probably helped him. So let's go to the next clips as we continue to walk through the field sobriety test. Just as a reminder, the Segura case is on a break. They were still in the middle of the DNA evidence. The Gaspar case, they came back to the courtroom. The defendant, Mr. Gaspar, said that he was not going to testify, and then the judge took what was supposed to be a 30-minute break to go over some evidence and on his other dockets. We are waiting for both cases to come back. As a programming reminder, ladies and gentlemen, any time that we're watching one trial on the main screen and you want to watch something else, just go to the upper left-hand corner of your screen. There's a drop-down, and you can pick whichever trial you want to follow. The plan right now is to go with Gaspar closings when they come back, but if Segura comes back first, we'll go there first. Right now, we're going to continue to play the clips of the portions of Sergeant Gable's testimony about the field sobriety test and discuss them with Matthew while we have him here, so we'll go back to that next clip.
Walk us through the instructions you typically give for the one-leg stand test.
Sure. Again, as though the person were standing there at the table, I tell the person to put their feet together, hands down against their sides. This is the instruction position for the test. So I tell them that's what I need them to do. I wait for them to get into that position before I begin the test, for the instructions for the test. I tell them that when I tell them to raise one foot into the air, either foot, hold it level or parallel with the ground, about 6 inches off the ground, and then I typically say that's about right out here. I tell them to keep their hands against their sides, their feet and legs straight, and to remain in that position while counting out loud in the following manner: 1001, 1002, 1003, and so on until told to stop. And then I tell them it will be 30 seconds. I ask them if they have any questions about the test. If they don't have any questions, then I tell them they can begin the test. When they begin the test, I start timing the test on my Prior to having him do the test, did I observe him? Yes.
Did you see any visible injuries to his head or face area?
No.
Prior to having the defendant perform the test, did you question the defendant about any particular injuries or pains to any area?
Yes.
Did he provide you with any responses to any issues he was having?
He said that he had a bad back or a sore back, or he had back problems. I don't remember exactly what he said as far as his back went.
Did you inquire of the defendant as to whether or not he was experiencing those issues at the time of the test?
Yes, I did.
And what was his response?
He said he was not in pain.
Did the defendant indicate to you any injuries to his head or leg or anything of that nature?
No.
After all of this is completed, what is it that you do next?
As far as this defendant or in standardized field sobriety tests? Okay. For in this case, I moved beyond standardized field sobriety tests after the vertical gaze nystagmus. So, beginning with horizontal gaze nystagmus, I'm looking for several things in that test. I moved into vertical gaze nystagmus, then I moved into what's called lack of convergence. So that's a test where I move, again, the same stimulus that I used for horizontal and vertical gaze nystagmus. I moved into lack of convergence, which is moving the stimulus around in a circle 2 times and then bringing the stimulus in toward the bridge of the person's nose. And then I hold that stimulus there looking for the eyes to converge equally and remain converged. There are some drug categories that don't allow the eyes to fully converge and stay converged. So what I'm looking for is for the pupils, the irises, to not come all the way in and stay there. In this case with Mr. Gaspar, as I moved the stimulus in, his left eye moved back out straight rather than staying converged. I repeat the test to see that I get the same thing, and again, his left eye moved in with his right as it came in, and then his left eye moved out to the side before I removed the stimulus.
As it relates to this defendant, Was the performance or administration of the standardized field sobriety tests that were administered to him captured on video?
Yes.
If you were to see that item, would you recognize it again?
If I were to see
The video.
the video, sure, yes.
Your Honor, can we play State's Exhibit 1514 at this time?
Yes.
So welcome back to Law News Network. Matthew, Adam Gray, and I are here talking about the field sobriety test in the gas bar case as we wait for those lawyers to come back and do their closings. So Matthew, if you're a former prosecutor.
Correct.
If you're
and also, I did some public defense work as well.
Wow, so you've got both sides,
yeah.
right? And you're currently trying cases. So if you're, let's talk first if you're the prosecutor, because we've talked so much about how we both, I think, feel the defense has a pretty strong case here. But if you're the prosecutor, you have to A, believe your case, and B, argue it to the jury. How would you do that in this case with these closings coming up in minutes?
I mean, basically what I think they're going to end up doing is arguing that all the other vehicles on the road were somehow able to avoid this tragic accident, and yet the person who had just popped some methadone in their mouth was unable to. Also, I guess they're going to revisit, I mean, they lost some credibility on that we talked about earlier with that speed. I mean, that's essential to a reckless charge. So
yes.
I guess they'll focus on the fact that speeding, I mean, sometimes speeding is based on the circumstances. The speed limit's a suggestion, I guess. If it's stop and go traffic, if you're going 60, you're like, oh, that's the speed limit. That's kind of not how that works. So they would focus on that. And then I guess the portions of the field sobriety test that were negative, I think that we're not reflecting well on whether he was impaired. The horizontal gaze nystagmus, they keep saying that, like very technical term. To me, I would just explain it to them as like it's a fluttering. It's a flutter of the eye, and someone who's loaded, their eyes flutter. Like
Matthew,
I just kept it kind of.
Such a good point. And one of the things that I always stress to my young associates is the curse of knowledge. You know, when you know something so well, and so these police officers and the prosecutors know the nystagmus test, but the jury doesn't. So you've got to say, you know, what does it mean? What does it look like? Right, exactly, a flutter.
It's
and then
really, I mean, that's my takeaway from it. If someone's loaded or high or intoxicated or impaired, their eyes are going to do this involuntary thing when you try to get them to go to the different areas of the eye plane.
And that's such an easier way and a better way to explain it to these jurors, and it makes things so much easier to sort of wrap up at the end.
Right.
But I think you're 100% correct, because we saw it in their opening that the prosecutors are going to say everyone else was able to avoid this. Everyone else was able to do the right thing. And yet this one particular gentleman who just happened to have just taken a drug was not able to do the right thing. Right. And that may be strong enough. I mean, you know, we may see a really strong closing from the prosecutor. I'm going to take us back to the next clip of the field sobriety test description, and then I'm going to ask you what you would do if you were the defense attorney, which I think might be a little easier for you. But right now we'll throw to the next clip.
What is it that we're seeing at this time, Lieutenant?
This is where I had Trooper McGill go and get my patrol car and pull it up. I was motioning to him that I needed my belt light.
point in time in this video?
This is the horizontal gaze nystagmus followed by vertical gaze nystagmus, and then lack of convergence are all right here together.
And during your administration of these tests, what, if anything, did you notice from the defendant?
So throughout horizontal gaze nystagmus, there's 6 total clues that I'm looking for: a lack of smooth pursuit in each eye, a distinct and sustained nystagmus at maximum deviation.
I'm sorry.
I'm sorry. I'm so sorry. A lack of smooth pursuit in each eye, a distinct and sustained nystagmus at maximum deviation in each eye, and then an onset of nystagmus prior to 45 degrees.
And what, if anything, did you observe in the defendant in regards to those 6 indicators?
I did not notice any of those indicators in his eyes.
We are back live in the Gaspar courtroom, so I'm going to take you straight back there. We'll hopefully be back with Matthew Adam Gray during the next break.
There's been no testimony by any witness that methadone is in fact a drug of abuse. In reality, what we did have was Dr. Franklin testify that methadone is not a drug capable of impairing an individual in any way, and there's been no indication that methadone is anyhow abused by folks. Given those things, Your Honor, I'm going to ask that this court grant a judgment of acquittal on count 5, and then by extensions to count 1 and 3.
Thank you. On behalf of the state?
Yes, Your Honor. In regards to that motion, Your Honor, the state will request it denied. The facts still have to be viewed in the light most favorable to the non-moving party. And it seems the only thing at issue, or what defense counsel is attempting to challenge, is whether or not methadone is a drug of abuse. As defined by the courts, and as will be defined in the jury instructions, a drug of abuse means any controlled substance, any harmful toxicant, and any dangerous drug. And so the state would submit that there has been more than enough testimony regarding methadone being a controlled substance and a dangerous drug. And that was testimony given through various witnesses, Your Honor.
Let's stop, because this is a really technical argument, and I didn't bring this up to the parties lightly, all right, because I understand the situation involving the trooper is tragic, and everybody has worked very hard on behalf of their clients, all right? But this is a very technical issue, and it's one that only came up because of an offhand remark by defense counsel the other night. And when I was driving home, I thought, all right, well, they're asking for a definition in the jury charge of drug of abuse. And so Saturday I spent a lot of time going over every aspect of the potential jury charge, all right? So we're dealing with count 5. And the issue is when at the time of the operation, he, being Mr. Gaspar, was under the influence of alcohol. Do we have evidence of that?
No, Your Honor.
All right, so alcohol, a drug of abuse, or a combination of them. Well, I thought from the urine and from the blood there was no evidence of alcohol.
Correct.
So now we're only dealing with whether he was under the influence of a drug of abuse. And I would, for purposes of sentencing charge and all, I would have put in to it methadone. But going back to the statute, 451119A 4511.181 definitions. Subsection E says, drug of abuse has the same meaning as in section 4506.01. Do you have that pulled up?
We're pulling it up now, Your Honor.
So it's a term of art. It's defined term, drug of abuse, is in quotes, has the same meaning as in 4506.01. This is why I wanted the parties to look at it yesterday.
Yes, Your Honor. And in addition to those arguments, though, Your Honor, we also believe that 4506.01 still defines drug of abuse as any controlled substance, dangerous drug, as defined in 472901, or over-the-counter medication that, when taken in quantities exceeding the recommended dose, can result in impaired judgment or reflexes.
I'm sorry, where are you going?
This is 4506.01M, Your Honor.
Yes, and that's exactly where I'm at, okay? Under subsection M means any controlled substance. So when you go to 3719.41, Schedule 2, and then it has under B, narcotics, opiates, 15, methadone. Do you want me to repeat?
Could you please, Your Honor?
Yes. Controlled substances under 3719.41, Schedule 2, under B, narcotics, opiates, subsection 15 is methadone. Okay?
Okay.
So then that takes me back to drug of abuse means any controlled substance. So that would include methadone. A dangerous drug is defined in section 4729.01. So we'll have to look at that. Or an over-the-counter medication. Well, this is not. This is he obtained a prescription or had a prescription. This is not like he took an over-the-counter allergy medicine or something.
Correct, Your Honor, but under 4506.01M, drug of abuse means any controlled substance. So methadone is covered under controlled substance, which you just recited from 3719.
But there's a qualification.
Cool.
Drug of abuse means any controlled substance, dangerous drug, or over-the-counter medication that, when taken in quantities exceeding the recommended dosage, can result in impairment of judgment or reflexes. So, I guess we have to focus on how that's read. Does that qualification, where it says medication that, does that refer only to what follows, or does it refer to any controlled substance? That's what we're talking about.
I believe it refers only to what follows, Your Honor. And what would make me argue that is the case of Ohio v. Richardson, which is 2016, Ohio 8448. And that case is the one that's particularly controlling and on point in this because it discusses the issue of a substance that would be considered a controlled substance under hydrocodone. And that's similar to the methadone situation that we have here. In that case, the court held that the state had presented sufficient evidence to prove that that defendant had just ingested the hydrocodone. And then the court further went on in paragraph 18 to state that there was sufficient evidence to impairment based on the officer's observations on the scene. And the court ultimately in that ruling held that when the effects of a drug are sufficiently well known, as they are in hydrocodone, expert testimony leading to ingestion of the drug with indica of impairment is unnecessary, as there was lay witness testimony that connected Richardson's impairment to the hydrocodone, i.e. the testimony of an experienced, well-trained officer. On these facts, we hold that the evidence was sufficient to support Richardson's OBI conviction. The state would argue that that connects exactly to this case in the arguments in regards to drug of abuse and impairment, and that those are similar to the facts of this case. You have a substance, methadone, that is labeled as a controlled substance. Controlled substance is listed as a drug of abuse in the code section that you cited. And based on that, 4506.01 subsection M definition of drug abuse, it falls under controlled substance. There's been more than sufficient evidence or testimony that has been submitted to this court that would establish the two things that are required under Richardson. One, that the drug was in fact ingested, and actually it's three things. The drug was ingested. There's no question the defendant ingested methadone. There's been numerous testimony. There was video of him ingesting methadone.
There also was a blood test to confirm.
Correct. Two, that there was expert testimony linking the injection to impairment. Wasn't even necessary under Richardson, but in this case you actually have testimony from the lay people on the scene. I believe there were about 3 or 4 witnesses who testified to their observations and concerns in regards to the defendant's impairment based on their observations, not even knowing what was in his system. And then you have the extensive testimony from Lieutenant Gable as to his observation of the defendant throughout his time reviewing him on the scene, that he in fact believed he was impaired. So that in conjunction with the fact that he ingested the methadone, there was no disputing whether or not he ingested that. It's in his system. The code sections clearly define methadone as a drug of abuse since it is a controlled substance under 3719.41, Your Honor. So the state believes there's more than sufficient information here to show that methadone is a drug of abuse based on its categorization as a controlled substance. And furthermore, to the Richardson case, there's more than enough information to send it back to the jury, Your Honor.
What was the, it was 2016 Ohio what?
Ohio 8448.
All right, and looking at the definition of dangerous drug under 4729.01 F 1B, it says under chapter 3719 of the revised code, which is where methadone is found, that the drug may be dispensed only upon a prescription. So again, I'm looking at whether the phrase, when taken in quantities exceeding the recommended dosage, can result in impairment of judgment or reflexes. Does that modifier relate to over-the-counter medication, or does it relate to controlled substance, dangerous drug, and or over-the-counter medication?
It would be the defense's position, Your Honor, that it relates to all three. I think a plain reading of that statute indicates it relates to all three.
Well, that's why I asked the parties to see if they had any, not just argue it, but support it. So do you have support for that? Is there a case that has considered this issue?
I do not know there was a case to consider that issue, Your Honor. What I would say is that I had a chance to look at the case they cited. In that case, it can be distinguished from this case. One, in that case, Vicodin is a well-known drug of abuse. The court kind of relied on that, saying that Vicodin is just a well-known drug of abuse. There's been no testimony whatsoever that methadone is a drug of abuse. In fact, the testimony has been contrary to that by the medical testimony that methadone is not a drug of abuse. Dr. DeFranco said that it's not a drug of impairment. It doesn't cause impairment. When you look back at the case that the state cited, that individual had many, many indicators of impairment that the court thought were relevant. The fact was, he failed all his field sobriety tests, he was stumbling, he was slurring his words. That, in combination with the well-known effects of Vicodin, led them to believe that there was enough evidence to send that to the jury. That's different in this case. There's no indications, or not nearly the amount of indications of impairment in this case. There's no medical
impairment is a separate issue. That's whether he's under the influence. We're just dealing with, is methadone here a drug of abuse? That's the only issue we're dealing with. Because there is sufficient evidence from the testimony of the trooper that, in his opinion, Mr. Gaspar was under the influence. There was some corroborating evidence from others that a jury could find supported that contention or that belief.
Well, then it's going to fall on our interpretation of that very narrow definition. I would say the rules of construction would imply that, yes, Your Honor, that caveat or that qualifier is necessary. There's been no testimony that this drug was given an amount greater than the recommended dosage or an amount that was likely to cause influence.
One or both of you can respond.
Judge, I would direct the court's attention to the testimony of Dr. DeFranco. I know it was long and tedious and filled with the black box warning language in which he agreed with the black and white of the pharmacology warning that when you have someone break their treatment by being non-compliant, even though you've previously reached a tolerance of an administered dose, when you begin to lose tolerance, you then fall into the dose initiation warning. The dose initiation warning Dr. DeFranco testified to was applicable where a person could suffer the initial side effects of impaired judgment, slowed reflexes, euphoria, sedation, and all of those things. There is evidence before this court and this jury that the defendant was non-compliant with his course of treatment. To say, arguendo, that you can have a prescription for an opioid and that because a doctor prescribed it, you're immunized under the law from all effects that might flow from your misuse of the treatment program is wrong and it's unjust. Here you have someone who has departed from his physician's care, he was absent, and then the dose was increased. The totality of the evidence is that he should have received a decreased dose or become stabilized. Dr. DeFranco admitted that it takes 5 to 6 days of continuation of dosing after a break to establish stability, which then takes additional time to then follow the black box warning of dose titration so that you can have established medically that the person is tolerating the dose at the newly established level. That is lacking here. And the defendant's absent from the clinic on the 10th and the 11th, so he's not in compliance with his physician's care. So he is, per se, abusing his right to the prescription.
The statute says it has to be taken in quantities exceeding the recommended dosage.
Your Honor, what the statute actually says I agree, the statute does say that, but I think we're trying to break the statute up when necessarily that's not what should happen. What it says is drug of abuse means any controlled substance, comma, dangerous drug as defined in section 4729.01 of the revised code, or, comma, or over-the-counter medication that, comma, when taken in quantities exceeding the recommended dose. The way that verbiage is set up can lead the reader to understand that that is talking about the over-the-counter medication. It's talking about when the over-the-counter medication is taken in doses exceeding the recommended dosage. And we can make that inference and understand, Your Honor, when we flip to the other statutes that you define, because those don't talk about necessarily there being a recommended dosage. It talks about the actual warning label that has to be on there telling someone, hey, this is the dosage you should take. So the state continues to assert the fact that that additional language is something separate and apart to the underlying language. And then we go back to the case law, which supports the state's contention on that. And what the court actually said was, when the effects of a drug are sufficiently well known, as they are with hydrocodone. Well, how do we know in this case that the facts or the effects of methadone are sufficiently well known? You had numerous witnesses who came in here and testified. They weren't methadone experts, they were just regular people in the medical profession. And whenever defense counsel began to inquire of them whether or not they knew the side effects of methadone, each and every one of them did. That can be taken as a drug that's sufficiently well known, or the side effects are sufficiently well known, Your Honor.
Mr. Sen, Ms. Knox, anything? No, Your Honor. All right, I'm going to go look at the Richardson case and see if there are any other cases I think are relevant before I look further at this issue. Any other counts that you have a different argument than you had on Friday?
No, sir.
And any additional argument on other counts for the state?
The state would incorporate its first Rule 29 argument into this argument, in addition to what we've stated.
Thank you.
Welcome back to LawNewz Network. I'm Heather Hansen here with Matthew Adam Gray, and we are talking about that argument. You know, most of the time these arguments are just a throwaway, something that lawyers have to do because they want to have something to appeal later. But this is an argument that the defense very well could win, isn't it?
Absolutely. I mean, they feel like, it looks like the state is on the ropes a little bit.
Yeah.
I mean, they're really doing this very precise statutory construction, and then they're kind of jumping over each other. When I was a prosecutor, my argument was my own. Nobody was coming up and helping me out. I mean, it seems like they have to kind of assist each other and tag team, which kind of speaks to their desperation a little bit.
Let's unpack that a little bit, because first of all, the statutory reconstruction thing is the whole thing that we do in law school, and it was my least favorite part of law school. Picking apart the statutes. I know our host Aaron Keller loves this stuff, and he's done a pretty thorough review of this case and this statute online, but they're picking apart the judges, the statute, to say, do these words modify these words, or do they modify these words? It seems pretty clear to me that the judge agrees with the defense that this case, the use of the methadone here, does not fall within the statute that defines impairment. Don't you think that that's ultimately what he's deciding here?
It looks like he's leaning towards that, and yes, the defense, once again, has kept it simple and kind of drawn the court's attention to really the quick, and it sounds like the right answer. I mean, is that really it's about the prescribed dose? I mean, how do you find someone impaired if they're taking the dose that's prescribed by their physician?
Well, right, and if we start doing that, then how can we not have the courts filled with people who are taking the medications, and then you find out, have they skipped 2 days? Because that's been a big issue on the prosecutor side. But another thing you pointed out, Matthew, that I think is important to point out is when I was first learning, I would go to court with my mentor, and he would allow me to have some arguments. And I knew if he popped up during my argument, then things probably weren't going all that well. And that's what we just saw there. Correct. That the female prosecutor was arguing, and then the male stood up and sort of piped in, and sort of a different argument. Does that show to you that they're a little bit concerned about this?
Of course. I mean, yes, absolutely. I mean, it's kind of the fact that they're fighting so hard does speak to the fact that there is a possibility that they could have a directed verdict here. I mean, I think his argument was actually stronger. When he stood up, it made a little more sense. But then she got back in and muddied the water. And when it comes to questions of fact and directed verdicts, my concern would be that sometimes the judge just gets confused and there's enough going on. They're like, you know what, let's let the jury decide. There's a question of fact, we'll let the jury decide. But who knows? I mean, he might come back and find he might dismiss some of those charges.
And if he doesn't, there's a very strong appellate basis to appeal any sort of conviction on those counts. Because this is the type of law that everyone in Ohio and ultimately nationally is going to want to be clear, especially if we have increasing methadone clinics across the United States. You saw we saw the body language of not only the defense attorney, but the defendant when the judge was sort of seeming to be agreeing with them, nodding their heads and almost jumping up for joy. You know, that's the type of thing where you have to remember to keep your mouth shut and not push your luck. Right. So hopefully we'll get a ruling pretty quickly. We do want to take you back live. The Segura trial is back again, and the DNA expert continues to be on the stand. In case we don't get Matthew Adam Gray back before he has to leave, I want to thank you for being with me for so long here today. We'll definitely have you back to help us pick apart these cases. But in the meantime, we want to take you back to the Segura case, and we'll be back as soon as Gaspar's live.
You did testing on a T-shirt that was found at Jack McLean Park, and I'll identify it by state's exhibit number in just a minute here. It was published to the jury and held up a little while ago, correct?
I don't know that I did.
You don't recall doing that?
No.
Okay. We can ask you about that later. I have no further questions for the witness at this time.
Redirect.
Couple of things. The gloves that we're talking about from Jack McLean Park, you identified some blood on certain locations, correct?
On TPD numbers 11A and 12A. Yes.
Okay. And you did test those?
Yes.
and you excluded them from being Brandy Peters, Tamaya, Tanaya, and Javante Peters, correct? Javante Seguros, correct?
Correct. Well, that was for 12A. For 11A, I got no results.
Okay. Fair to say, Jack McLean stuff, you have no idea where that was involved in the homicide at all, and then the fact that the blood didn't come back for anybody related to the homicide is inconclusive at best, correct?
I did not even know they came from Jack McLean Park.
Okay, fair enough. You also talk about DNA being degraded over time. Would it sitting outside in a trash can for 5 days cause problems with DNA?
Probably.
Let's talk about projectiles real quick. You mentioned, you asked about a projectile you did testing on, and you usually don't get results.
It is rare to get results since that projectile has been subject to very high temperatures for firing.
Touch DNA is can be transferred from one thing to another, correct?
Yes.
If projectile in question landed in a closet with some other clothing material or towels or something like that, could it possible that that's where the, I guess, transfer of DNA could occur?
It's possible.
Okay. One of the questions that was asked of you had to do with blind testing, and what I think was the term Mr. Prince used. And I think there was some discussion about whether you talk to somebody going into doing your testing or not. You understand? You remember that?
Yes.
Okay. What is the danger of talking to somebody about what you're looking to find before you actually do your testing?
Well, a scientist is supposed to be impartial, and whether I talk to anyone or not would not actually influence how I did my testing. I suppose it might be possible for some people to be influenced. If they say, is someone's DNA on this item, you might, well, you can only get what the DNA shows you, so you can't actually invent it, so I'm not sure how it would actually prejudice you.
Could you skew, and I don't mean skew, I don't mean that you falsify any documents, but as it relates to DNA, is it possible that maybe if you could interpret it two different ways, if you're looking to find a certain result, that you may interpret it that way? Basically,
I suppose it's possible.
You find what you're looking for.
Well, again, the DNA is not going to show me what I want it to show me. It's just going to show me what's there.
Okay.
So,
do you understand what I'm asking, though? If you're looking to find a certain result, and it can be interpreted one way or the other, is there a danger at that point? And not of you, I'm talking hypothetically, that you could find and alter your opinion and lean towards that which you're supposed to find?
I suppose in general, someone might be influenced to do that.
Fair enough. Thank you very much.
Hey, Juror, I have a question. All right, if you have a question, let's write it down. Right. All right. Next, you can step down.
Am I excused?
We need to keep her further.
We don't need to keep her here, but she would remain under subpoena.
Need to remain on call, please.
Okay.
All right, next witness.
Your Honor, I hate to do it right after we come back, but this is going to be a change of computer systems and stuff like that. We need to load up some stuff for the next witness. If we can just take a 5-minute break to make that happen.
Okay. Take a few minutes.
Thank you.
Well, that was quick. Welcome back to LawNewz Network. I'm Heather Hansen, and here Matthew Adam Gray is still with me, and we just saw the little teeny bit of Segura, and they're done with the DNA witness, at least for today. In total, I mean, it was dry. Mm-hmm. It was sometimes painfully dry, but in total, who do you think she helped the most?
I think overall she was a defense witness. I mean, there is no physical evidence, DNA, blood, anything whatsoever, fingerprint tying this defendant to the crime scene.
Yeah, this case is such circumstantial evidence, and these are two cases where you see potential overcharging of defendants, and we'll see where both cases go. But I think juries are a whole lot smarter than we sometimes give them credit for, and it'll be interesting to see. It appears as though in the Segura case they need to set up something for the next witness, and so hopefully it's not more of the same type of testimony, but it may well be, because we hear a lot about forensics and gunshots and all of that type of sort of DNA, TV type evidence that is a lot more dry than it is when we watch it on television. Right. I want to go back to talking about Gaspar because we may see a verdict as soon as today. I think if I remember correctly, the judge does put some limit on the amount of time that they can use for closings. How do you feel about that as an attorney, a trial attorney? I know a lot of times for me, judges will say closings can't be more than 30 minutes or an hour. Do you feel that that's appropriate, or do you feel like as an attorney you should have the right to argue as long as you feel necessary?
I think it depends on the case. I mean, if they give me a reasonable amount of time, I think that that's sufficient. But if they're cutting you short and you're not able to hit every argument, I think it's problematic. Plus, there's a tendency to rush and try to speak more quickly, and then the jury's not really following everything you're saying. I mean, I think in this case, he's recognizing that the arguments are what they are and that they shouldn't drone on and on and on for hours after hours.
Especially if he cuts out that impairment count, then it could really sort of shorten up the case in total. I want to continue to talk about Sergeant Gable's field sobriety test, because that plus the statute is where the prosecutor gets the argument of impairment. And if the judge is arguing that the statute doesn't really apply, that plus this field sobriety test may not be enough to influence the jury either. So let's go to the next clip and watch a little bit more about the field sobriety test.
Sure. So the process begins with a breath test. So when a DRE becomes involved in the case, the first step in the protocol is a breath test. Second thing is an interview with the arresting officer. The third thing we do is take an initial pulse and talk with the person. Then we move into psychophysical tests. Then we move into vital signs, including blood pressure. Psychophysical tests, including the modified Romberg balance test, the walk and turn test, the one-leg stand test, where we have them stand on both their right and their left foot, and then the finger-to-nose test are all psychophysical tests that are included in the DRE protocol. Then we move into vital signs, which includes blood pressure, a second pulse, and body temperature. Then we move into observation of the eyes, which is in 3 different phases of light. So we measure pupils using a pupillometer in room light, near total darkness, and then direct light. And then also during direct light, we're looking for the pupils to pulse, basically. And then we move into injection signs, a third pulse, muscle tone, and then move into toxicology and the interview with the person, basically, at the end.
Now, is there a national agency through which drug recognition examination is recognized?
Yes.
Which agency is that?
The International Association of Chiefs of Police. That's who does the...
And in terms of drug recognition examination, were there additional tests you administered to this defendant?
Yes.
What were those physical tests that you administered to this defendant?
The modified Romberg balance test and the finger-to-nose test.
Can you explain the instructions you give for the modified Romberg balance test and the finger-to-nose test?
Sure. So modified Romberg balance is basically a test where someone is to stand still with their head tilted back and their eyes closed and estimate the passage of 30 seconds. So that's really the instructions, that you need to stand still, tilt your head back, close your eyes, and estimate the passage of 30 seconds. I tell them that I will start the time clock when I say begin or start, and they will end the time clock when they feel 30 seconds has passed. They need to bring their head forward, open their eyes, and say the word stop.
And what instructions are given for the finger to nose test?
In finger to nose, the person is to stand still and upright, hands down at their sides, make fists, and then pointer fingers out so that their hands are down at their sides. And then I'm going, sure.
For finger to nose, do you demonstrate to them what they should be doing and give them those instructions?
Not necessarily through the test. No.
So what instructions are given?
So the instructions are to just to get them to initially stand with their hands and their pointer fingers pointed down at their sides. And then I tell them that I'm going to be giving them instructions, either left or right, and then whatever side I give them, I need them to bring that finger up and to touch the tip of their nose with the very tip of their finger, and then return that hand down to their side. I explain to them that it's really important that they touch the very tip of their nose, so then I kind of show them kind of a nose, and I say, I don't want you to touch the underside of your nose, or the sides of your nose, or the bridge of your nose, but the actual tip of your nose, so the very end of your nose. And when I say tip of your finger, I mean the actual tip, where the finger meets the nail at the tip of your finger, not the pad of your finger or the sides of your finger, but the tip of your finger. So tip your finger to the tip of your nose. It's pretty important, so we spend some time going over that with them.
What's the significance of that? Why do you say it's pretty important?
Because I definitely don't want to leave any of it up to confusion.
The judge is ruling in the Gaspar case, so I'm going to take you straight there.
State versus Richardson, and I stopped there because it is a recent Supreme Court decision from December 29, 2016. I'm not aware of anything more recent. The parties haven't presented anything more recent. And paragraph 14 seems to be dispositive of the issues that the court raised. And that was the statutory interpretation of this phrase, 4506.01M, drug abuse. So in paragraph 14 in Richardson, the Supreme Court references that. They give the definition of drug abuse. Then they refer to, and quote, the section specifically means any controlled substance, dangerous drug as defined in section 4729.01 of the revised code, or over-the-counter medication that, when taken in quantities exceeding the recommended dosage, can result in impairment of judgment or reflexes. Then they go on to talk about 4729.01F, and they also cite to Revised Code section 371941 that puts hydrocodone in the Schedule 2 list. Then their comment, or their holding is, distilled for our purposes, those statutes say one thing, hydrocodone is a drug of abuse. So the fact that hydrocodone was a controlled substance and also would fit into dangerous drug, for them seemed to be dispositive of the issue of what constitutes a drug of abuse. And we're in the same situation here. Methadone is a Schedule 2 drug. It's a controlled substance. So I think I'm constrained by the Supreme Court's decision, guided and constrained. So count 5 then will be amended so that it reads, did operate any vehicle, streetcar, or trackless trolley within the state, but at the time of the operation was under the influence of a drug of abuse, to wit methadone. I think that that's what the present state of Ohio law is. So the motion for judgment of acquittal on Rule 29 on that narrow issue that we talked about is denied, and it's also denied on counts 1 and 3 then because they require an underlying finding of driving under the influence.
You respectfully note my objection, sir.
Yes, thank you. And it's an issue that they dispose of in one paragraph, and at some point they may review that section differently. I don't know, but that's how they read it most recently in the Ohio Supreme Court. Any argument upon anything, any of the other counsel, I might ask you, but anything you thought of while I've been out?
No, Your Honor.
All right, so Rule 29 then, as reviewed, is denied as to counts 1, 2, 3, 4, 5, 6, 7, 8, 9, and 10. Now the state was going to consider whether they were going to consolidate counts.
Judge, at this time, we agree with the court's prior, if you will, suggestion or observation that counts 3 and 4 are unnecessarily duplicative, and we would withdraw them or dismiss them at this time, so that the jury is not unnecessarily confused by repeat counts, if you will, the difference being the furthermore. Our primary concern, though, is that the instructions of the jury adequately apprise them, as I think it already does, and the court will instruct, that a finding of guilt on the base offense without a finding of the furthermore does not negate a conviction. It's just the element of the furthermore that needs to be established that distinguishes it from the other parallel counts. That is the state's concern, so that so long as that is made clear to the jury, we agree that they're duplicative.
Any objections to the state asking the court to dismiss counts 3 and 4?
No.
To reiterate, counts 1 and 2 contain all the allegations in counts 3 and 4, but they also contain an additional further finding that the jury would have to make a decision upon that would enhance the potential penalty. So they're the same charge, but with an enhancement. All right, so upon the motion of the state without objection, counts 3 and 4 are dismissed. So then you're going to be going forward counts 1, 2, 5, 6, 7, 8, 9, and 10. I have a revised jury charge. It has not incorporated the just decided issue on counts 3 and 4, but otherwise I ask you to look at it. Mary is going to lunch. Whatever changes you have, Diane can make. She's back from lunch. And then when we come back, 2:40, 2:45. We'll be back here at 2:45. If the jury charge is acceptable, you can argue, and then I'll charge the jury.
So we're talking about lesser included request? Or?
Well, that's the kind of thing I would have expected to have been brought up earlier. But go ahead, what's your request?
I am requesting a charge of negligence, particular assault, based on the current state of the evidence, either as a lesser included offense or an offense of an inferior degree.
Judge, I know the court recalls the old issue of whether you can get there from here, as they say, or you can't get there from here, as they say in Vermont. The issue of lesser included versus inferior, and whether the elements are dissimilar or there's an additional element. I don't believe that there is a path. I could be wrong, but I don't believe that the issue of negligence can be derived.
All right, guys, we have a little bit of a frozen thing going on here in Gaspar, but what just happened is the judge went back into chambers and read a recent, I think the prosecutor had said it was a 2016 Ohio Supreme Court case that she argued was analogous because it referred to hydrocodone. And the judge went back and looked at that case and felt as though that case was persuasive for him to actually deny the defendant's motion. Now they are talking about some of the other counts. I think we just lost the frozen portion, so I'm going to take you back there live.
Perhaps we could take a short break, Your Honor, on the law on that, or do it right now. Well, nuclear manslaughter is probably what I looked at. 47, 1 second, Your Honor. I think you're correct when I said I'm looking for vehicular manslaughter.
I'll come back, look it up further.
I got it.
Well, no. Sure. Mary can't stay here all day.
Vehicular homicide 2903-0683. So operating.
Mr. Sen, sorry, Your Honor. It's 2 o'clock. I'm sitting at her lunch. And you can talk with me about that. Mr. Thompson can talk with me informally about it. And then I can make a decision on it. And it can be put on the record later. Okay, so I'll see you back here at 2:45. Well, I'll see Mary back here at 2:45. You all aren't going anywhere right this moment. Thanks.
Thank you.
Welcome back to LawNewz Network. I'm Heather Hansen, and I know that a lot of that was difficult to follow, so I'm going to do what I can to let you know what just happened. The judge had seemed very likely to perhaps grant the defendant's motion to dismiss the charge for driving impaired because of the way that the statute reads. However, the prosecutor at the end of their argument had cited to an Ohio Supreme Court case that indicated that hydrocodone was considered a drug that fell within that statute. The judge felt that persuasive enough to decide that methadone also fell within that statute. So the long and the short of it is that impaired driving count has not been dismissed, but it remains against Mr. Gaspar. Now they're going through some of the other counts, counts 3 and 4. According to my documents, count 3 is an aggravated vehicular homicide and count 4 is an aggravated vehicular homicide, but so are 1 and 2. So I think what the prosecution was doing here was saying that he would agree to sort of combine the counts. The defense attorney is arguing about that. They decided that they were going to go to lunch. I feel like they've been taking about 12 lunches today and talk about whether or not they could agree upon how to focus these counts, focus the jury instructions so that ultimately the jury gets a concise, appropriate instruction here. So we are slowly but surely taking steps towards closings in the Gaspar case. But remember, from the defendant's position and from the lawyer's position, these arguments today were very important. If it seemed as though the judge did not like the Ohio Supreme Court decision that he ruled upon here, and he actually indicated that it was just a paragraph at the end of the decision, and if Mr. Gaspar loses on the impairment charge, we will definitely see an appeal on that particular issue. But in the meantime, the lawyers are going to sit down and try to work some of these things out to really focus the case on an impairment charge, a recklessness charge, and then obviously the fact that it was a police officer involved is an enhancement, as we've discussed on here before, and the fact that he was allegedly driving with a suspended license will also become part of the enhancement and its own misdemeanor charge. So hopefully when they come back after this next break, they will have a pretty focused sense of where they're going from here. The judge will be able to give some pretty focused jury instructions. We know that's often been an issue in the cases that we've covered here at LawNewz. and then the attorneys will be able to go ahead and give their closings. In the Segura case, we have some interesting testimony coming up after this break that they're taking. The reason for the break was to get some equipment prepared. They are going to be showing a video of an interview with the defendant, Mr. Segura. So that should be very interesting, a little less dry than what we saw in the Segura case this morning. But to go back to Gaspar, now that we know that impairment charge will stick, it's going to have to be a big focus of the defense attorney's arguments here. And I believe that a great part of that argument is going to rely upon the field sobriety test. You know, when I was sitting in this chair last week, we were patiently waiting for that field sobriety test and the witness who was going to testify to it. Now we've heard from him, and many of us are shaking our heads as to whether or not that's enough to establish impairment under the statute and factually. So I'm going to throw back to a clip of a description of the field sobriety test. We've been watching that intermittently today. When you come back, you'll have Aaron Keller sitting in the chair, and he's got quite an afternoon for you. You've got the witness interview of Segura in the Segura case, and you've got closings and potentially a verdict watch in the Gaspar case. Remember, ladies and gentlemen, you always have an option on the LawNewz.com page, upper left-hand corner. You can watch whatever trial you prefer. So if we go to the Gaspar closings and you'd prefer to be watching the Segura interview, have at it. We always want to give you options. For now, I'm going to throw you to a clip of a further description of the field sobriety test. I'll be back tomorrow, and Aaron Keller will be with you after this break.
Sure. So the process begins with a breath test. So when a DRE becomes involved in the case, the first step in the protocol is a breath test. Second thing is an interview with the arresting officer. The third thing we do is take an initial pulse and talk with the person. Then we move into psychophysical tests. Then we move into vital signs, including blood pressure. I'm sorry, psychophysical tests, including the modified Romberg balance test, the walk and turn test, the one-leg stand test, where we have them stand on both their right and their left foot, and then the finger to nose test are all psychophysical tests that are included in the DRE protocol. Then we move into vital signs, which includes blood pressure, a second pulse, and body temperature. Then we move into observation of the eyes, which is in 3 different phases of light. So we measure pupils using a pupillometer in room light, near total darkness, and then direct light. And then also during direct light, we're looking for the pupils to pulse, basically. And then we move into injection signs, a third pulse, muscle tone, and then move into toxicology and the interview with the person, basically, at the end.
Now, is there a national agency through which drug recognition examination is recognized?
Yes.
Which agency is that?
The International Association of Chiefs of Police. That's who does the...
And in terms of drug recognition examination, were there additional tests you administered to this defendant?
Yes.
What were those physical tests that you administered to this defendant?
The modified Romberg balance test and the finger to nose test.
Can you explain the instructions you give for the modified Romberg balance test and the finger to nose test?
Sure. So modified Romberg balance is basically a test where someone is to stand still with their head tilted back and their eyes closed and estimate the passage of 30 seconds. So that's really the instructions, that you need to stand still, tilt your head back, close your eyes, and estimate the passage of 30 seconds. I tell them that I will start the time clock when I say begin or start, and they will end the time clock when they feel 30 seconds has passed. They need to bring their head forward, open their eyes, and say the word stop.
And what instructions are given for the finger to nose test?
In finger to nose, the person is to stand still and upright, hands down at their sides, make fists, and then point their fingers out so that their hands are down at their sides. And then I'm going... Sure.
For finger to nose, do you demonstrate to them
what they should be doing and giving those instructions?
Not necessarily through the test. No.
So what instructions are given?
So the instructions are to just to get them to initially stand with their hands and their pointer fingers pointed down at their sides. And then I tell them that I'm going to be giving them instructions, either left or right, and then whatever side I give them, I need them to bring that finger up and to touch the tip of their nose with the very tip of their finger, and then return that hand down to their side. I explain to them that it's really important that they touch the very tip of their nose, so then I kind of show them kind of a nose, and I say, I don't want you to touch the underside of your nose, or the sides of your nose, or the bridge of your nose, but the actual tip of your nose, so the very end of your nose. And when I say tip of your finger, I mean the actual tip, where the finger meets the nail at the tip of your finger, not the pad of your finger or the sides of your finger, but the tip of your finger. So tip of your finger to the tip of your nose. It's pretty important, so we spend some time going over that with them.
What's the significance of that? Why do you say it's pretty important?
Because I definitely don't want to leave any of it up to confusion, that they actually get the tip of their finger, they follow these directions, tip of the finger to the tip of the nose, because they're pretty specific instructions. And they're not hard to follow, especially when it's specified to that degree. Tip of the finger means tip of the nose. That has to meet.
And did you administer these tests to the defendant?
I did.
I'll begin the clock by telling you to start. You'll end the clock by telling me to stop. Okay, I'm going to put my hand where it is. We're going to go back and close your eyes. Keep your hands left to the side. Keep together. We'll do it away. Go back and close your eyes. I'll say the start. I'll start the clock. You say stop. And let the leave your eyes open. You understand? Yeah. Okay. Start.
What were your observations of any of the defendant performing the modified Robert balance test?
So through this test, I'm looking for a lot of different things. Obviously, primarily looking to see how well he's estimating the passage of 30 seconds time. In this case, he was 33, nearly 34 seconds, which is not really significant. That's pretty much what's expected for somebody to be within roughly 5 seconds of 30 seconds. But what I did notice during this test, I'm also looking for sway. That's why I'm kind of walking back and forth. So I'm looking for him to sway side to side and front to back. So in standing, looking at him from this angle, I'm looking beyond him at the line, the painted line, to see if he sways back and forth in relation to the line that's beyond him. And then I walk to the side, find a vertical object beyond him, and then look for him to sway back and forth. I'm also looking for ingestion signs. So I'm looking for nose hair. I'm looking to see if, so someone that insufflates or snorts things, it burns the hair out of their nose. So a lot of times someone that prefers one side rather than another will have a lot of hair in one side of the nose and no hair in the other. So it's an indicator that someone is doing something to remove only one side of the nose hairs. I'm also looking to see if there's debris in the nose. I'm also looking for just body position and tone. And in Mr. Gaspar, again, he was very, very rigid throughout this test. His fists were balled up very tightly. His elbows were actually cocked a little bit to the back because he was standing so rigidly. He had leg and body tremors throughout this test, so as his head is back and his stomach is pushed out, I can see that his core is shaking throughout this test, and then he's just rigid throughout this test. I could also see, specifically during this test, when his head was tilted back, I could see his carotid artery, and it's just banging away very quickly. So he had what I observed to be a very rapid pulse or pulsation of blood through his carotid artery. It was very visible and very obvious to me during this test.
What was the next test that you administered?
That would be the finger-to-nose test then.
One more thing I'm going to have you do right here on the other side. Feet together. This. You put your pointer fingers down? Yeah, good. Good, go ahead and do that. Good. Fingers down so I can see them. All right. You're going to do the same thing. You're going to tilt your head back, slowly rise. I'm going to tell you left or right. I'll tell you left, I want you to bring that left hand up. I want you to touch your tip of your fingers and the tip of your nose and then immediately put it back down. All right. Now, I say tip of your nose, I mean, like if this is your nose, side, this is the bridge of your nose, this is the underside. I want you to touch the actual tip of your nose, not that underside. When I say tip the finger, I mean actual tip, where the nail meets the finger, right on the tip. I want you to grab your finger inside. Any questions about that at all? No. Okay. Go ahead, put your head back, put it right. Point your fingers down for me again. Good. Left. Good. Yes, left.
Okay, folks, I'm Aaron Keller. I'll be with you this afternoon here on the LawNewz Network. We have live testimony in the Segura case out of Florida, so let's go live to the courtroom as a police officer is testifying right now.
Canvassing the neighborhood and things like that?
Yes.
Is that what we're talking about?
Yes.
Would you also talk to friends and family?
Yes.
You previously mentioned some schooling that you've gone to, and I'd like to go on that a little bit. Have you gone into any particular kind of training as it relates to interviewing people and motives and things along those lines for homicides?
Yes, I have.
And what kind of things are you looking for to drive this investigation?
Body language, person being evasive.
Let me get to that. That's an interview. I'm not there yet. I'm talking about when you're trying to figure out and you're doing these questioning of the neighbors and friends and family, what are you looking for to get out of that in order to help identify a suspect?
A motive of who would want to do this.
Okay. During your training experience, have you been able to identify different kind of motives and what is typically a motive in a situation like this?
Yes, I have.
What would that be?
Usually it's either persons who have had relationships with the victims or involved with money as well.
Okay. You're also aware of the autopsy, and we talked about a little bit of that earlier.
Yeah.
And that's, if I recall correctly, one of the things you looked at with the autopsy is the nature of the event, nature of the injuries.
Yes.
And there was some anger involved, so you were also looking for somebody who would have been angry with Ms. Peters.
Yes, that is very true.
At some point during the course of this investigation, did you make contact with Mr. Segura?
Yes, I did.
Okay. And how was that contact initiated?
Initially, we had to make a phone call to him, and then we sent investigators to his location.
Okay. At any point, did Mr. Segura contact you?
No.
Okay. Did Mr. Segura agree to come and talk to law enforcement?
Yes.
Okay. And when he agreed to come and talk to law enforcement, was he a suspect at that point?
No, not at all.
Then why were you looking to talk to him?
To find out information about the victims.
Okay. So he's just one of many people you're talking to at that point?
Yes.
Did you go to talk? You mentioned you sent somebody out to his location. Is that where the interview was conducted, or where was it conducted at?
The interview was conducted at the Tallahassee Police Department.
Okay. And just for clarification purposes, what day are we talking about?
Saturday, November the 20th.
So we're talking about the same day the bodies are discovered?
That is correct.
During your training that you previously mentioned, are you taught about what to look for during the course of basically an interview, as far as the person you're talking to?
That would be yes.
Okay. And what kind of things are you looking for?
Pretty much body language, what the person is saying, if what the words are coming out match what you're asking them.
Okay. When you say body language, what are you talking about?
Is someone stiff? Are they self-soothing? Different reactions to questions that you shouldn't receive that type of reaction.
Are you looking for, you mentioned something about what they're telling you and how it relates to things you already know or are uncovering during the course of the homicide. Are you looking for deception?
Yes.
Now, Mr. Segura wasn't coming in for an interview per se as a suspect, but with those tools that you utilize, you still carry them with you, if I'm not mistaken.
That's yes.
As it relates to that interview, I'm showing you previously marked as state's for identification purposes, state exhibit 122. May I first? You may. Did you have an opportunity to review the recording? Oh, let me ask you this. Was that interview on November 20th recorded?
Yes, it was.
Okay. Both audio and video?
Yes.
Okay. And who was present for that interview?
Myself and investigator Phil Hines.
Okay. I assume he's also a Tallahassee police officer?
Yes, he is.
Okay. Have you had an opportunity to review that interview prior to coming to court?
Yes.
Was it an accurate recording of the interview with Mr. Segura on that day?
Yes.
Okay. Your Honor, this time I move State's Exhibit 122 into evidence, please.
Any objection? There could be admitted.
And Your Honor, this time I'd like to publish it to the jury.
All right. The appropriate time to give the instructions we agreed upon.
Yes.
Members of the jury, you're about to view a video recording. The court instructs you that the recording has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way you view and consider the evidence. These redactions have been agreed upon by the parties. These recorded conversations are proper evidence, and you may consider them just as any other evidence. You are also being furnished transcripts of the recorded conversations. The recordings are the evidence, and the transcripts are provided to you only as a guide to help you follow as you listen to the recordings. The transcripts are not evidence of what was actually said or who said it. If you notice any difference between what you hear on the recordings and what you read in the transcripts, you must rely on what you hear, not what you read. Now, I know transcripts were passed out, but I haven't heard any reference to them. Are you anticipating using transcripts with this interview?
Yes, Your Honor.
Well, they need to be identified for the record.
Okay.
Authenticated.
One moment, Your Honor. Your Honor, I believe it's for stipulation.
Well, we need to mark one for identification.
Yes,
to be part of the record. We'll make the recording itself 122A, the transcript 122B. Is there any objection to 122B?
No, Your Honor.
All right, so it will be for purposes of the presentation here. So you can pick up the transcripts that were there. You ready to proceed?
Yes, Your Honor.
You may. Give us a spare copy of the transcript.
Your Honor, Mr. Dugan, they can put it up there for you.
Okay.
Is there a way to turn on our computer to monitor communication?
You get it down the room?
It's flashing on and off.
Somebody take a minute. You can't get that, just move where you can see the screen. Let's go, Mr. Hughes.
I'm fast forwarding, Your Honor.
Doing okay?
Yes, sir.
Good. This address on Mustang Drive is still this a current address for you?
Yes, sir.
Do you live anywhere else?
I'm everywhere, actually. I live on the road mostly.
On
I'm a welder.
Okay.
I work different power plant, paper mills everywhere.
Okay.
I normally live in a motel, but that's my house right there.
Okay. What welding company do you work for?
Right now I work for a company called On Site.
Okay. Give me 1 second.
I'm laid off right now. I go back to work on 6.
Okay. Is that routinely that you get laid off and then catch a job somewhere?
Yes, sir.
Do you like work on oil rigs or something like that? You said you're a welder. So,
Paper mills and power plants.
so you pretty much travel the country.
Yes, sir.
Okay. But Tallahassee is your home base.
Yes, sir.
Since you travel on the road a lot, what are your cell phone numbers or your cell phone number, or how do I get a hold of you to follow up to this case?
850-509-4380.
Are there any other numbers?
My number.
What is that?
421-1288.
About your dad or your mom? What are their numbers? 570-8339. That's my mom. 459-3485.
3758. That's my dad.
Okay. Is it this 570-8339, is that a cell phone?
Yes, sir. Both of them, the cells.
Cell?
My dad in my house.
All right. Is there a primary home number, or is that 421 the primary number?
That's my home number, yes, sir.
Okay. And while you're on the road, is there a on-site, do they have a cell phone that they provide you, or do they have a hotel, or is there something that they provide you for contact, or mail, or a P.O. box? Or, okay. You said you work for on-site welding?
I think it's just called on-site construction, maybe. I don't know. I only work with them 3 or 4 weeks, maybe.
You have a way of another phone number off the top of your head?
No. Okay. I got it in my cell phone, but I don't even have the main guy's number. I just got the guy that's my foreman. I have his number.
Mm-hmm. Is your cell phone on you?
No, sir. It's in the truck.
Do you have
Folks, so we're sorry about that. We're trying to bring the audio back up in the Segura feed out of Tallahassee, Florida. Again, that's a case where one man is facing the death penalty for 4 separate counts of first-degree murder related to the deaths of his girlfriend and her 3 children. The children were ages 6 and 3, so we're working to bring that feed back up. We hope to have it back for you any second. Again, an interesting case because there is another prison inmate who claims that the death was actually the result of a drug hit, and the defense really wanted that other prisoner to testify, but it turns out that he has pressed a Fifth Amendment standing to not have to testify, so makes things into a mess for the defense because they think there's this other theory out there as to how the victims died, but it's going to be a real struggle for them to try to actually present that because the person who claims he was involved in the hit or claims he was involved in ordering the hit won't be able to sit on the stand and actually say that he did it because he doesn't want to be charged with a crime. So they've been wrangling about that for a couple of days and trying to get that straightened out. And some of those discussions were ongoing as of this morning. We are also waiting for live testimony to resume in the Gasper case. A couple of interesting developments in that case today because the judge apparently agreed at the prosecutor's motion to dismiss 2 of the charges off of the second indictment in that case. Those are aggravated vehicular homicide charges as a result of operating while impaired and with an enhancer for striking a peace officer, and also an aggravated vehicular homicide charge for driving recklessly and striking a peace officer. So that's a second-degree and third-degree felony off the table for the defendant in the Joshua Gasper case. Interestingly enough, though, those charges are really sort of contained in charges 1 and 2, so the more serious charges are still on the table at this point. But we have the Segura feed back out of Tallahassee, Florida. Let's listen back in.
Drew a pint. I was doing my son's hair. Then when I went back over there, she said, no, they did find him in the house. So I don't know what else she said.
Over there? Do you know Pint's real name? Do you know, how do I get a hold of her?
Well, she's the one who, she's my son's, she's braiding my son's hair. Her daughter is, I don't know, her daughter is the girl who knows Brandy, godmother. And she knows, I don't know, I guess that Brandy's mom must have went over there this morning and told them the news, so she called Pint and told her.
And you just happened to be there today? And
no, I called Pint to make an appointment to get my son's hair done.
And show up.
And she told me on the phone. But she said that my son wasn't found there. He wasn't there. But when I got there, she said he was in the house.
Okay. And Javante is your child?
Yes, sir.
Okay.
it was some paternity issues, but legally he is my son. He has my name.
Okay. Tell me about these paternity issues that you have going on.
Well, like the girl Bank was saying, she think that he was with that other guy.
Do you know the other guy's name?
Caleb, that's all I know.
Okay.
That's all I know. That's Brandy used to tell me that was that he was Javante was his son. Then she would come back and tell me that no, he's not. So, like a little mind game back and forth. So I put myself on child support. Then I went to get a paternity thing done, but they said I couldn't get one because I had to pay $400, something like that, to get a paternity test done. I just didn't have the money to do it, so they just moved everything forward without me getting a paternity test. So I just kind of wouldn't worry about it.
Okay. So are you currently paying child support, or are you on it?
I'm on child support. I haven't paid it.
You haven't paid it? No. Any reason why?
Just haven't had the money to pay.
Okay. Because you're out of a job?
No, just bills backed up. Just haven't had the money to put towards it.
Okay.
I got another kid in Orlando. I pay child support too. I haven't paid it in a while. Just backed up on it.
Okay. How many kids do you have?
2, 3, 4, 3 now. I had 5.
All right, and different women?
My 2 sons with my wife, and I had Javante with her, and I got a little girl in Orlando.
Okay. How many vehicles do you have?
2, 3. I got a 63 Impala, Monte Carlo SS, and a Chevy truck I got.
All right.
That's the only one I got registered. I ain't got the other ones on tag or nothing.
You have a 63 Impala. What color is it?
Green.
What else?
The Monte Carlo SS. It's white.
A white Monte Carlo. And what else?
That's it.
What about your wife?
She got an Expedition. A white Expedition.
Okay. What's your wife's name?
Malika.
Can you spell Malika for me?
M-A-L-I-C-A.
She have your last name, Segura?
Yes.
How long you guys been married?
10 years. Been good 13 years. Been married 10.
You said she has a white Expedition?
Yes, sir.
What color is your Monte Carlo?
White.
White, you said? It's a green Impala, and you have that green Chevy truck. So, do you know or do you not know if you're Javante's father? Like, for sure. Do you suspect not, or do you suspect, yeah, he's mine?
I'm not sure.
You're not sure? But since he has your name, he's your son?
Yes.
Tell me about Brandy. What kind of person is she?
Spunky.
Okay.
She's down to earth. She's real sweet. She's a cool person.
Mm-hmm. How'd you guys meet?
At the gas station. She was walking at the gas station. I stopped her, started talking to her. And
how long ago?
4 years ago.
You just immediately started dating one another, or did she know you were married?
Yeah.
She had no problems with that. What about your wife, Malika? Did she know about?
Yeah, eventually.
Okay, eventually. Do you mind elaborating? Tell me about all that.
I don't know, not much to say. She caught me on the phone bill one day. Seen my phone bill, seen I was calling this number a lot. That's what happened. I don't know what else to say.
So she confronts you with a phone bill and says, hey, who's this? What's this all about?
See me talking on the phone 2 or 3 o'clock in the morning for an hour, 2 hours. This number has got to be somebody important.
So did she ever make the phone call, like call the number?
Yeah. Oh yeah, they used to call each other all the time.
Oh really? Malika and Brandy?
It was like before Devontae was born.
Friends
Oh,
or no? But they were squabble.
Yeah.
Okay.
She just would tell her, stop messing with me and yada yada yada.
Okay.
Whenever I left to go to Colorado about 2 years ago, I think. No, it was about 3 years ago. It was right when Javante was 6 months when I got back. Yeah. It was somewhere around when Javante was 6 months. I think it was when I left, he was 6 months. I went to Colorado, and that's when me and Brandy stopped talking.
Why'd you guys stop talking?
She texted my wife, called her something fat, something. And I asked her why she did that, talking about because it was funny. I said, I'm tired of you being disrespectful to my wife. I said, I don't think me and you mess around.
Was it the last time you had contact with her?
Well, that's the last time, yeah, until I got back to Tallahassee.
Okay.
And I talked to her. I was at her house Wednesday.
This past Wednesday?
Yeah. What's the day?
Today's
Friday? Saturday. I think I was at her house Wednesday. Because it was right when she picked Javante up. It was around 1:30ish. I got there. And I left. She had to go pick the twins up at 2:50. So I left. It was right before that. That was Wednesday.
May I ask what you're doing here? What's going on?
Just seeing Javante.
Okay.
Staying around. Me and her don't have no relationship no more than like that. She was just seeing her.
How much do you have to pay a month in child support, if I may ask?
I get $800 or something.
To Brandy?
Mm-hmm.
Right.
The paperwork, what you call it? I guess the paperwork, everything just got granted to start child support. I think like $800 a month.
And when did the judge tell you you had to start paying?
I didn't have to go to court, they just put it in.
Right, so is it like they automatically take it out of your check, or you actually have to write a check?
I think I have to write a check.
Okay.
They don't take it out of my check.
Okay. Yeah. But you've fallen on tough times, so you can't make it.
Yes. Okay. I started working, I went to work on the 6th of December. It's a short job. But after that, my boss was telling me that we got a bunch of work. January, February, March, we did pretty booked. I feel I was to catch up on everything then. But the main thing was my mortgage, and to get it straight. That was just going to work on that.
Are you behind on your mortgage?
Yeah.
Okay. So between paying all that child support, all everybody's behind their mortgage, and and money's pretty tight with you, huh?
Yeah, it was kind of tight. Not too tight, but it's kind of tight. I'm not used to having as much as normal because the economy is so messed up. The work is nothing like it usually is.
Right.
Your wife ever confront Brandy in person?
Nah, I never met in person.
They've never seen each other?
She's seen her. Brandy's seen her. My wife, I don't think she knows what Brandy looked like. Brandy knows what she looked like.
Okay. So you described Brandy as being spunky.
Yeah.
When you were there this past couple of days ago with Javante, was there any kind of confrontations, any problems?
She was cool.
She's cool. Like, what was Brandy doing while you were playing with your son?
Taking some food up to cook for late on in the afternoon. She sat on the sofa, on that big sofa. Me and Javante was on the love seat.
Okay.
Just playing, flipping them around, just playing.
Did you try to work something out with Brandy where you didn't have to go onto child support?
No, like I said, I put myself on child support.
So she never filed the paperwork for it, you did it?
I did it myself.
Why would you do that?
So I wanted to pay child support and let her know that it's over between me and you, and you know, we ain't got to sleep together no more. I'm gonna pay child support, and that's it.
Okay. Before this past Wednesday, when was the last time you were at her house?
That was it.
How often would you visit?
How often?
And on 7 days, we get 7 days in a week. How many days out of the week would you visit?
Well, that was my first time going there in a while. I was working at Crystal River at one time. That was about a year ago. I used to go back every day because her brother was staying with her. I think his name's Spud.
Her brother, Brandy's brother, was staying with her?
Yeah, he was. I don't think he's staying with her now.
Okay.
But it was when he was staying with her. I used to go over there all the time.
How long ago was that?
Like I said, it might have been a year ago.
Okay.
Probably about a year ago.
So, between today and let's go back a year from today, today's November the 19th, how often would you visit on a weekly basis?
Not often.
Not often at all? Count your fingers, 10 fingers, or more than 10 fingers, or less than?
I guess maybe 15 times. Not as much as I should have, I said. Not often.
But Brandy never said you got to pay up. You did it yourself.
Well, she used to tell me, you know, when you gonna start paying.
Okay, so she was expecting something out of you.
Yeah, she was expecting it. Like I told her, I said, you know,
okay,
hard times, I'm gonna get you straight when I start back working.
Okay.
She was understanding with it. She knows she, like I said, she's pretty cool down there.
When you were working, how may I ask how much you were paying her?
I ain't paid her nothing in the last year, for sure. Better.
Okay.
Like when Javante was younger, I used to buy him clothes and give him money like that. But then when I put myself on child support, I don't know when it was. You can probably look up and see when I put myself on child support, but I haven't paid her no child support since then.
Does your wife have a cell phone? What's her number?
It's 556-8782.
Does she know that you're here?
Yep, I called her. I told her to pick the kids up. Exactly. I'm going to talk to you guys.
Okay. Is she okay with this?
Yes.
Does she have any other means of contacting you? Is that the only phone she has?
Yes.
Where does she work at?
At Florida State University.
Doing what?
She's an accountant.
Is there a special school that she works for, or just?
Yeah, she
okay.
the mag lab.
As an accountant.
And she goes to school.
Where?
Florida State.
What she's majoring in?
Accountant.
I guess I should have known that, right?
She got a business administration degree. She's going back to get her accountant to get her more money.
Smart woman. Do you own any kind of firearms?
No, yeah. I got a 12 gauge single barrel.
Any others? What about your wife? When was the last time you spoke to Brandy?
Maybe Thursday. She sent me a text message Friday. Asking what I was doing. I didn't respond.
She sent you a text? So she sent you a text message yesterday?
Yeah.
And you did not respond? first found out about Brandy being pregnant, how was that?
It's cool.
You cool with it? Were you happy?
Yeah.
You had no issues?
I was hoping we were going to have a girl, but...
Okay.
I already had 2 boys. We was looking at a girl, but she wanted boys. She already had 2 girls.
Mm-hmm.
Yeah, I was there with her when she had the baby at the hospital. Watched them come up and everything.
Pretty special moment.
Yeah, it is.
It's amazing, isn't it? It's a miracle.
She had a C-section, so it was like, when he pulled him out, and like, I just had to sit down.
Mm-hmm. Yeah.
When my last son was born, my wife had a C-section, had an emergency C-section. He was only 1 pound 10 ounces, and that was amazing. He was that big.
Yeah. It's amazing. It's amazing child, the whole entire process. You know. Well, we're going to do everything we can to figure out what happened. Because unfortunately, Devontae is dead. And it wasn't at the hands of God. It was at the hands of a man or a woman. And that's not supposed to happen. And man doesn't have the right to take another person's life.
How was he killed?
I don't know yet. I mean, this is going to be a long, drawn-out investigation process. It's not going to go away in 2 days, 2 months, or 2 weeks. You know, until we figure everything out, and it always stays open forever until someone's arrested for it. How do you feel? How are you feeling now?
It hurt. I was nothing I could do about it.
Did you find it odd that Brandy texted you yesterday?
She used to send me all my text messages, little forwards and stuff like that.
Daily?
Not daily, but every night and then. Like she'd see me at McDonald's in the mornings. I'm on my way bringing my son to school. She'd text me, "Good morning," or something like that. "I see you at McDonald's," something like that. She used to bring Devontae to school. He goes to, what's the name of it? It's right off of Orange Avenue by Nims. I forget the name of the school. He goes to daycare right there. She's passed that way to bring him out. I stop at McDonald's every morning and I bring him Trey to school. She'll send me a text message to say good morning, so.
Were you a victim of a violent crime recently?
Yes, sir.
What happened?
I got robbed. Shot in the stomach.
You get shot in the stomach? Do you have scars and all that stuff?
Yes, sir.
Can I see? That right there is the cut?
Yes, sir.
Do you have any other injuries on you or anything like that?
Hurt my leg at work the other day. Ain't nothing major. Slowing me down now.
How'd you hurt your leg?
Jumping out the scissor lift.
Was it cut or something like that?
No, it's just swole where I hit the flange. Just got a little knot on it. No cut on it.
Do you have any other cuts or any injuries on your person whatsoever? You got a little cut right there in your finger. Can I see that?
Right here.
That's scrap.
I did this in St. Pete. I was trying to get into the latest trunk. It's a burn. It's healing up.
What's that?
I think this is a burn too. It's starting to heal up.
What about this down your pinky right here?
I'm talking about that was a burn. It's starting to heal up.
But other than that, is that injury right there, is that the reason why you couldn't pay for child support or something like that? No?
Well, it put me out of work for a while, but...
That's why I'm asking.
Yeah, no, I I was just being damn lazy, pretty much. I could have been paying something, you know. I couldn't have paid the whole thing, but I could have been paying something.
Okay. All right. But my question pretty much was, I guess because of the injury, you couldn't pay for your mortgage and all this other stuff. Is that what's going on with all that?
Yes, sir.
So where did that happen at? That wasn't here in Tallahassee.
I was in Mississippi.
In Mississippi. Did they catch the guy?
I don't know. I don't think so. I haven't heard anything from him.
Okay. Well, wow.
I stopped to ask for some directions.
And you got shot in the stomach.
Yeah, pulled me out of the truck. I was in that truck. Pulled me out of the truck. Took all my clothes off.
And shot you in the stomach.
Well, he asked for my keys for the truck. I said, I ain't getting keys for the truck. I don't know where I'm at. I'm out of town. He got all my money. It was in my pockets. With my wallet, I kept it in the center thing. So I didn't sit on it. I gave him all my money. He had my clothes. And he said, you gonna give me the keys? So I threw the keys off to the side. And when he looked at it, I jumped at him and hit him. And when I jumped at him, he ran. And he ran, I started cursing him out. Pussy, this and that, yada, yada, yada. When I catch you, this and that. He turned around and he didn't even look. He just started shooting and running. I jumped around and bumped the front bumper of my truck. I noticed I got hit.
Got caught.
The doctor said God got to be watching over me. It was a 45.
Oh my gosh.
Didn't mess anything up. He's expecting my intestines to be all tore up, so that's why he cut me from here to here. They found a bullet down here somewhere.
They said they removed the bullet?
Yes, sir.
Do you know where in Mississippi you were shot?
Yep, Long Beach.
I'm assuming you're the Long Beach Police Department in Mississippi? How does your wife feel about you having all these children? If I may ask a personal question.
Yeah, she don't like it, but I gotta tell her it's already here. The baby's here. It's not their fault. It's my fault. I slept with another woman and got her pregnant. So we can't even have them kids. So she accepts them.
She accepts them?
Yeah.
Christmas presents, all that stuff. Was she in the hospital when the children were born, all that stuff? Or no? Okay, so
she don't accept them that much.
Okay. Okay. All right. Like I said, I don't know. You said she accepts them.
She don't accept them that much.
Okay. All right, but she realizes that
right.
There are other children out there.
Like I said, I used to say I can afford to pay for them. I want to have more kids. I want some more girls. I work hard for a living. I want something to show for it. I want somebody to.
May I ask, what does a welder make?
It depends on what company you're working with. Right now, I make $24 an hour.
Okay.
And we work 12 hours a day. Well, lately we've been working 10 hours a day, but normally we'll work 12 hours a day. And everything after 8 be time and a half. And they pay you travel there and travel back. They give you per diem $100 a day. This company here, $100 a day. The last company I worked with was on $50 a day and 21 hours. So it depends on who you work with. I work with one company making 28 an hour, 100 a day.
Average yearly, what would you make?
60, 55, 60, something like that.
About this year?
This year, I don't really know that. This year, I work with AMAC. I can't remember who all I worked with. I worked with AMAC, I worked with On-Site, I worked with Zachary. 30, probably maybe about 40 grand, maybe better.
It's not a whole lot of money between mortgages, 5 kids, and all that stuff. 4 kids, that's
My wife makes
pretty tight.
decent.
Right. Tell me about Brandy's lifestyle.
I don't know. I ain't never really been in it lately. I don't know what else she was up to, what kind of people
She
she was
texts you
dealing
all
with.
the time, so...
Yeah, she'd send me forwards. Them crazy text messages. Man with a man having sex with a midget in the sink. Stuff like that.
Okay.
Like I said, I don't know what kind of people she's been dealing with lately. I really don't know. I don't know who she's been talking to. So I don't know.
When you were over there on Wednesday, did you share anything about like what's going on with her? Any problems she's having or anything like that?
She ain't offered nothing, an accident.
So she didn't really talk to you about anything?
She's asking me what else to get Devontae for Christmas, but I don't think she really said towards me.
Was she on the phone or anything while you were there?
I think she was.
Could you, I mean, not that you were listening to conversation, but could you tell if it was just normal conversation or if it was heated or friendly, anything like that?
No, she wasn't yelling and she had a raised voice.
So basically you don't know if she's had any issues with anybody recently? Would that be something that she would share with you, or who are the people that she usually hangs out with? I mean, her closest friends. Even girls that she hangs out with, you don't know who she hangs out with at all. Even when you were around her more.
When me and her was together, she had a girl named Deanna that she used to deal with. But she stayed in Atlanta somewhere. She used to talk to her on the phone. They never went nowhere together. But most, I guess, she hung out with her sisters. She got two sisters, one Teresa and what the other name? I can't think of her name right now. Monica.
Monica, Teresa.
I know Teresa. Her and Teresa used to go to the club. And they used to hang out and all that kind of stuff. I never known her to go out with any other female than Teresa.
How does her family feel about you?
I don't know, we've been pretty cool every time I'm around. I hadn't seen them in a while.
And
I was debating if I should call her mama and show her my sympathy, or I don't know if she'll cuss mad. She ain't talked to me in a while, I don't know.
So they accept you because I'm assuming because you the mutual child you got together.
Yeah, my mom lives out in Chairs. At one time, her and the twins were staying out there. And my son. I used to go out there all the time and see them. That was back when me and her was dating. When me and her stopped dating, we didn't see each other all that much. I see Devontae sporadically when I'm in town, something like that. Nothing really scheduled or nothing like that.
You said you were over there Wednesday, right?
Yes.
About what time?
About 1:30.
1:30 in the afternoon?
Yes.
For about how long?
I don't know, she had to pick the kids up 2:50. When I was leaving, the mailman was just passing. Not finna give her mail, but on the other side of the street going that way. He just passed from the house when I was driving home.
Okay.
What time that is? I know it couldn't have been 2:50. She said she had to pick them up at 2:50.
Okay, so you were maybe there in an hour then?
Probably.
Okay. So yesterday, you said you don't work, right?
Not right now.
Okay. So what do you usually do during the day?
That's my cars. I'm trying to restore a car.
Okay.
Two of them, actually.
All right. So, like, say yesterday, Friday.
Yes, sir.
Okay. Just take me through your day. You get up. What time about you get up?
7. And I gotta bring the kids to school now.
Okay. So this just yesterday, Friday. Did you take the kids to school?
Yep.
Okay. So what time would that have been?
I left home, what, 7, probably 7:30, 7:45. I got a son goes to Woodville Elementary.
Okay.
And I got another son goes to Cobb Elementary. I mean, middle school. Cobb Middle School. Okay. I dropped him off at Woodville, went to Southside McDonald's, dropped him off at Cobb, went to McDonald's on Magnolia, and went home.
Okay, so after you dropped your son off at Cobb, you went to McDonald's? Yeah. On Magnolia?
Yeah.
Okay. Then you went home? Yeah. You have any idea what time that was around? And when you went home?
9:30 maybe. It was before 10 o'clock, so I was still listening to Steve Harvey's morning show.
Okay.
It go off at 10.
All right. So you get back between 9:30 and 10, then what did you do at home?
I went outside and started taking my fenders and doors off the car.
Okay.
Trying to do an off-frame restoration.
Okay.
On my car.
So you're working on your car from 10 something to what, like in the afternoon? You have to pick your kids up too, or?
No, my wife picks one.
Okay. So when does your wife usually get home?
5:15, 20, something like that.
Okay. Were you home until then? Until she got home? Okay. All right. What about after she came home? Did you stay at the house the rest of the night, or?
Yes.
You did? Okay. And she texted you on Friday around, you remember what time that was? When you were working on your car?
It was about 1:20.
Okay.
Or 2:20. It was 7:20. I think it was 1 or 2:20.
Okay. I'll say 1:20 or 2:20. Doesn't really make a difference.
I didn't know.
We'll just say that. Okay. So you were there until your wife came home at 5:15, and then you guys didn't go out for dinner or anything? You stayed there? Okay. And you were there through the night? Okay. So this morning, Saturday, you don't have to get up to get the kids to school. You still get up that early?
Yeah.
Don't blame you. What time do you think you got up this morning?
8 o'clock probably.
Okay.
Probably did wake up 7:30, 8 o'clock. So I went to Walmart. And whatchamacallit, Procedural.
Okay. Yesterday, Friday night, you said you were home until you went to bed. About what time do you think you went to bed? You stay up late, or
I probably fell asleep around 10 or so.
Okay.
What was I watching? I was watching a movie ahead on 7 years on Sunday.
Okay.
I don't know what time it was I went to sleep, but it was on the part where you just broke out of prison camp. Last thing I remember.
Your wife did a bed about the same time, or she did a bed earlier than you, or later? Or?
I don't know what time she went to bed.
Okay. You don't know if she was asleep before or after you? Okay. Did you sleep in the bed, or are you in the family room watching TV, or
on the sofa?
Okay. Was she out there too, or was she in the bedroom?
She was in the bedroom. I know when I woke up this morning, the TV was off.
Oh, okay. So she already got to turn the TV off. Okay. So when you got up this morning, was she gone, or was she still there? Or?
She was still there.
Okay. All right, so after Walmart, Crawfordville, what did you do after that?
Went to my buddy Adam house, the guy I work with.
Okay.
And then shooting bow and arrow. Helping him run a cable for his dog. Running, what do you call it?
All right. Do you have any idea when you were at his house? Just guessing the time frame.
I left Walmart. I went out that way. When I left there, I got home. It was about 5 o'clock maybe. Whenever I did get home, I called the girl Pink to find out I get my son hair braided.
And what time of day was that?
Sorry?
What time of day was that when you called Pint?
I don't know, probably like 6, maybe 5:30, 6 o'clock whenever I got home. Whatever time it was I got home.
Does Adam live out in Crawfordville too?
Yes, sir. He stayed at, what's it called? Soft Shop, actually.
Soft Shop. All right, so you called between 5 and 6, called this, called Plank. And then, what did she say, y'all could come on over? Or?
Yeah, matter of fact, I remember I was supposed to be there at 5:30 to get this out done. So I must have got home around 4:30. So I want to give myself out. I didn't get to the house till like 5:40.
Do you normally take your son to get his hair done?
Normally my wife will do it, or I would bring him to do it, or she'll bring me to do it.
No, she does it?
Yeah, she got her nails done, so she could do it. So, bring him.
So what time did you take your son to, you said the appointment?
About 5:40.
Okay. And then you were there with him since 5:40?
Yes.
When we pulled up and talked to you, that's where you were since 5:40? Okay. Do you know what Adam's last name is?
Thornton.
Can you work with him, or?
Yes, sir.
He does the same thing you do?
Yes, sir.
Would you have a number for him on your phone, probably?
Yes,
sir. You said you helped him run cable or something like that yourself?
We ran a dog line for his dog. He just got a new dog.
Okay.
And shoot the boy out. Okay. Show me how to shoot the boy out. Throw the football around. I ate. Went on.
You have any idea, whenever you came home, or I'm sorry, whenever you had dinner or whatever with your family on Friday night with him, kids and your wife, and does she put the kids to bed? Do you both do it, or?
No, they fell asleep in the living room with me watching TV. They fell asleep before I did. I put them in the bed. Okay. And I went back to watching the movie, and then I fell asleep.
Okay. Would you have checked on your wife to see if she was asleep or not, or just said anything to her or anything? Because you don't know what she was doing in the bedroom. Okay. So is it like right after dinner she goes to the bedroom and you go in the family room, or?
We sat in the living room, talked,
Okay.
watched TV, and told me what we were going to cook for Thanksgiving and stuff like that.
Okay. But you fell asleep with the TV on, you woke up in the morning, the TV was off. Okay. And it's not on any kind of timer or anything, it goes off by itself. Okay.
She always turn it off. I always fall asleep with it on.
Okay.
So she'll turn it off, wake me up, put me in the bed.
Okay. All right.
Have you ever done any work for Adam before, or was this the first time you've ever done it? I don't know, is that work, help run dog line, or help pick up pipe, or have you ever been in his house more than once?
Okay.
To help him out do stuff?
I'm trying to think what last time I went there for, maybe 7. I don't know, it was a while ago. I hadn't been out there in a while. No, I don't normally go out there to help him fix nothing, do nothing. Last time I was there, he was showing me how to shoot the bow and arrow.
So today you just had to pick it back up again, try to learn how to do it?
Nah, he wanted me to help him do that, whatchamacallit?
Dog line.
Yeah.
When you called Pike to get your son's hair done, and that's when you found out about what happened?
Yes.
Okay. Did you call your wife or anybody and tell them? So your wife doesn't know what happened?
Well, she probably don't know. She at the house.
Okay.
Whatever news is happening, she knows.
Okay. All right. So you didn't make any calls to anybody about what happened after you heard? Okay.
Let's stop it for a minute, Mr. Deeks. Let's take a short break. I want to make sure everybody's still attentive.
Yes.
All right, I'll let you step out. I know sitting listening to this can sometimes wear on you, so let's take a quick break. Either side and anything.
Yes, sir.
All right. We'll take 10 minutes.
We have a pause in the case of Henry Segura out of Tallahassee, Florida, and we've been listening on the side to what's happening in the Joshua Gasper case out of Cleveland, Ohio. It looks like everybody stood up there, so I'm not sure if they're bringing the jury back in or exactly what they're doing in that case. All of a sudden, two pauses at once, and I could only listen to one of them at once. So I want to dip in. Well, I guess we can't because we just lost both of them. So, okay, we're waiting for the jury potentially to come back in the Gasper case because the attorneys and the judge have spent some time this afternoon arguing about exactly which charges they're going to leave for the jury to consider. Originally, that particular defendant, Joshua Gaspar, faced a total of 13 separate charges. He had 3 on the first indictment from 2016, 2 felonies and 1 misdemeanor. And then another indictment came down in 2017 with 10 more charges. Many of them felonies, the balance were misdemeanors, but barely so. So it looks like the judge has already agreed to take charges 3 and 4 off the table. That's 2 separate counts of aggravated vehicular homicide. One involved driving under the influence of methadone, that is, and striking a peace officer, and then the other was for driving recklessly and striking the peace officer. Now, that's not the whole case, though, because the top 2 charges also include those elements, and they go further to add the element in charges 1 and 2 for not having a valid license. So ultimately, it looks like the state is trying to do the all or nothing thing with these charges. They don't want the jury really getting in the nitty-gritty or possibly compromising and say, well, we don't know if we can prove the license thing or the impairment thing. We're going to make them go all or nothing on that particular set of charges. So they would have to find, at least on the second indictment, aggravated vehicular homicide as a result of operating while under the influence of the methadone, the striking the peace officer, and not having a valid license, all rolled into one. That's the top charge, and that I think is still on the table, having listened to most of this discussion this afternoon, and that's a first-degree felony. So it looks like the state really wants to keep that top charge, that first-degree felony, on the table. They still have 2 second-degree felonies and 1 third-degree felony on the table across both of the indictments. All the rest of the charges that still are on the table are misdemeanors. But while we wait for things to come back here, I want to dip to some of the motions for an acquittal that we listened to a little bit earlier today. If I can go to clip 73 while we wait to see how quickly they come back here, that would be a good place to get you caught up if you haven't heard some of those arguments already. With a case with this many charges and so many of the charges overlapping, again, originally we had 6 different aggravated vehicular homicide charges with different elements depending on impairment or reckless behavior, peace officer, not having a valid license. All of those different things were in the mix, and those are starting to get pared down based on the evidence presented and where the state and the defense really think that they can convince the jury to go in this case. So let's go to that clip now, and we'll be back whenever we have live testimony in either of the 2 cases.
Abused by folks. Given those things, Your Honor, I'm going to ask that this court grant a judgment of acquittal on count 5, and then by extensions to count 1 and 3.
Thank you. On behalf of the state?
Yes, Your Honor. In regards to that motion, Your Honor, the state will request it denied. The facts still have to be viewed in the light most favorable to the non-moving party. It seems the only thing at issue, or what defense counsel is attempting to challenge, is whether or not methadone is a drug of abuse. As defined by the courts, and as will be defined in the jury instructions, a drug of abuse means any controlled substance, any harmful toxicant, in any dangerous drug. And so the state would submit that there has been more than enough testimony regarding methadone being a controlled substance and a dangerous drug. And that was testimony given through various witnesses, Your Honor.
Let's stop, because this is a really technical argument, and I didn't bring this up to the parties lightly, all right, because I understand the situation involving the trooper is tragic, and everybody has worked very hard on behalf of their clients, all right? But this is a very technical issue, and it's one that only came up because of an offhand remark by defense counsel the other night. And when I was driving home, I thought, all right, well, they're asking for a definition in the jury charge of drug abuse. And so Saturday I spent a lot of time going over every aspect of the potential jury charge, all right? So we're dealing with count 5. And the issue is when at the time of the operation, he, being Mr. Gaspar, was under the influence of alcohol. Do we have evidence of that?
No, Your Honor.
All right, so alcohol, comma, a drug of abuse, or a combination of them. Well, I thought from the urine and from the blood there was no evidence of alcohol.
Correct.
So now we're only dealing with whether he was under the influence of a drug of abuse. And I would, for purposes of sentencing charge and all, I would have put in to it methadone. But going back to the statute, 451119A, I'm sorry, 4511.181 definitions. Subsection E says, drug of abuse has the same meaning as in section 4506.01. Do you have that pulled up?
We're pulling it up now, Your Honor.
So it's a term of art. It's a defined term, drug of abuse, and it's in quotes, has the same meaning as in 4506.01. This is why I wanted the parties to look at it yesterday.
Yes, Your Honor. And in addition to those arguments, though, Your Honor, we also believe that 4506.01 still defines drug of abuse as any controlled substance, dangerous drug, as defined in 472901, or over-the-counter medication that when taken in quantities exceeding the recommended dose can result in impaired judgment or reflexes.
I'm sorry, where are you going?
This is 4506.01M, Your Honor.
Yes, and that's exactly where I'm at, okay? Under subsection M means any controlled substance. So when you go to 3719.41, Schedule 2, and then it has under B, narcotics, opiates, 15, methadone. Do you want me to repeat?
Could you please, Your Honor?
Yes. Controlled substances under 3719.41, Schedule 2, under B, narcotics, opiates, subsection 15 is methadone. Okay?
Okay.
So then that takes me back to drug of abuse means any controlled substance. So that would include methadone. A dangerous drug is defined in section 4729.01. So we'll have to look at that. Or an over-the-counter medication. Well, this is not. This is he obtained a prescription or had a prescription. This is not like he took an over-the-counter allergy medicine or something.
Correct, Your Honor, but under 4506.01M, drug of abuse means any controlled substance. So methadone is covered under controlled substance, which you just recited from 3719.
But there's a qualification. Drug of abuse means any controlled substance, dangerous drug, or over-the-counter medication that, when taken in quantities exceeding the recommended dosage, can result in impairment of judgment or reflexes. So I guess we have to focus on how that's read. Does that qualification, where it says medication that, does that refer only to what follows, or does it refer to any controlled substance. That's what we're talking
I
about.
believe it refers only to what follows, Your Honor. And what would make me argue that is the case of Ohio v. Richardson, which is 2016, Ohio 8448. And that case is the one that's particularly controlling and on point in this because it discusses the issue of a substance that would be considered a controlled substance under hydrocodone. And that's similar to the methadone situation that we have here. In that case, the court held that the state had presented sufficient evidence to prove that that defendant had just ingested the hydrocodone. And then the court further went on in paragraph 18 to state that there was sufficient evidence to impairment based on the officer's observations on the scene. And the court ultimately in that ruling held that when the effects of a drug are sufficiently well known, as they are in hydrocodone, expert testimony leading to ingestion of the drug with indica of impairment is unnecessary, as there was lay witness testimony that connected Richardson's impairment to the hydrocodone, i.e. the testimony of an experienced, well-trained officer. On these facts, we hold that the evidence was sufficient to support Richardson's OVI conviction. The state would argue that that connects exactly to this case in the arguments in regards to drug abuse and impairment, and that those are similar to the facts of this case. You have a substance, methadone, that is labeled as a controlled substance. Controlled substance is listed as a drug of abuse in the code section that you cited. And based on that, 4506.01 subsection M definition of drug of abuse, it falls under controlled substance. There's been more than sufficient evidence or testimony that has been submitted to this court that would establish the two things that are required under Richardson. One, that the drug was in fact ingested, and actually it's three things. The drug was ingested. There's no question the defendant ingested methadone. There's been
Okay, folks, we're going to break out of that clip from earlier today in the Gasper case out of Cleveland, Ohio, because the judge is back on the bench in Tallahassee, Florida, in the case of Henry Segura. Again, that defendant facing 4 separate first-degree murder counts related to the death of his girlfriend and her 3 young children, ages 6 and 3. The 6-year-olds were twins. Let's listen in as we're expecting testimony to resume there. Well, it looks like they came back onto the bench here and are continuing to look over either exhibits or paperwork or arguments or something. So looks like the jury's about ready to come in just a second. The judge beat the jury to the courtroom by quite a bit here. So we'll hang on in the Segura case and just wait for things to pick up again. Also want to mention, for those of you watching the Gasper case out of Cleveland, Ohio, which from a legal standpoint is a drastically more complex case because of the complexity of the 13 original charges. Again, we were talking before about how the 13 original charges were dropped down to 11 now, with charges 3 and 4 off the second indictment being taken away by the judge at the prosecutor's motion. So we're waiting to see exactly how they shake out the jury arguments. The jury in that case reported at 11:30 this morning, so they've been there for about 4 hours or close to 4 hours without any, without doing anything, and it's because of the complexity of the legal arguments in the Gasper case. So again, a lot for the judge and the attorneys in the Gasper case to try to unravel in dealing with the complexity of the charges due to the various enhancers under Ohio law. Feel bad for the jury because they've in essence been relaxing on the state's dime here, not keeping very busy, but now that the judge has dropped those 2 charges, there needs to be a reworking of jury instructions and whatnot. And because it's a case that's ripe for appeal based on the definition of impairment in Ohio, certainly a lot can be said and done there, and they want to make sure that those jury instructions are very, very specific. But it looks like the Segura case is going to resume in just a second here. They're listening to the first police interrogation of the defendant. That's what we're listening to before they took this break. And in just a second, the camera's going to pan back over and get that interview underway. We will make sure you get there without anything to miss.
When we were there, when I was there with the other 2 officers, and you called your wife to have her meet with your kids, what did you tell her why you were going with us?
Oh, yeah, I did tell her.
Okay, so she knew kind of what was going on then?
Yeah, I did, yeah.
Okay.
Yeah, I think I did tell her someone killed Brandon and my kids.
Okay, so that right then is when you told her? Yeah. Okay, how did she react on the phone?
She said, "Are you serious?" I was like, "Yeah, just go pick the kids up and I'll talk to you when I get done." Until that phone call, and you talked to your wife at all today? Seen her or talked to her at all? Yeah. She was home when I got home. So,
after Axon's?
Yeah. Okay. Then she said she had to go to Marshall's to get some clothes off the railway.
Where does Adam live?
In South Georgia.
Do you know where, or street, road?
I know how to get there. I can't tell you how to get there.
Okay. So did he call you up this morning and say, "Hey, dude, can you help me run a dog line," or was it something pre-planned?
No, it was pre-planned. We was talking about it on the way home.
Yesterday, or?
No, when we come back from work the other day. We just got back from St. Pete.
Okay.
So
When did you get back from St. Pete?
Monday.
So when you said you were unemployed, you've only been unemployed for 4 days? Okay.
I went down to St. Pete. We worked 3.5 days. Before that, I was in Atlanta. 2.5 days. 3 days. Worked 3 days in Atlanta. Before that, I was home for a while.
Okay.
The job varies.
Being that you know her, at least used to know her, I guess, a lot better. If you were in our shoes, who would you say, you know what, I need to talk to this person. This person might be able to help us out.
Nobody.
Nobody.
Her mama.
Her mom.
She tell her mama everything. They real close.
and you were there a couple days ago, and she hasn't expressed that she was in any form of danger whatsoever. I have no idea why someone would kill her and her children.
Anybody in your family been sick recently that's been going around? You, your wife, your kids?
My wife.
Your wife's been sick? Is she sick now?
Yeah.
Okay. Like just like a cold?
Yeah.
Okay. Kids did get sick?
She's been sick the last couple of days. This kid's not sick. So I've been sitting on the sofa.
Okay. Gotcha. Want to step out for something? You need a drink or anything, man? Yeah. Okay. Get yourself.
Here's your wife's truck.
98.
Any kind of rims or any of that stuff on it? Just a real plain old. It's a Ford, right?
Yes.
Expedition. Any tent windows on it?
The back windows, the front windows aren't tinted.
What color's the interior?
Beige. Beige leather.
Your wife doesn't like Brandy, does she?
She didn't like her that much, no. She don't like baby mama that much either. Unless she wouldn't kill her.
Okay. I never said that. Yeah. This is a tragedy. This is a real tragedy, and the communities have a lot of questions and a lot of concern about what's going on with this case. Yeah, the pressure has been turned up.
Yeah, she stays in a pretty nice neighborhood, it seems like.
Yeah. Just can't figure out why. Why would someone want to kill children? Do you have any idea why someone would want to do that? Yeah, I understand it's one thing, you know, you're pissed off at somebody for something, you know, but children.
See a prayer for when I first heard it. I know it's going to be hard on the family. I know how it is to lose somebody like that. My mama called me today, told me one of my cousins got shot and killed last night.
Really?
In Louisiana.
So y'all heading out to Louisiana?
don't know when. He just got killed last night, I guess. We're going to find out when the funeral or whatever.
Are you going to go to Javante's funeral?
Yeah.
Or are you going to make the arrangements?
I don't know. Talk to her mom. Sure, I'll be the one paying for it.
Terrible.
Not much to it, but it's some.
Maybe a little Coca-Cola. I've never seen one that small before. How'd you get into the welding business?
My daddy.
Your daddy was, I guess your dad's welder, I guess over the road, around the road, kind of thing.
Yes, sir.
So do you like weld ships or trains or something, or?
Just in the paper mill, like the machines that produce paper, turns the wood into pulp, turns the pulp into paper. We take in. They have a shutdown every now and then. They shut all the machines in the mill down. We'll go in and open the machine up, look inside, do repairs on it, or tear the whole machine out, put a new one in, depending on how old it is.
So you're pretty good with your hands, mechanically. That's pretty good. I'm assuming those machines are not exactly easy to take apart and put together. But you've done it a couple times.
Yeah, I've been doing it since '98.
Okay. I guess the bill's paid, right? Yeah. And how old are you?
32.
Okay, so you've been doing it since like your early 20s.
18, 19. Excuse me.
So you didn't go to college or anything like that, so you knew right away this is what I wanted to do?
No, I was just doing it to make some money until I figured out what I wanted to do.
Yeah. Been doing this job a long time, and I have to say this is the worst thing I've ever worked. The worst. I've been a cop for 18 years. I've seen a lot of shit. been doing this job a long time, and I have to say this is the worst thing I've ever worked. The worst. I've been a cop for 18 years. I've seen a lot of shit. This is the worst. Been doing this job a long time, and I have to say this is the worst thing. You have its own little chapter in my head. Carry it with me the rest of my life.
You got kids?
Of course I do. That's why I can't fathom someone kill kids. Adults, I mean, I can't really fathom anyone want to kill anybody, really, to be honest with you, but kids, I mean, it's the future. So that's what we're, I mean, that's what we're here, we're trying to figure out, you know? To who, what, when, where, why about Brandy, you know, that's why you're sitting here right now, trying to give some insight. Who she was, what she was. You're one of the last people she saw. I mean, someone must really want to hate her, hurt her, to do this. Vengeance, you know. But you know, we all have.
No, I'm sorry. Can we take a break? We might get it figured out.
Let the jury step up.
Looks like they're taking yet another break in the Henry Segura case out of Tallahassee, Florida, and pending them coming back after a second break in relatively quick succession. I'm assuming that's so that they can shovel the technology around that they required in order to show the video. We'll be back there. In the meantime, I want to get you all updated on what's happening in the Gasper case in case you're curious. They are not going to give closing arguments today. The jury reported today, but the closing arguments are going to commence tomorrow morning at 9:30 in the morning. The jury has to report at 9:15 Eastern. Closings again at 9:30, and then followed by what apparently are going to be relatively lengthy jury instructions. The reason that they're going to be so convoluted is because of the reasons we've been discussing, with the myriad of 13 charges getting cut down to 11 charges, and I'm sure that there'll be some consolidating and some very careful looks at the language in the jury instructions, because there's been a lot of argument today, if you've been following that case, about whether or not the state's legal definition of impairment sticks to the facts in this particular case. And a lot of people following it on the side are saying this is not a clear-cut case of impairment. Ultimately, he passed the field sobriety test, but the officers still think he was somehow impaired. And then they said, well, it was really not passing, it's just he had a couple of indicators. And so, you know, I go back to the burden of proof in situations like that and say, okay, look, well, The burden of proof is on the state. My own opinion of this particular case is that I don't think they've met it on the impairment, and the science would seem to back up that particular definition. But the judge did not dismiss the charges which require an element of impairment. Many of those charges are going to go to the jury, but the state did turn around and say, okay, we'll agree to dismiss a couple of them. So this will hopefully all get settled out tomorrow, and I'm really interested to see how the defense does the closing arguments in this case, because it'll be an interesting one. A good decision, however, for the defendant not to testify in the Gasper case, because if he were to testify, then there's a 99.999% chance that he would be forced to go back over other criminal acts. He's got a record in Ohio and presumably in Alabama as well, where he had some other drug offenses, and he has some other issues related to the loss of his license in Alabama. So if he were on the stand, then the state would be able to cross-examine him on all of those prior acts, and that might color the jury. So a good decision for the defendant not to testify in the Gasper case. So while we're waiting here for the Segura case to pick back up, I want to go back all the way into some of the earlier testimony in the Segura case. Maybe we'll go all the way back here into clip 14 and listen to some of the medical examiner who was on the stand the other day. Again, it looks like they're taking about a 10-minute break due to technical issues. I'm getting that message just now, probably having to do with this lengthy interrogation with the defendant that they just played. So we'll go into that clip, and when we have live testimony, we'll be back any moment.
Yes, I'm Lisa Flanagan. That's Flanagan.
Where do you work?
I work here in this district, which is District 2, at the medical examiner's office.
And what do you do at the medical examiner's office?
By training, I'm a forensic pathologist, but I work as a medical examiner for this district, where I investigate deaths and that fall under the law. There are certain deaths or causes of death that we have to get involved to investigate, and so I investigate those deaths.
I guess you're called on by local law enforcement agencies, Tallahassee Police Department, Leon County Sheriff's Office to do that?
Yes, we currently cover 10 counties. So when deaths that fall under our jurisdiction, such as homicides or suicides, accidental deaths, then we take jurisdiction of the body and we complete a death investigation.
And how long have you worked in forensic pathology?
I've been working full-time as a medical examiner in Florida since 1995.
Can you tell us a little bit about your education and your training?
Yes, I received my undergraduate degree from Florida State University. I then attended the University of Florida College of Medicine, and I received my MD degree in 1990. After that, I completed a 5-year residency program in pathology, and I did that at the University of North Carolina in Chapel Hill. And that included training in anatomic pathology, clinical pathology, and I completed a 1-year fellowship position in forensic pathology, which is my specialty. I am board certified in all 3 of those areas, clinical, anatomic, and forensic pathology. And I became a medical examiner, and I worked down in Broward County in 1995. I worked there for about 5 years. I then was chief medical examiner in Palm Beach County for about 5 years, and then I moved here to Tallahassee, and I've been working full-time as a medical examiner since 2005.
And about how many autopsies have you performed?
At this point, I've performed over 4,000 autopsies.
What's the purpose of an autopsy?
An autopsy is part of the death investigation.
Looks like we have live video replaying, resuming in the Henry Segura case out of Tallahassee, Florida. Again, a defendant there facing 4 first-degree murder charges related to the deaths of his girlfriend and 3 children, ages 6, 2 6-year-old twins, and 3. They are playing more of his interrogation video, the defendant's interrogation video, after a brief break for technical issues, so let's listen back in.
Sometimes people do things they don't really mean to do, but you can't change the future. You can't go back. Can't do anything. just like I asked that question, if you could turn the clock back 24, 36 hours when you used to have to pick up my son. Can't undo that now, so now we gotta go forward. Figure out. Like I said, if I gotta look for a real evil person, you think something like that, you said, what does a real evil person look like? The really reality is, looks like you and I. We're all capable. Just a right trigger mechanism. What would do it? I don't know. We'll get to the bottom of this one. Is there anything else you could tell me you think something I need to be looking at going forwards? Look at somebody, something, maybe when you were living with her, did she have a confrontation with somebody that would want to do this?
She got in a fight with a girl out there one time. I don't even remember who it was.
Would that girl want to kill Brandy?
I doubt it.
A couple of years later, and her kids? What about her other, the twins' daddy? What do you know about him?
I don't know anything about him.
She ever talked to you about him?
He was a deadbeat, she said. He didn't do anything for him.
Does she have in my child support?
I don't know.
Does she have any other kids other than the 3?
No, sir. Yeah, she said, the twins' daddy, she said he capable, but he won't do anything.
Capable of what?
Taking care of the kids, but just won't. He don't care.
There's some truth. He said the easiest part is making the kid, the hardest part is raising them. That's the truth. To tell a lot of times, and I can say it because I am a parent. Once you have kids, it ain't about you anymore. About your kids. No insight whatsoever. Can't think of anything. Right now, not do I. I can't figure it out. I really can't. I will. No jilted lovers. Do you know anything about any of the other guys that you may be seeing? Her names?
The only person I ever knew of was the guy, Kalo.
That's right. Kalo's locked up. We verify he's locked up. So, hey, Kalo.
I don't think he would kill either. I think they dating now.
Kind of hard to date from jail now, isn't it?
I ain't know he was locked up. Yes, I knew they was dating. Or they was together or whatever.
They're locked up. prison.
Sir?
I don't think you want to order someone in prison, especially if they're dating. Nah, somebody who's out here.
I'm sure he ain't had nothing to do with it. I don't know what kind of relationship they had.
What was so spunky about her? You said she's just spunky. What was so spunky about her?
She's real, I don't know, I guess she was a go-getter. Couldn't really hold her back. She wanted to do something, she'll do it. She had good determination about it.
So,
she was a survivor, you know. She, I don't know how to explain it. She just.
what were your favorite things about her?
Sex.
Okay. Other than that, well, you had a good conversation with her. She was fun to be around. Good, loving mother.
Yeah, she was a real good mother.
You enjoyed hanging out with her.
Yeah, we got along pretty good.
But you weren't.
Only altercation we've had was whenever my wife would call and she'd pick the phone up or something like that.
I'm sure those are some trying times.
Yeah. Other than that, you know,
I'm surprised your wife didn't leave you.
it's come real close.
So what makes your wife hang on?
God.
Just faith. Faith that you will change, or faith that
I would change and start doing right.
How long have you dated your wife?
13 years. 3 years. Been married 10.
Okay, so like you weren't like high school sweethearts and all that stuff. Where'd you meet her at? Gas station?
Chick-fil-A.
Chick-fil-A. Okay. All right. And you just hit it off from there. And you have 2 children again. In between that, then you met another woman and you have a daughter in Orlando.
She's 8.
How's that relationship with that woman?
Good.
Good because you're not around?
Oh, no. We talked. I talked to her a little while ago.
Today?
Yeah. A couple hours ago. Just see how she was doing. Asked her about it. They got a parade coming up on the 4th of December. And my baby wants me to drive her through the parade. She just won this pageant.
Oh, okay, cool.
It has something to do with that pageant or whatever. She got a spot in the parade. I was calling her asking if she reserved a car and all that. Got to be a convertible car.
May I ask who the other woman is?
No, it's Tamika.
Tamika what?
Hawkins.
Can I have the phone number?
Yeah, it's in my phone.
Okay. How old is Tamika?
I'm 32. She's 34 or 5.
Why didn't you hit it off with her?
Because I was married.
Okay. So pretty much you're not faithful, but you're not leaving your wife. Do all these women know this going into it? Hey, look, I'm married. This is just fun. Where does Tamika live?
Orlando.
Do you know an address?
She's in Altamont Springs, actually.
What's your daughter's name?
Janae.
Can you spell it?
J-A-N-A-E.
Hawkins?
I guess I'm Hawkins.
And she's 8. When you leave here, would you mind giving me their phone numbers? You mind if I step out? Do you need to go to the bathroom? Drink water? Is that Coke okay? Is that Coke all right?
How long I got to be here?
You can leave whatever you want.
I'm saying, what else I need to tell you?
I'm hoping you can give me some insight and tell me what's going on. You know, help me out. Help me solve this. I'd like to catch the person who killed Brandy and your son. But I'm going to need some help with this. We have theories, but theories have to be proven. You can't just say it. They did it. I mean, you have the physical evidence, witnesses, information, all that stuff. So there's going to be a whole lot of people we're going to talk to. That's why I was asking, is there anyone we need to talk to? Some of you, just...
I wouldn't in her life. Like, I don't know. Honestly, I don't know who else she's been hanging with or talking to and all that kind of thing.
Last time you were there was on Wednesday. You were not there last night. We're not there on Thursday night. Like I said, I need to step out. You're here voluntarily. You are a free man. So
I want to help you as much as possible. I just ain't want to be here all night. I have to be.
Well, sir,
I can help as much as I can help.
Right now, I need to know everything you know. You told me everything. Like I said, you're free. Just as long as I can get
your phone numbers. So.
Yeah, get those numbers. But as long as I can get a hold of you with these other telephone numbers, I'll let you know what's going on. Like I said, I won't know how Javante died. I'll find out tomorrow. And we'll go from there. And maybe you'll help me out and put some feelers out on the street. Let me know what's going on. So I was pissed off at her. Pissed off enough to kill her. And the kids. That was wrong. It was very wrong. One thing, I got something with somebody, but kids. Well, I gotta step out over here. I'll be back. Tell me what you want to do, dude. I got a lot of work to do.
Get my phone out the truck.
Say it again?
I get my phone out the truck.
Yeah, like I said, you're a free guy. Can you wait up one sec?
Sir.
Can you give me 1 minute?
Yeah.
No injuries or anything like that on your person or any you're concerned about? Is it alright? Would you mind removing your shirt just so I can make sure you have no injuries or anything like that on your person or any to be concerned about? And like I said, you don't have to do that. How'd you get this little scratch right there? You get some scratch right here. Yeah, how'd you get all that?
I believe that's today. I done that today. Done this today too. I was digging in the bush, getting arrow out.
Scratch right here.
I got that.
You mind
scratches everywhere, man.
You mind if I just take some pictures?
No, I don't mind.
Okay.
Is this gonna be like used against me or something?
Well, like I said, we're doing an investigation. I don't know. Like I said, I was going to ask you if you would mind giving me some DNA as well. And what is it? Just a swab, Q-tip swab around your mouth?
You actually pull it out and you do it and stick it back in there.
Or I'll do it. Just make sure it gets done right. But you'll sign the evidence statement. Nothing's done here maliciously whatsoever. The ultimate thing, what we want to do is solve this crime, right? And
I want to solve.
And when we want to do everything right and pretty. You're not opposite. I think a camera.
Things like this are going to basically just a check mark off the list.
That's cool. Yeah, that's fine. What you say you want to do? Do I need to sign something?
Yeah, he's going to read that form. He's got to fill it out. He'll read it to you and have you sign it. I don't know what he wants to go get. You shoot it with those foam things or something?
Is that? Yep.
Feel like a compound bow or something? The one with like this few different strings on it.
It got like, I think you said it was 70 pounds of torque or something.
Yeah. Was he hunt or something?
Yeah.
That's the old-fashioned way, that's for sure.
I told my wife I've been trying to learn how to shoot the bow.
Yeah.
So I wanted to get her some deer meat for Thanksgiving.
That'd be good.
She said she ain't gonna eat it.
That's good stuff. Just don't tell her what it is.
So she said she ain't gonna eat it.
It's good stuff. It's lean too.
I had a couple times. Every time I had it was tough.
Oh really?
I figured they just didn't know how to cook it.
They can make it. I mean, you can have them make a sausage out of it. All kinds of stuff. It's good. I like it. I said I like it because it's kind of like turkey. It doesn't have a lot of fat on it.
Yeah, man, I stay scarred up. Everywhere. Comes with the job, I guess.
So when they got the bullet, was it like right underneath your skin, or was it deep down in you?
It was down here somewhere, he said.
Really? Huh.
Said he'd never seen nothing like it. You don't know
Didn't
how it lived.
Didn't hurt anything on the inside. That's pretty wild.
Didn't come out the back. He
How
said
far
no.
away was he when he shot at you? Was he pretty far?
He wasn't too far. He's probably about 2 or 3 of my truck's length.
Really?
The doctor said I was supposed to have a hole. The hole was about this big.
Yeah.
It closed up a lot. He said I was supposed to have a hole about that big coming out my back.
Yeah. That was the entry right there?
Mm-hmm. Wow. It didn't come out though. Just, he said he don't know if it
hit a rib or something. Just
shit down.
Huh. Yeah, ricochet off your ribs. It didn't break your rib? Huh.
My cell phone was dead. I didn't know where I was at. I ended up driving myself to the hospital. I put in my GPS.
Really?
Drove myself to the hospital, walked on in there and said, hey, I got shot. Robbed and shot. The lady was like, you got what?
Huh. Imagine they see all kinds of things in the emergency room.
be pointing a finger, this guy did, that guy did it, whatever.
We'll get this done. Get out of here.
So get this paper. I appreciate you waiting around helping me out with this. And like I said, when we catch this person, whatever, you know, he may be pointing a finger, this guy did, that guy did it, whatever, you know, as long as you're cooperating with me, you're helping me out, whatever, we can say, hey, no, that ain't the way it happened. Type of thing. You know, just bear with me a couple more minutes, all right? You're going to be dealing with me for a while until I can figure out what happened to your child. The 20th is today? I've been saying it's been the 19th all day. I don't even know what day I'm on. Today's November 20, 2010. You are Henry Segura Jr. Says I, Henry Segura Jr., having been informed of my constitutional right not to have a search made of the above-mentioned person without a search warrant, and my right to refuse to consent to such a search, be where I authorized by Investigator Mark Lewis, that's me, and Investigator Phil Hines, that's him. Officers of the Tallahassee Police Department or their designated to search the above-mentioned person and to seize any swabbing. That's what we're going to do, which they may desire. This written permission is being given to the above-named officers voluntarily and without threats or promises of any kind. How long have you had your hair done like that?
About 2 weeks, maybe 3.
Okay.
How is it usually done? You just have it redone? Huh? You just have it redone? Okay. So it's always braided.
Fill this thing out.
Not always. Normally I wear it out, like an afro. If I don't have braid.
I got you.
You know my case number off the top of your head?
Yeah. Just fill it in later.
Yeah, I'd prefer if you did. Peel down. I peeled down. You didn't like me. So I went the wrong way. Okay. This is still a Q-tip. Okay. Nothing's on it whatsoever. You've done this before, you said? All right. Well, then you understand what I'm about to do is I'm just going to run this in the inside of your mouth on your cheek. I'm not going to touch that Q-tip whatsoever.
You just have him grab it out and stick his head.
All right, how about you grab it from the piece of wood over here? Rub it around on your cheek and on your, there you go. Get both sides in your gum.
Just stick your head down in there.
And you stick it in a hole right there. Okay. And then I'm going to put it inside this evidence envelope right here. Sealing it. Here's the evidence tape right here. Initial it. want you to do is over the tape in the red part on both sides, I want you to initial input today's date as well. That way we both verify that no one's messing with that, okay? And just make sure you get it onto the envelope as well. Take some pictures if you don't mind. You stand up and get an overall view. Put your bag against the wall over there. Okay. We'll start right there. Can you hold this? You see, you got this out of...
I'm guessing this one up I dug in that bush. Get an arrow out. That bush getting more right on. And notice no scratches there. We got real red, right?
Got some right here. These are from today.
Yes, sir.
Here, shape of an L. Okay, so you had one on your bicep, or somewhere on your bicep.
Yeah.
Take that one.
Is that from today too?
I don't know.
Remember you had one inside your bicep.
I'll do the other arm.
Right there.
And you did this one in the bush.
That's okay. Just make sure you got nothing else on you. Like I said, I really do appreciate this. Not saying anything you did or anything like that, but, you know, I want to exclude you. We're good. If I need to have those pictures, if say these turn out bad, would you mind coming back and letting me take pictures?
What do you mean turn out bad? Oh,
I'm saying
don't turn out good? Yeah.
I don't know. Thank you. Actually, I need to get a proper receipt too. I want you to, so just bear with me 1 second so I get this impounded. 30 seconds. Gotta grab a proper receipt. I'll find that. I just gotta fill that proper receipt one at a time.
Look here, Lewis, at the end of that interview, I noticed you taking some photographs of the defendant. I'm sorry, Mr. Segura.
Yes.
Show me, Your Honor, if I can approach, show me to the previously marked States Composite 121, photographs A through G, please. You mind? I should take a look at those.
Yes, sir.
They're in evidence, according to my notes. Yeah, they're in evidence.
Sorry.
And are those the photographs you took of Mrs. Segura on that day?
Yes, they are.
Your Honor, Commissioner Volk.
You may.
Photograph A appears to be just an overall picture of Mr. Segura.
Yes, sir.
Photograph B appears to be just a little bit closer.
Yes.
And photograph C appears to show a scratch along his arm.
Yes.
Looks like, I assume this is in inches. Is that correct? The measurement stick the evidence?
Yes, sir.
So we're talking about almost 2 inches.
Yes.
Photograph D appears a little blurry, but is that another injury or the same one?
Appears to be a different injury.
Again, a little bit over 2 inches long.
Yes.
Photograph E. It appears almost as if this is a kind of an intersection, 2 different ones. Is that correct?
Yes.
Photograph F. Is that on the arm still? We're talking about right in the elbow joint?
It would be in the elbow joint.
And then G is the hand. Appears to be an older one.
Correct. Yes.
Now, in listening to the interview, Mr. Segura gave you a phone number that was his cellular phone of 509-4380.
Yes, that's correct.
And then I believe he also gave you a home phone number of 421-1288.
That's correct.
Okay. And to your knowledge, were there any analysis done as to the cellular phone of 509-4380?
Yes.
And do you do those analysis?
No, I do not.
Who does those?
Investigator Chris Corbett.
Okay. So he's the one that we're going to hear from regarding those records?
I presume.
That's after this. I know this. I heard the Mr. Segura mentioned something about getting phone numbers out of his phone in his truck.
Yes.
And did you go with Mr. Segura to get phone numbers from out of that phone?
Yes, I did.
Okay. And did you ask him for a phone number for Mr. Silas Thornton?
Yes, I did.
And just for reference, Mr. Thornton's the one that he apparently went down to Stop Choppy and was shooting bow and arrows with.
He met Mr. Thornton in Stop Choppy, yes.
Okay. Did Mr. Segura give you Mr. Thornton's phone number?
Yes.
Okay, was there anything unusual about the way in which he gave you the phone number?
Yes.
Could you please explain that to the jury?
While obtaining the phone number, Mr. Segura gave me a phone number and then quickly said, no, 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 that's not his number, and then gave me a second number for Mr. Thornton.
That first number that he gave you, what was that phone number?
I don't know it off the top of my head, I'm sorry.
If I were to show you something, would that help refresh your recollection?
Yes.
Without reading it, I ask you to draw your attention to the bottom of that page. Does that help refresh your recollection?
Yes.
Okay. And what is that phone number?
408-8669.
And again, please.
408-8669.
And that phone number, as I understand it, then he said, this is Mr. Thornton's phone number. Oh, wait, that's not the right number.
Yes, that's correct.
During that interview there on the 20th, did he ever tell you that that was his phone number, being Mr. Segura's phone number?
No.
At some point after this interview, I think we already talked about the group meetings you have on a regular basis. Did you become aware of an importance regarding that particular phone number?
Yes, I did.
And what was it that made you aware of that phone number?
During our group meeting, we were discussing persons who had contact with the victims, and Investigator Corbett identified a number. He said the person with this number, 408-8669, had a lot of contact with the victim on the day she died.
Okay. And again, Investigator Corbett's the one that will testify regarding that information, correct?
Yes.
Well, no further questions, Your Honor.
Well,
Not at this time, Your Honor.
any juror have a question of this witness? All right, you can step down. Call your next witness.
Your Honor, in case the state didn't mention it, we'll keep them under subpoena under the rule.
Right. You remain under subpoena, investigator?
Yes, Your Honor.
What was that name? Vance?
Vance Wiggins.
Okay. Come up here, please, sir. Would you face the clerk and be sworn, please?
Do you solemnly swear or affirm that the testimony given in this case will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Have a seat. Side of the microphone, please, sir.
Yes, sir.
Good afternoon, Mr. Wiggins. Would
Good
you
afternoon.
introduce yourself to our jury, please?
My name is Vance Wiggins. I'm the Service Center Manager for the Tallahassee Service Center under the Child Support Program for the state of Florida.
Thank you, Mr. Wiggins. Would you spell your name for our court reporter, too?
My first name is V-A-N-C-E. Last name is W-I-G-G-I-N-S.
Just a second. Just a moment, Judge. All right, sorry about that, Mr. Wiggins.
Yes.
So you said you are the Service Center Manager for Department of Revenue, basically the Child Enforcement Division.
Yes,
Child
Support Program. Yes, ma'am.
Okay. Thank you. And what are your duties there?
As Service Center Manager, I pretty much manage the entire center. I've got 54 specialists and 7 administrators. that I oversee operations for the Tallahassee area.
And how long have you been in your current position?
I have been in this position for 16 years now.
Okay. All right, so I want to talk about a few things in general first and then talk about this case specifically. How does Department of Revenue go about trying to hold a person accountable, a non-custodial parent accountable for paying child support?
Well, first what we do is we have to establish the obligation. And then once the obligation has been established, then we would then go about doing our administrative enforcement. That's things like sending out letters, suspending driver's license, professional license. There are other remedies like liens and tax offsets and so forth that we use to try and get the person that is ordered to pay support to actually pay the obligation.
And when you say obligation, like let's say it's a man that has not paid child support or needs to pay child support. When you say obligation, do you mean like establish paternity, establish that they are the father?
Yes, they would have been established as the father of the child. You can either do that through DNA testing, or if the obligor has already signed the paternity acknowledgement on the birth certificate, they would then be established as a legal father.
So in the eyes of Department of Revenue, a man who signs the birth certificate of a child is assumed the father legally?
Correct.
Okay. Once Department of Revenue has established who that non-custodial parent is, has established that obligation, how do you go about notifying that person of how much child support that they owe?
Generally, there are a couple of ways of doing that. If it's established judicially, then of course they will have been in the courtroom when the obligation is established. If it's done through our administrative support process, we actually send out several notices letting them know what the obligation would be.
Is like a final order of child support, is that a way to let them know how much is owed?
A final order indicates to me that we've done that through the administrative support process. And what it'll do is we actually will send out a proposed order prior to that, and it has all the terms as far as what the current support amount will be, what the arrears would be, and then after a certain number of days, if there's no response, then we render what's called a final order.
And if after that final order is sent, if that non-custodial parent doesn't pay, what happens next?
If the non-custodial parent, is what we call them, fails to pay, we would start our administrative enforcement process. And back at this point in time, we actually use 3 notices to first notify them that, okay, you had an obligation established, we've yet to receive any payment towards that obligation, and the last of the 3 notices would then tell them exactly what types of actions may be taken against them.
What type of actions are available after that 3rd notice if they still hadn't paid?
After the 3rd notice, like I said, we've got driver's license suspension, professional license suspension. We do property liens. We do what we call tax offset, lottery offset. We've got also business and recreational license that we can suspend also.
If someone is employed as a welder, is that a job that requires a professional license?
Yes.
And does Department of Revenue have the power to suspend a welding license if someone hasn't paid their child support?
Yes,
if a welder hasn't?
Yes.
Okay. And you said something about putting a lien on a property. What does that mean?
The lien on the property, whenever the arrears that are owed meet a certain criteria or a certain amount, one of our administrative actions that we can use is to actually, if we can find some type of personal property, that we put a lien on that personal property. So if it's ever sold, then of course we would receive the funds off of that.
And if a lien is on your property, does that keep you from like taking out a second mortgage, that type of thing on your property?
It can, because we also do report that to the credit reporting agencies, the total amount that's owed, and if the lien has been put in place, we would then, report that a lien has been put in place on the property.
I guess finally, if those things are done or those things are put into place and someone still hasn't paid, is even incarceration, is that something the Department of Revenue can do to enforce child support?
Yes, ma'am. We would then file a motion for contempt, and then in that, of course, we would request the court to either order a writ of bodily attachment and a purge at that point.
Okay. A writ of bodily attachment, does that mean basically you have to pay this amount of money, and if you don't pay, you're going to jail?
Correct.
Okay. I want to talk about this case specifically. Can you tell us how this case originated, how the defendant ended up owing child support to Brandy Peters in this case?
From the notes that we have on our system, looks like Mr. Segura had...
Your Honor?
Yes.
I have an objection to reapproach. Go.
Permission to approach the witness?
You may.
Mr. Wiggins, I've just shown you a few documents that are pre-marked as states 120A through, I believe it's E is the last document there. I'll double check for the court. But I wanted to ask you about those. Are those types of documents the type that are normally kept in the regular course of business at Department of Revenue?
Yes, it is.
And is it Department of Revenue's practice to keep track of records like that to show what's been sent and received as part of a child support enforcement case?
Yes.
Are your records maintained through a computer system there at Department of Revenue?
Yes, they are.
Do you have access to that system?
Yes.
And in your job as the service system manager, are you familiar with how to read those records?
Yes, I am.
Okay, at this time I would move states 120A through. A through G into evidence.
Is there objection? No. To be admitted?
All right, so I want to talk a little bit about how this case originated. The first document that you have there in your hand, what is that?
Looks to be a letter from Mr. Segura.
Okay. May I approach again?
Yes.
So the case against or for child support for the child Javante Segura Did it begin because Mr. Segura contacted the Department of Revenue because he wanted his paternity tested in this case?
Yes.
All right. I'm now showing you what's been moved into evidence as 120A. All right. Can you read that, Mr. Wiggins?
Yes.
Okay. What date is on there?
July 22nd, 2010.
Okay. Could you read this letter for us?
To whom it may concern, in reference to case number 2009 DR 3502, I am petitioning the court to order a paternity test concerning the minor child Javante Segura, born on or around July 28, 2007. Newly discovered evidence relating to the paternity of said child has come to my attention since signing the birth certificate for the minor child Javante Segura. This evidence was presented to me in the form of a recorded voicemail left by the minor child's mother, Brandy Peters, on my home phone. In the message, she stated that I was stupid for signing a birth certificate for a child that was not even mine. She also stated that at the same time she and I were engaged in sexual relationship, she was engaged in a sexual relationship with someone else that she claims is the father. It is for these reasons that I am asking the court to order a test for paternity and stay any order of child support until the results of the paternity test are known. I will make the voicemail recording available to the court upon request. I ask the court to consider and approve my petition as expeditiously as possible. Thank you, Henry Segura.
And you said this was from July 22nd of 2010?
That's correct.
So once this case began, and Mr. Segura obviously is requesting that a paternity test be done in this case, did Department of Revenue try to establish an obligation, as you told us that y'all do earlier? Did you try to do that in this case?
We did not do any type of paternity testing because the paternity acknowledgement had been signed. And as far as the program would be concerned, that established him as the legal father.
Okay, and that means the birth certificate, right?
That's correct.
Okay, so because he signed the birth certificate, Department of Revenue then doesn't paternity test everyone after that. He's assumed to be the father.
That's correct.
All right. Was a proposed administrative support order sent in this case?
Yes, it was.
All right. I want to show you the first page of that document. It's been marked and entered into evidence as 120B. Can you read at the top for us who it says that this document was sent to?
Henry J. Segura, Jr.
And it has an address of Mustang Drive there?
Yes, it does.
All right. Looking over this case number, is this the Department of Revenue case number ending in 7661?
Yes, it is.
And above that, that's the court case number?
That's correct.
All right. So this proposed administrative order, how much does it say the current amount of child support is, or how much does it say y'all are proposing that it would be?
In this case, the current child support amount would have been $744.47 per month.
And that's right here under A?
Yes, it is.
All right. And what about the retroactive amount?
The retroactive amount under item B at the time was $19,356.22.
And when we say retroactive, what do we mean? Why does he owe retroactive support?
Retroactive support in an administrative case, basically what that is when the case starts, that establishes the time as to when the support payment would have been due up until 2 years prior.
And does it also say if he ever gets health care coverage, he has to provide health care coverage for the child too?
Yes, it does.
And it says that all payments must be made to the State of Florida Disbursement Unit.
Yes, it does.
Does it say the name of the child and his birth date?
Yes, it's Javante Segura, birth date July 26, 2007.
All right, and then it has the other parent's name as being Brandy Peters.
Yes.
Does it also name Brandy Peters the custodial parent here at the bottom?
Yes, it does.
And what day was this proposed administrative order sent to both parties being Ms. Peters and the defendant?
It was mailed to both parties on August 17th, 2010.
Okay. All right, so the next step was a final administrative support order sent in this case.
Yes, it was.
And what date was that document sent?
That document was sent on September 14th, 2010.
I actually, before we get into the final order, I want to show you what's already been entered into evidence as State's Exhibit 39B, miscellaneous paperwork from the Master Bedroom Entertainment Center. What do we have here?
That is a copy of the proposed administrative support order.
Okay. And did you have an opportunity to look at this before you testified today?
Yes.
Okay. Does this appear to be the same document that Department of Revenue that we just saw in Department of Revenue sent out to each party in this case?
That is correct.
All right, and it has Javante Segura, the same amount per month, all the same information?
Yes.
And this reflects August 16th, 2010?
That is correct.
Okay, and what do we have here?
Those are where the child support guidelines were calculated using the income and expenses for the child for both parties.
And it indicates this case is Brandy D. Peters versus Henry J. Segura Jr.?
Yes.
And this is showing how the amount of $744.47 was calculated?
Yes, it is.
And are there more calculations showing both parties' gross monthly incomes, their different compensation and benefits?
That's correct.
This appears to have been mailed to Ms. Peters.
Yes, it was.
And what do we have here?
That is the financial affidavit that we request of both parties. This particular one is Mr. Segura's financial affidavit that he turned in to us.
Okay. And where it says your full name, it's signed Henry J. Segura Jr.?
Yes.
And the other parent is Brandy Peters?
Yes.
What's written above non-custodial parent that's checked off here?
Written alleged.
And here does it say that he's employed at Wright Welding at a rate of $7.25 per hour?
Yes, it does.
All right. Here showing some liabilities he has per month, and then a payment to Adetto to Farmers Furniture.
Yes.
And can you read the statement on the back?
It states, I have strong evidence to support that this child is not mine. I have been told on a number of occasions that this child is not mine by his mother, as well as recorded voicemail message from the mother stating this: I am disputing the paternity of said child. No order of support should be issued until the issue of definitive paternity is addressed. I am
it's okay if you make it out of something.
I am something,
My due process?
yeah, my due process.
Welcome back to the LawNewz Network, everybody. I'm Aaron Keller here for the afternoon. For some reason, we've seen some random building pop up on the stream, and we're not exactly sure why. So we'll try to work on getting us back to the Segura case out of Florida. In the meantime, I'm here with Dan Shore, who's been patiently waiting for us to come back. And an interesting case, and we're going back over child support information now. What do you make of where they're going with this? Because I'm not quite seeing the connection yet, other than that he owed a lot of money related to the care of this child who became a victim, and that apparently he didn't pay it.
Right, and that's a big part of the motive here for the defendant to allegedly commit these murders, that he owed child support, that he didn't want to pay the child support, that he was contesting it, and the prosecution's going to argue that's why he committed murder. The defense has already said in pretrial arguments, and I believe in opening statements, that that's not a motive to kill just because he owed some child support. So that's going to be the tension here. This is a really complicated case, as I'm sure we'll get into. There are a lot of competing allegations about what happened here, but the prosecution is trying to establish the defendant owed a lot of child support, he didn't want to pay that child support, and therefore they're going to say he committed murder.
Well, I think we've got the feedback up, so let's listen back in live to the Segura courtroom in Florida. This judge has a knack for running a little late, so we'll see how long things go today.
Ordered you set on August 14th of 2010?
Yes.
You checked that date. Seemed like I'd heard a different date at one point.
I'm sorry. Is the date that it's necessarily in your system the date that it was filed?
Not the date that it's sent to the parties. That's the date they actually signed. The actual order was August 14th. It was mailed to the parties on September 14th.
Thank you. 120D. What is this?
That is a notice of IRS certification for intercept a federal tax refund that's sent to the custodial parent.
What does that mean?
That just lets the custodial parent know that we have notified the Department of Treasury that any refund that Mr. Segura is to receive should be sent to us.
Okay. And is Mr. Segura notified that any tax refund that he gets is going to be taken from him?
Yes, he's notified by the Department of Treasury. They actually send a letter out to him.
Okay, but simultaneous with that, y'all send a letter to Ms. Peters saying if he gets a tax refund, you'll get it.
That's correct.
I'm sorry. Can you tell me the date that this notice is from?
September 19th, 2010.
What was that exhibit number again, please?
That was 120D.
D.
As in dog.
Okay.
All right. Now in 120E, what do we have in 120E?
That is the first notice of non-payment.
And what does that mean?
That's the notice that we send out when the payment that was due is not received by the due date.
Okay, so if the respondent has not sent any money in after that final order, the date that they're supposed to, they get one of these.
That's correct.
Okay, and can you tell me at the top, this was sent to Mr. Segura again at his Mustang Drive address?
Yes, it was.
And on what date was this sent?
October 3rd, 2010.
And could you read this notice to us?
The Florida Department of Revenue Child Support Program Support Enforcement Program records indicate that as of 10/3/2010, there is a past due amount owed on your child support case number 1320907-661. To resolve this past due amount, please pay $818.92 by 10/18/2010 or contact our office to establish a written agreement for repayment. If you've already made payment to satisfy the past due amount, thank you. And it says make payments available to and mail payments to the State of Florida Disbursement Unit, P.O. Box 8500, Tallahassee, Florida, 32314-8500.
Thank you. And so it basically gives him the place to send it and all the information he needs to make that payment.
That's correct.
And was any payment made by Mr. Segura after he received that proposed order or that final order?
No.
What about after he received this notice of non-payment?
No.
So what is the next thing Department of Revenue did after he didn't send any payment in after that notice?
He would receive a second notice.
In his 120F, that second notice of non-payment.
Yes, it is.
And again, it's sent to Mr. Segura at his Mustang Drive address?
Yes.
And what date was this second notice sent on?
On October 20th, 2010.
And do you mind reading this one to us?
The Florida Department of Revenue Child Support Enforcement Program's records indicate that as of 10/20/2010, there is a past due amount owed on your child support case, court case number 093502DR. You have not responded to our previous notice. We are concerned because in addition to other adverse actions that may have already been taken or in process, the following significant action may have already occurred because you have not paid your child support. A lien recorded by the clerk of court in which may prevent you from selling or mortgaging real estate that you own.
And is the box, I guess, X'd out next to that?
That's correct.
Does that indicate that that may have happened?
That's correct.
Okay, and what's next?
Florida law also allows the department to recover money owed for child support using a variety of means. The department may request a negative credit rating because of your past due child support account. This seriously limits your ability to obtain credit in the future, such as credit cards, automobile bank loans, or a mortgage, etc.
And is the box marked next to that indicating that that may have happened as well?
That's correct.
And then what's next?
Suspension of your driver's license number S20390782580.
And is that one marked indicating that that may have happened too?
That's correct.
And then the last one, suspension of your license. What license does that mean?
That would be a professional, recreational, or there's a, oh man, I can't think of which one it is.
Well, let me ask you, for a professional license, if your professional license is suspended, does that mean you can no longer work in your trade?
Correct.
And if a recreational license, let's say a hunting license, that means you can't go hunting anymore?
That's correct.
Okay. And then again, at the bottom, it tells him how to make his payments, what information to put, that kind of thing?
That's correct.
All right. Did y'all receive any money from the defendant after you sent out the second notice of non-payment?
No.
And what was the next step?
We would then send a final notice of non-payment.
I want to show you what's been moved into evidence as 120G. Is this the final notice of non-payment?
Yes, it is.
Okay, and it's sent to the defendant at his Mustang Drive address?
Yes.
And what date was this one sent?
On November 3rd, 2010.
Can you read this one to us?
As of the date of this correspondence, you have failed to pay the past due amount of $1,637.84. The Florida Department of Revenue Child Support Enforcement Program is offering you one last opportunity to clear the account or to establish a written agreement for repayment. If you fail to pay the past due amount or enter into a written agreement for repayment within the next 14 days, the department will have no alternative but to aggressively pursue administrative and/or judicial enforcement actions to collect the past due amount. An immediate response is required. Make payments payable to and mail payments to.
Okay. And the judicial enforcement actions that this talks about, is that like the incarceration that you spoke about earlier?
Yes, that would be a referral for contempt.
And it has immediate responses required in large, bold lettering?
Yes.
Okay, thank you. I think we're finished with the projector, Judge.
Okay.
So by mid-November of 2010, how much total money did the defendant owe to Brandy Peters? And if you need to see any of these documents, please let me know.
Yeah, I'll need to see the...
Okay.
Okay, by mid-November, the total was $20,100.69.
And that was the retroactive amount, correct?
That's correct.
Okay. And that was in addition to his, or he also had a monthly payment amount that took that into consideration too.
And that would have, we actually keep those separate on our system.
Okay.
We keep the retroactive amount separate. What we then would have is a past due amount, which is the $1,637.84.
Okay, and that was from the final notice.
That's correct.
What was that figure again?
$1,637.84.
Did the Department of Revenue receive any money from the defendant after sending that final notice out?
No.
As a person's income increases over time, does the amount of child support they would owe, would that increase as well?
The amount of delinquency would accrue.
Okay. And from what you've told us, after that final notice is sent, at this point come the liens, the suspension of the licenses, the judicial enforcement, the possible incarceration.
That's correct.
Okay. I have a couple of questions for you regarding, how the defendant might get out of owing this child support or not be held accountable to owe this child support. What if he came in and said, look, I got a DNA test done on my own, this actually isn't my child. Would he still have to pay that $20,100 or $20,100?
Yes, he would have to pay it until a court had ordered that he not be obligated to pay it. Sometimes when they do this establishment, they still require that the defendant pay the arrears amount.
And that's because that's what he retroactively owed since he signed that birth certificate.
That's correct.
Okay. And he was waiting until years later to get any type of test done, basically.
That's correct.
All right. And what if the custodial parent, what if the custodial parent, what if Brandy Peters said, never mind, I don't want any money? Would he still have to pay that retroactive amount?
In this case, he would have, because she was receiving assistance from the state. She had assigned her rights to the state, so we would still be pursuing the child support.
And what about if the child, what if Javante Segura, what if something happened to him? If Javante Segura died, would the defendant still have to pay that amount?
No, he would not.
That's all I have. Thank you.
Yes.
Cross.
No cross at this time, Your Honor. We'd keep him subject to recall.
Does the juror have a question of this witness? All right, write your question down, please. We'll go sidebar.
You're watching and listening to the LawNewz Network. Aaron Keller still along with you here as testimony runs a little bit late. It looks like the jury's got a few questions for this particular witness. We're listening to Vance Wiggins, who works for the state of Florida's child support program through the Department of Revenue. Bottom line is that in the end of the year, 2010, the defendant owed Brandy Peters, the victim in this case, $20,100.69 worth of child support. They said that in theory he could get out of it, but he would still be on the hook for past amounts owed because he had signed the child's birth certificate. The state is trying to use that child support amount as motive for first-degree murder charges here. So as the state's theory goes, because the defendant owed $20,100.69, the defendant killed the mother of his child, Brandy Peters, his child, Javante Segura, and he killed Brandy Peters' two twin daughters with someone else. The children, the twins, were age 6. His child, Javante Segura, with the other victim, Brandy Peters, was 3 years old. So this is really critical information on the state's theory, and we heard this particular witness on the stand right now say that he would only get out of the child support payments in the future if he, for instance, was able to prove through a DNA test and a subsequent court order that he was not Javante Segura's father. But because he had signed the birth certificate, he would be on the hook for the payment amount. He would just be able to use the court order and the DNA test, as I understood this, to get out of future payments. Also, interestingly, here, Brandy Peters was on state support herself. She assigned rights to the state to enforce judgments against him for her benefit. The jury questions are starting, though, so let's listen in.
Does the witness have the documents in front of him? Do you have the documents
Yes, sir.
there? Okay.
Yes, sir.
Question from the jury. I guess the first thing that was shown to us was a letter from Mr. Segura. Is that the first thing in your file?
Yes, sir.
And that was dated when?
July 22nd, 2010.
And had Department of Revenue sent out any notices to Mr. Segura prior to that time relating to this particular child?
Yes, we had.
And when was that?
And that would have been, looks like on June 26, 2008.
Okay. And what was the nature of that letter?
That particular letter, we actually had provided Mr. Segura what we call a non-assistance package. And in that package, you've got your financial information and an application for services.
Was there anything actively occurring by Department of Revenue between June 2008 and when this letter came in July of 2010?
During that time, we were making contact with Ms. Peters because she, like I said, was receiving assistance from the state, and we were establishing the case at that point.
Okay. So it was essentially in the process of being made?
That's correct.
Okay. Does the June 2008 letter, does it ask for support?
No, it does not.
Okay. So up until the time he contacted Department of Revenue, had he been asked by the Department of Revenue to pay child support?
No, sir.
Okay. I know you've done this, but would you explain how you arrived at the arrearage figure again, please?
In this particular case, the arrears were based on it was based on the retroactive support amount that would have been done or due between 7/1/2008 up until the present time that this administrative order was being calculated, which was on August of 2010.
All right. So basically you use that same monthly amount, roughly $750, and counted back 2 years?
That's correct.
Okay. Any follow-up, Ms. Dugan?
I want to make sure I understand you correctly. So before the defendant requested that the paternity be tested, Brandy Peters had applied for government benefits, which initiated a case on Department of Revenue's end.
That's correct.
And it was after that point that Mr. Segura said, no, make sure I'm the father of this child.
That's correct.
Okay, that's all.
Mr. Prince? No, Your Honor. All right, you can step down.
Sorry, Judge. I do want to, recall this witness because I have one question I didn't ask him.
Go ahead.
Thank you. I guess I can just ask from here. Did Ms. Peters call the Department of Revenue, for a status check the week before November 19th, 2010?
Yes, Ms. Peters made contact with our customer contact center on November 17th, 2010.
That's all. Thank you.
Mr. Prince?
No questions, Your Honor.
All right. You said you wanted to keep him under subpoena. Is that what I understood?
Yes, sir.
All right. You're free to go, but you'll be on call. Thank
Yes.
you. All right. Would this be a good place to break for the evening?
Yes, Your Honor.
All right. A couple of things. The jury, I think parking has been discussed with you. I think we have something worked out on parking. There'll be a window in which court administration people let you in downstairs. You won't be able to get there except when somebody's there to meet you. So I don't know what time they said they were going to start. 8 o'clock. So between 8 and 8:30, they'll let you in. Does everybody understand how that's working? I haven't been involved in the details, but anyway. Don't discuss the case with anyone. Don't watch or read any media accounts. 8:30 tomorrow morning. We'll see you then. I'm sorry, I should have had her pass them down. Would you collect those transcripts when they're out, please, Stephanie? And as the clerk received a copy of the transcript marked for identification, the clerk needs a copy of the transcript marked for identification, and also needs a copy of the DNA sort of summary that needs to be marked for identification.
Yes, sir.
We got those items. And did you get the exhibits back from the Department of Revenue? All right.
Your Honor, we do have two other issues we need to.
Well, let's take care of my issues first, all right?
122B is being presented to the court, to the clerk right now. I have to have I'm going to get the DNA stuff printed in color. I can only get it in black or white at my desk. I'll provide that to him first thing in the morning.
Okay, Madam Clerk, if they don't do that, remind them, please. All right. Okay. What other issue?
Your Honor, Mr. Campbell received an email today as it relates to one of the jurors. We provided, I believe, to the defense counsel. I think we all agree it's really not an issue because it's an issue that she brought up during jury selection. She was selected anyway, but we want to make sure that the court aware that we actually received that.
So you just want to make this part of the file?
Yes, sir.
All right.
And the final issue, Your Honor, as it relates to juror Amores, which is the last one on the row here. I believe that I was out, well, I know I was out at Academy Sporting Goods over the weekend. On Sunday specifically, I saw her shopping. I didn't make eye contact. I moved on. I don't know whether she saw me or not. I immediately exited there and quite frankly made sure I would not run into anybody else during the course, but I just want to make everybody aware that I did see her, and I don't believe she saw me, but I just want to make her aware.
Yeah. All right. Anything else?
Nothing else.
Did you get me the documents? You going to get me, Mr. Prince?
We'll have them for you first thing in the morning, Your Honor.
Okay. All right. State probably ought to hang on to these transcripts just in case they're needed later. If nothing else, we'll see y'all tomorrow at 8:30.
Thank you, Your Honor.
All right, that ends the day in the Henry Segura case out of Tallahassee, Florida. A couple of interesting things. Apparently, the prosecution got a letter from one of the jurors, but they didn't go into any detail in open court about what it said, and the state sort of blew it off. I was just chatting with Kathy Russin, our senior trial producer, to see if she caught any more of that discussion. Now I'm curious, but if the state says it's nothing, I guess we won't hear anything else right now. Jury is expected back in session at 8:30 in the morning in the Segura case in Florida. Important afternoon, important close to the day, because the state was able to get the information out of the Department of Revenue that the defendant owed more than $20,100 in child support payments related to the care of Javante Segura, the 3-year-old who was one of the victims. The state is using that evidence to indicate that there was motive for the murder, not only of Javante, but presumably of the other 3 victims, including Javante's mother. So that's critical for the state to prove its case. We are also expecting closing arguments tomorrow at 9:30 in the morning Eastern Time in the Joshua Gaspar case out of Cleveland, Ohio. That'll be an interesting case with 11 of the original 13 charges still on the table for the jury to consider. So we are planning to start the day tomorrow with closing arguments in Gaspar, but we will continue to monitor Segura for those of you who want to keep an eye on both trials. A reminder that we here at the LawNewz Network are on the air from 9 a.m. until at least 5 p.m. But on days like this, when we're covering the Segura trial, we start early because they start at 8:30 in the morning, and we stay late on evenings like this when testimony runs late. For now, this is Aaron Keller at the LawNewz Network. Have a good evening, and we'll see you tomorrow morning.